Check, check, 1, 2. Good morning. Today is April 13th of 2023, and the current time is 8:33 a.m. This proceeding is being held in room 310 of the Governor Office Building, and there is some participation via WebEx. This is day 2 of the Ameren rate case hearing. This case is captioned as in the matter of Union Electric Company doing business as Ameren, Missouri's tariffs to adjust its revenues for electric service, and that is file number ER-2022-0337. My name is John Clark. I'm the regulatory law judge presiding over this proceeding today. I'm going to ask counsel to enter their appearance for the record, starting with Ameren, Missouri.
Good morning, Jermaine Grubbs and Jennifer Moore on behalf of Ameren, Missouri.
Thank you. On behalf of the commission staff.
Yes, Judge. Jeff Keevel and Paul Graham on behalf of the staff of the Public Service Commission.
Thank you. On behalf of public counsel.
Nathan Williams appearing on behalf of the Office of the Public Counsel and the public in general.
On behalf of Consumers Council of Missouri. They do not appear to be here yet. We will take their entry of appearance when they trickle in. MIEC also does not appear to be here yet. We will take their entry of appearance when they get here. Midwest Energy Consumers Group.
Tim Opitz for MECG.
Thank you, Mr. Opitz. On behalf of Renew Missouri, Mr. Linares had previously told me that he had an obligation in St. Louis. I had given him the WebEx info for this proceeding. He had emailed just a few minutes ago indicating he was having some difficulty getting on, but also indicated he had only one exhibit to enter and no questions for today's witnesses. On behalf of the Sierra Club, NAACP, and Metropolitan Congregations United.
This is Ethan Thompson on behalf of Sierra Club, NAACP, and MCU.
Thank you, Mr. Thompson. Is there anybody I didn't call? Okay, when we left off yesterday, we had just finished some of the commission questions for witness Stephen Wills, and I had a few questions for Mr. Wills. So Mr. Wills, if you'll just go ahead and come up and take the stand. I'm going to go ahead and re-swear you in.
Hey, Judge, it's Commissioner Roop. I just wanted to let the court reporter acknowledge my presence.
Thank you very much, Chairman. Would you raise your right hand to be sworn, Mr. Wills? Do you solemnly swear or affirm that the testimony you're about to give at today's evidentiary hearing is the truth?
Yes, I do.
Thank you. If you'll give me just a second. While I get this up, I guess the first question that I have that's kind of stuck in my head, and you were here for the testimony of Mr. Hickman, is that correct?
Yes.
And if you'll remember, he said that if I wanted to know about rate modernization, that you were the person that I needed to ask about that. So what can you tell me about rate modernization?
Sure. So I think rate modernization is a term that maybe is used broadly and can mean different things to different people. But I guess I'll give you the company's perspective on it, and that was really developed, in preparation of the 2019 electric rate case where our time of use residential rate plans were originally approved. And in that case, we had worked with Dr. Ahmed Faruqi, who testified in that case, who's a really well-known rate design expert who's worked on time of use on other types of rates for years. And I think the way that we think about rate modernization and characterized it in that case and still think about it going forward is really two key elements in my mind. One is that, modern technology, the modern metering technology allows us to construct rates that better reflect the cost structure of the utility. I think historically rate designs were as cost reflective as kind of the monthly meter read paradigm allowed, but with interval data and more granular usage information, it allows us to better and more accurately reflect the cost structure of the utility. And then the second element that we thought was very important to the rate modernization is providing choice to customers, choice and control. And that's why we have a portfolio of residential rates for different customers to engage with a rate that kind of meets their preferences and their lifestyle, but yet is still that kind of cost-reflective rate that we're looking for that is enabled to be billed by today's metering technology.
And thank you for answering my question. I was curious as to whether it was a term of art or a buzzword or just something that
Yeah, I do think you'd get different, different answers or perspectives from different people in the industry. So, yeah, but that's how we're thinking about it.
And moving forward, how does Ameren think that that modernized rates are going to look different from today's rates?
So I think we've made a lot of the progress on the actual types of structures we need for the residential class. I think the challenge going forward will be to advance our customers' knowledge and understanding of those rates, hopefully having higher levels of adoption of some of the more sophisticated rates over time as we give customers more information and feedback. I think we still need to go through the process on the non-residential side to look at what we can do with the new meters that we've rolled out to enhance the kind of the cost reflectivity and price signals of our non-residential rates. So, and you've heard a fair amount about that in this case, about there being the potential for a workshop on those topics. So I think the biggest space right now is to really evaluate the options for those non-residential customers.
Now, you had said this morning that the granular data that you're able to get, I assume, from the AMI meters as well as other technological changes.
I think primarily the AMI meters is what I'm referring to there. Yeah.
And yesterday you indicated that granular data could get so dense that you could end up being down, looking at it to a level that was non-productive.
I think I was trying to refer more to the distribution asset data. I do think that using very granular load data is useful and has a place, and I think we are because that data now, we've got about half of our customers with it. We're starting to leverage that, and we can leverage it more as we get to complete AMI rollout. When I was talking about the density of the data, I was really talking about the kind of the distribution asset data that's also going into the class cost of service study. So the information about the physical components of the system out in the field, and how do you analyze that in a class cost of service setting?
Now, Ameren had termed staff's approach as a novel approach, and as I understand staff's approach is attempting to align customer classes more closely with the infrastructure most used by that customer class. Is that your understanding of staff's approach?
It may be the intent, but I don't think that's what's being achieved by the way it's being executed. This is what we're doing is class cost of service class cost of service study, and by looking at what staff is characterizing as customer-specific data, we believe that's not actually fairly representing the class cost, because there are customer-specific costs, for example, that are easy to identify for a really large customer, but there are very, very comparable costs to those for communities of residential or small commercial customers. And when you're able to do all this class-specific analysis of a large customer and pull out that data and directly assign it to those large customers, but then you take the remaining pool of assets and allocate them to all customers based off of the demands that are placed on the system, that includes the demands of those large customers, we think it's introducing a bias where we're getting direct assignment or close to direct assignment of a lot of what is termed customer-specific costs for large customers. But the comparable types of facilities that are dedicated to another class, that in the result of this class cost of service study ought to be borne by that class, are just getting spread across everybody. So we view the approach right now to look at this customer-specific infrastructure as introducing bias into the results of the study.
And you indicated that you think staffs had the intent to more closely align that, but they've missed the mark. Is Ameren moving forward with rate modernization? Is is aligning customers with that infrastructure. Would that be part of Ameren's rate modernization? Or do you believe that that would always introduce bias into the equation?
So I think there's maybe a misconception that the existing data that we're using for class cost of service doesn't give kind of the level of information that we need to do this rate modernization, and I think it really does. The important thing in this aligning rates with the cost structure of the utility, as I kind of talked about with rate modernization, is that costs are recovered in a charge type that reflects how those costs are incurred. And regardless of how, the industry evolves and the equipment changes, there's really been for a century, and there's no change, that there's no reason for any change of this. Three really recognized cost drivers: the connecting customers to the system, building enough capacity to meet peak demand, and producing and delivering enough energy to meet the total energy consumption. So every class cost of service study that this commission has probably seen for decades is an attempt to put things into customer-related costs, demand-related costs, and energy-related costs. And we've had for all of our rate cases enough load research data to understand the class's contributions to those demands, to understand their energy, and to understand, what infrastructure is needed to simply provide a basic connection to the system. I think where the more granular data comes in is you can maybe use that in some of the time of use to which time periods are causing those with more granularity, and I think we're doing that. The AMI data is good for saying, now that I've identified demand-related costs, or now that I've identified energy-related costs, what are the right time periods to reflect those in, and how can I bill those to customers? But that's where I see that granular data being helpful, not in trying to figure out how a transformer or a pole or a line of conductor relates to providing service to the customer. I don't think the granular hourly usage data is really instructive at all to tell how much of the pole outside of a residential neighborhood ought to be allocated to the residential customers versus someone else, for example.
Now, you indicated there were kind of three drivers of Ameren cost. Is one of those more primary than the other in setting rates?
The customer demand and energy? No, I think they're all, foundational elements of providing service to customers. And I think, are you talking about, is one of them more of the dollars? Or are you just saying is one of them more important? Because I think they're all absolutely indispensable and foundational to the ability to provide service.
Well, I actually meant the one that you answered, which is more important, but since you brought it up, which one would have the higher dollar amount?
Mr. Hickman's schedules would probably be the best way to tell it. My sense is probably demand related. But there's, very significant buckets of cost in all three of those categories.
Are you aware of any jurisdiction that is taking an approach that's more like staff's?
I'm not aware of one.
Let's shift for a little bit. Do you know if MISO treats wind and solar generation differently from coal and nuclear generation in rating the generation unit's capacity?
All generation gets specific accreditation based on its capabilities and MISO's kind of study of its performance over time. So, I don't know that they treat it differently, but the application of the methods that they use for all generation produces a different level of accreditation of the amount of capacity that, renewables get versus other resources. I should back up. There may be some differences because of, for renewables, MISO might have to do things like study geographic diversity and figure out how renewables being spread across the system impacts it, rather than just assessing kind of the performance of an individual facility, whereas for a coal or a gas facility, they're probably looking at that individual unit's historical performance. So maybe there is a little bit of a nuance to it, but in general, MISO is using common principles to assess how much capacity a resource type would get accredited with, and it's the outcome might be different. Like I said, there might be a different amount of accredited capacity for a renewable versus a conventional generator. Or I say conventional, a fossil fueled or steam generator.
Are natural gas peaking units treated differently from, are natural gas peaking units treated differently in a class cost of service study from coal and nuclear units?
I think there are different methodologies that could do that. What the average in excess, the 4 NCP average in excess that the company uses and that we've talked about quite a bit in this proceeding is that the fleet is viewed holistically as the suite of assets that are there to meet both the energy needs and the capacity needs of our customers. And it allocates a portion of that based off of those energy needs and a portion of that based off of those capacity needs. But it basically says the totality of this generation is what, through our integrated resource planning process, we've built, acquired, developed to meet those common needs. And the energy and the capacity needs are what drive the need for that entirety of that fleet. We view the fleet from a construction, from a resource planning perspective holistically. We develop it holistically to meet our customers' energy and capacity needs, and then we allocate it based off of their relative energy and capacity needs. So, but specifically on the, the combustion, the peaking combustion turbine, it's not carved out for separate treatment from a base load unit or a renewable unit or anything like that.
So all those are treated relatively the same?
Right, the whole pool is put together before it's allocated. The dollar pool is kind of pooled together before it's allocated out based off of those factors that are the cost causative factors for the entirety of the generation fleet.
And that may be what one of Ameren's other witnesses said regarding looking at the fleet as a whole?
Yes, I think that's what Mr. Hickman was talking about.
Away from the questions for just a moment, I received an email from MIEC's attorney indicating that they were having some trouble getting here today, and hopefully will be here later, but asking if we can take Mr. Brubaker out of order at the appropriate time, so I'll address that when we get there. Now, do you have, when I was talking to Mr. Hickman yesterday, I'd asked him some questions about Ms. Lang's SIR rebuttal. Do you remember that?
Maybe refresh my memory what the topic in them was.
Well, what I'm going to ask at this point is, it's specifically in regard to the stipulation agreement in ET 2018-0132.
I do recall that.
Can we get Mr. Wills a copy of Ms. Lang's SIR rebuttal to look at?
I think I recall the issue and the phrase. I mean, I guess I can have the testimony if needed, but we can probably speak to it.
Well, I can ask you the question, and you can tell me if you can answer it or whether you need to look at the testimony. On page 21 of Ms. Lang's SIR rebuttal testimony, she cites a stipulation and agreement in the ET 2018-0132 case in paragraph 8 that Ameren agreed to record customer contribution values by voltage and service classification. Is that correct?
Yes, that's correct, and we do have that information recorded, consistent with that provision.
Which gets to the second question. So, in your opinion, Ameren, Missouri has complied with paragraph 8 of the stipulation and agreement?
Yes, in my opinion, it has.
And how have they done that?
By doing just that, by collecting that information.
Has that data been shared?
I believe it was shared in a data request that was pretty recent, that has been made available.
Is there any place for the commission that you can point to that would show results indicating that Ameren has complied with that condition?
I mean, it may be possible to introduce that data request into the record or something.
We do not have a copy of it currently with us, but perhaps we could reserve it. We could reserve a exhibit and provide it later.
That would be great.
Okay. What is it, 5?
And this is another question I asked yesterday. Which party's class cost of service study in Ameren's last rate case, which is the ER-2022-0240 case, was agreed to by the parties as a starting point for non-residential rate design, for the non-residential rate design working case?
Yeah, I think the issue with that question is that the working case and the class cost of service was not stipulated in an agreement that was litigated in the case. So it was really a commission order that said we would start to have a working docket and have that initiated. And then there was also a commission order on class cost of service, which my recollection is it did say that Ameren, Missouri's class cost of service was reasonable for this case. They didn't specifically point to the working case, but I think somewhat by implication, if in the case that they were resolving, they felt Ameren, Missouri's was reasonable for it, I think that would have made sense for it to become the basis of that working case.
Okay, so you think there's good reason for it to become the basis, but you don't know if it has?
Well, the working case hasn't been opened, and there just isn't that formal direction, I don't think exists, whether it be from an agreement of the parties or an order from the commission. I just don't think it exists.
So you haven't gotten there yet, but you think Ameren's would be a good starting point?
I do.
Should the commission adopt the class cost of service study in Ameren's last general rate case that was agreed to by the parties as a starting point in this case?
I think the commission should adopt the class cost of service study that the company presented in this case. It's more current, it's relevant to the revenue requirement that was filed in this case, and more current cost levels and analysis.
With each of these, and you'll have to forgive my naivety.
Excuse me, did you say the parties agreed in the last rate case to the class cost of service? I don't think that's correct.
The parties in the last rate case did not agree to a cost of service?
To a class cost of service study,
Yes.
I don't think they did.
No, I
It
think,
was
and I think
litigated.
I'd said when, in my response that it was not a settled issue, it was a litigated issue in the last case.
Yeah, I would agree with that. Yeah.
Thank you for clarifying that for me. I appreciate it. Again, this is, I'm not necessarily the most technical person. So. Now, anytime you're doing one of these class cost of service studies for another rate case, are you starting at zero? I mean, do you design it from scratch, or do you start with the previous study that was done?
Methodologically, we use this, a similar framework. There are many, many inputs that you start from scratch to develop. There are some other inputs that you might use from case to case and restudy periodically. So, no, I think our class cost of service framework is very consistent with that class cost of service. There's new inputs that are developed with more current data for a significant amount of the input to the study.
Now, in your direct testimony, it states that customer charges are generally used to collect customer-related costs. Would you please explain what makes up customer-related costs?
Sure. Customer-related costs are costs that are going to be incurred just by virtue of connecting a customer to the system and being able to provide service to them at any level. So things that are the most obvious customer-related costs are things like a meter, right? Your customer has to have a meter and at their house to measure their usage. The costs of billing a customer are customer-related costs. You have to send a bill irrespective of how much power demand the customer places on the system or how much energy they consume. You have to have a billing system and send them a bill. But in the class cost of service framework, there's a lot of discussion about the distribution system. So if you think about poles and wires, et cetera, to have customers connected, you have to have some of that basic distribution infrastructure. Poles, you have to have wires, you have to have transformers, you have to have certain devices. So what the class cost of service study attempts to do is apportion that there's some amount of that cost that has to exist no matter how much demand is placed on the system. So our class cost of service, the company's class cost of service study, performs an analysis to apportion those costs between the level of costs you have to incur just to have enough poles and wires to connect to the customer, because you can't, just by virtue of the customer being on the system, you have to, have the infrastructure to connect them. But then the size of that infrastructure, you have to have bigger transformers, conductor capable of carrying more current, taller poles for that higher voltage, conductor, is based on demand. So there's a study that says, if all you were building is what we call a minimum system, just to build infrastructure to connect the customer, that minimum system is customer related. We have to have it. And so we do a study to apportion some of those costs to the customer function. But then we say the size of that equipment, the excess costs that are incurred because you have to build taller poles and larger transformers and heavier duty conductor, is demand related. And so those are demand related costs because they're there to meet the peak demand. So we have a detailed study that apportions costs between customer and demand related. In the NARUC rate design manual and in other manuals, you'll find a variety of different methods and approaches, but the distribution system is generally always viewed as either customer related, demand related, or some mix of the two. I will tell you, one of the significant problems that we have with staff study is that they introduce what is essentially a pure energy allocator for some of that distribution equipment, that the driver of the cost is either customer or demand related characteristics.
Can you expound on why you think that's incorrect?
Yeah, so class cost of service, we step back and say what causes, because there's a principle that customers that cause costs to be incurred should pay for those costs. So the starting point of class cost of service is this classification of costs. What caused their incurrence? Was it needed just to connect the customer? Was it needed to meet peak demands? Or is it something like fuel? You burn fuel to produce kilowatt hours. Is it based on the total energy? I'm not familiar with any rate design manual or treatise or anything like that that says the causation of the cost of the distribution system is the total kilowatt hour throughput, the total energy. So when staff allocates those costs based off of the total energy throughput, that's not the cost driver of that system, and so it's not reflecting those costs to the customers who caused the incurrence of those costs.
Thank you. Also, in your direct testimony, you state that customer-related costs from the class cost of service study to the customer charge suggests that a residential customer charge that truly reflects the customer-related cost would be approximately $25.94 per month. Is it Ameren's position that if going by the results of the class cost of service study, then $25.94 would be the customer charge for all residential customers?
I think if you strictly followed that class cost of service study, that would be. I think what we've recognized, excuse me, is that there have been many other policy considerations around the customer charge that a number of parties and the commission in the past have articulated. And so we don't recommend going to $25, but we do recommend an increase in that direction to become more cost reflective. But yes, the implication you've landed on is correct, that the cost study would suggest that that would be an appropriate customer charge for all residential customers.
Does that mean that irrespective of which rate plan is selected, the customer charge should be $25?
In that theoretical world where you absolutely strictly follow cost, yes.
Well, I guess that brings me to, if that's the case, I'm not really sure I understand why Ameren is assigning different customer charges to different time of use rates.
Sure, it comes back to those other policy considerations that I could just alluded to. Excuse me. So there's been, a lot of testimony over many cases and many years, and customer charge is always a, pretty heavily litigated topic. And parties tend to say that a high customer charge gives customers less control over their bill. There's some truth in that. What we think is appropriate is to provide customers control over their bill, but still in a way that aligns it with cost. So I think, there's a balancing of those interests of providing control over your bill, but also in a manner that doesn't end up shifting costs onto other customers. But if you look at our different rate plans, some of them are already more closely aligned with cost. Like our Ultimate Savers rate plan that has a demand charge on it, that demand charge is closer to a fixed. I mean, it's not an absolute fixed charge because variations in demand will impact the customer's bill, but demand is a more stable measurement. So there's a certain amount of fixed cost recovery that's kind of inherently assured in that demand charge. So it's already achieving some of the fixed cost recovery that could be done by a customer charge. So what we're saying is, if there is this interest in giving customers more control, let's give them more control on the rate design that gives them the most control over their bill. That rate plan, if a customer is interested in managing their usage, it gives them more control than any other rate. So what we've tried to do is balance these competing perspectives, right, of a purely cost-based rate versus the policy concerns that people have raised about, honestly, I think there's, it's a fairly thoughtful and innovative way, in my opinion, about how to balance those interests, right, is that if the concern with a higher customer charge is to give customers the opportunity to control their bill, but we have different rate plans that are kind of designed to give customers a different level of control over their bill, why don't we focus the control your bill policy customer charge on those rate plans that are designed for that purpose?
If the customer charge were to be the same across all of those residential rate plans, would time of use rates still work?
Yes.
In Ms. Lang's rebuttal, she states that Ameren used the minimum size approach as opposed to the weighted hour method used by staff for the customer charge, which staff says is more consistent with a modern grid. What's your response to that?
I do want to just clarify with you, I don't think the weighted hour method was related, unless I'm mistaken, was related to the customer charge. I think it was related to, and maybe there's something in the testimony you could point to. I think the weighted hours, what did you call it? The weighted hours method is what I was really referring to. Staff says it's a modern method, but the company views it as an energy allocator for costs that are not driven by energy. So I don't know what modern development tells staff that distribution costs are based off of, energy in every hour. I mean, the load on a mild weekend in October has absolutely no bearing on the level of distribution costs that the company incurs, and yet that load is influential in allocating the costs when you use a weighted hours method. And I'm straying a little bit afield of your question because you asked it about the customer charge, but I don't think that unless I'm mistaken, I don't think that weighted hours method is related to the customer charge. I think it was related to the allocation of distribution, what we would call demand-related costs.
Well, can we get a copy of Ms. Lang's rebuttal testimony? I'd just like to take a look at that. That is just fine with me, thank you.
Okay, I have the testimony now. Is there a page that I should be looking to?
Page 51, please.
Okay.
And I think we're just looking at let's start of that last paragraph on page 51 that runs on to page 52, and I think it says, Ameren, Missouri study remains unacceptably deficient.
Yes, I see that. And, failure to address customer-specific infrastructure, I think I discussed that a little bit earlier, that analyzing customer-specific infrastructure not doing that was not a failure on our part. We believe that doing it is a failure on staff's part because it introduces that bias. This is a class cost of service study, and if you don't treat the same infrastructure for different classes equivalently, if you've analyzed customer-specific on the large customers, but then allocated, class-specific infrastructure of a small customer class based on load metrics that include all customers, we think you double count and bias the results. But this does, I don't see this paragraph here as relating to the customer charge determination. I believe it relates to the allocation of distribution costs.
Now, you indicated that roughly 2/3 of Ameren customers have AMI meters, is that correct?
Roughly, that's correct.
Do you have an exact percentage on that?
My rebuttal testimony had one of the more recent statistics I have on it. I don't have it committed to memory. I may be able to find it if you'd like me to try.
But you believe that's in your rebuttal?
Yes, I believe it is.
Yeah, if you could take a second and find it, I'd appreciate that.
Or it might be my, I do think it was rebuttal, but. Yeah, maybe mistaken, it may be my rebuttal. Okay, I think I found it, page 9 of my rebuttal. As of today, and I think rebuttal was filed, so today would have been in February of this month. 795,261 customers have an AMI meter. And so that's of our, 1.25 roughly million total customers. So that percentage is, and this is still, I'm trying to see if I could find a precise customer count number to do a precise calculation, but I think I'll just have to use an approximation of our total customers. But that's 795, 261. Oops, I typed that wrong. It was about 64% at that time.
And that's current as of February of this year?
Right. And I had projected in here later, like on that page, that by July, we expected to have 955,000 meters deployed, or approximately 77% by July of 2023, when rates would take effect.
By the end of the year, by December 31st, what's your expected deployment?
I have that here too, I think. 87%.
What's Ameren's current education process for its residential customers before they receive an AMI meter?
So before they get an AMI meter, they get a 30-day, I think it's a 30-day advanced mailer that it just talks about the meter exchange process. But if I recall correctly, I haven't looked at that piece very recently, but my recollection is that it just talks about one of the benefits of that meter will be it introduces new rate options. But then shortly after they get that meter, they receive a mailing that is called I think it's a benefits mailer. It describes the benefits of their meter, and it introduces that there are on-peak, off-peak rates is how we frame them to customers for them to understand on-peak times and off-peak times. And it also tells them that there's, for more detailed information, there's information on our website, which has some pretty substantial graphs about how the rates work and FAQs about how the rates work. But then there's, and I'm going off of memory, but I think at 4 and 5 months, they get more additional information where it says, after you've had this meter for 6 months, so you're coming up to that point, you will be, if you don't choose a rate plan, you'll be placed on the evening morning savers rate. And in one of those 4 or 5 month mailers, it will show them, for the data that's accumulated for the several months they've had the AMI meter, what their bill was on their existing rate and what it would have been had they been on the evening morning savers rate. And it does not present the advanced rate options directly to them, because we think that limited amount of data, that few months, is probably not the right amount of data for most of the customers to be choosing an advanced rate. But for those customers who are very interested in it, we tell them advanced rates exist and you can go to our website for more information about that. So it's this kind of staged, we introduce that the rates exist, we tell them a little bit more about it, we show them bill comparison of them on the legacy rate versus the new default rate. And then we direct them right now to the web to get more information about the advance rates. And again, this gets to, some of the concerns that have been articulated, I think, in the case, that we don't want to take 4 months worth of data where a customer may not have had a summer yet, a summer of usage, they may not have had all the seasons, and tell them a rate like the Smart Savers or the Ultimate Savers is going to do this to your bill when they don't have a full year's worth of data. But if they are interested enough to go see, hey, how would I have done on this rate for 4 months? It is available on the web. They can log into their account and go out and compare their bills over that time period on the different rate options. And then again, there's pretty substantial information on the website Our call center is equipped with information to answer questions for those customers as they call in. So that's at a high level kind of the process.
So if my understanding is correct, at 5 months, they receive information that basically informs them about two of the rate plans.
It gives them specific information about two of them, and it informs them that the others exist and that they can seek out that additional information.
How long has the residential evening morning saver plan been effective?
We're coming up right on 2 years, I believe. So I'm trying, let me just think that it was a 2021, or it was 2019 rate case, but it was settled in 2020. And then it took about a year to deploy. So I believe it was May of 2021 or sometime around then that we started placing customers on the evening morning savers rate. So about a little less than 2 years ago.
Do you know during the summer period what days and times Ameren experiences its peak load?
Yeah, it's very weather dependent. So it's going to be, it's usually a weekday, although it could happen on a weekend if it was unusually hot on the weekend, more so than happened on a weekday. But we always know it looking backwards. But we also know that it's on a very hot day. It's usually on a weekday. That's, looking forward, that's about as much as we know about when it will occur. Looking backwards, it's very easy to identify.
Is there any data that would indicate that a particular time of day?
Yes. So it's pretty consistent that our peak load is usually set at the hour from 4 to 5 p.m., but plus or minus 2 hours around that is possible. But it's generally the hour from 4 to 5 p.m. In a given year, it could slip by an hour, maybe two, if there was just a particularly unusual weather pattern that occurred. That's really how those peak periods for the ultimate savers and the smart savers are set around that idea that 3 to 7 p.m. are the highest load hours and the load hours where our peak load is most likely to occur.
Now, given that this has been deployed for a bit, or been effective for a bit, has Ameren analyzed how residential customer usage on the evening morning saver plan has changed in comparison to the anytime rate?
No, we haven't done a retrospective analysis of that, but we did provide in testimony in prior cases from Dr. Faruqi, and I replicated that in some of the testimony here, what Dr. Faruqi's experience with the rates predicts that would be. So we have that information in my testimony, kind of a predictive impact that is based off of Dr. Faruqi's detailed analysis and study of hundreds of other time of use rate plans.
Have those customers reduced their usage during peak usage times?
I mean, again, we haven't done a retrospective analysis to prove it. Our expectation is that they would have, but just slightly.
I'm sorry, I said peak usage, I meant peak load, but I think you understood.
Yeah.
Now, with staff's proposal, they wanted customers to be able to transition onto plans, I believe a month within the next billing cycle after AMI meter installation. Does that sound correct?
That's my understanding, yes.
How would that change customer education to encompass the shortened time frame?
I think we'd have to redesign it entirely because obviously telling them for the first time about it 2 weeks after they get their meter would give them very little advance notice, and we certainly couldn't present them with any billing comparison of their bill on the old rate versus the new rate they would be assigned to. And you really obviously couldn't stage it as a educational sequence from meter installation to the 4-month mailer to the 5, to the different time periods. So I think we would have to rework the communication strategy, and it couldn't rely on giving them any bill comparison information before their rate switched, because the meter data just wouldn't exist to do so.
Now, the commission ordered certain load data, and I believe that was filed by staff in response to the commission's April 4th order. Are you familiar with that?
Yes, I am.
And I'm assuming that was prepared by staff, correct?
That was prepared by staff. The order said staff or the company, so the company was in the process of also preparing. But I do believe that the data that we were pulling was very consistent with staff, so we didn't feel it was necessary to make a second filing.
And you indicated you have had an opportunity to look at it?
Yeah, I saw it when it was filed, a week and a half ago, whenever that happened.
When you say consistent with Ameren's, are you essentially saying that you believe staff's filing is correct?
I believe so. I didn't validate every single number, but I have no reason to doubt that it's correct.
Would you like to look at it?
No, I've looked at it. I mean, like I said, I feel comfortable representing that it's materially correct. I didn't look at, down to the kilowatt hour if we agree, but in broad strokes, it's sufficient, I think, for the purpose that we're talking about here, for sure. And I don't have any reason to expect that it's not actually correct.
Thank you. I believe that's all the questions I have for you, Mr. Wills. I know this is thinking back to yesterday for many of you, but are there any cross-examination questions based upon either questions from the commission or questions from myself? Mr. Williams, anybody else? And staff, let's look at give me just a second to pull the order. I believe it's, for Ameren witnesses, it's public counsel prior to staff. Does that sound correct? Okay, so Mr. Williams, go ahead and ask your questions.
Good morning, Mr. Wills.
Good morning.
There's been quite a bit of testimony and discussion about data granularity. What is the granularity capability of AMI as you currently have it deployed?
We have load data from 15-minute intervals, I believe, from it. So every 15 minutes, it records the energy consumption of the customers with the AMI meters.
And how many 15-minute intervals can be stored in an AMI meter before it's downloaded?
I don't know that I have an exact number. I'm not a meter technician, but I believe, I mean, if you're interested in a broad strokes number, I can take a stab at it.
Sure, broad strokes, fine.
I think it's somewhere between 45 and 60 days, something like that. I don't want to ascribe too much precision. I'm not a metering technology person, but I've heard those numbers, and I think it's in that range.
And has data crunching capability improved since 1992?
I think probably so.
No further questions, thank you.
Staff?
Judge, yeah. Can I hand it to him so he can have those? Mr. Wills, we're handing you I believe it's Mr. Hickman's work paper, or from Mr. Hickman's work paper that shows certain allocation percentages in the Ameren study. Does that look familiar to you? Oh, yeah, that's a good point. The work paper is Mr. Hickman's. The highlighting in yellow over there on the side has been added by staff to calculate the percentages.
I mean, the format looks like Mr. Hickman's work paper.
Okay.
I mean, whether whether it matches identically, I don't know. I do see the additions that you're talking about that are not associated with it.
Now, I assume you would agree that in the Ameren CCOS study, 60% of polls are customer-related, allocated based on customer-related allocator?
I haven't looked at that number recently. I mean, I don't independently know that. Are you?
I mean, it's on that sheet that you've been handed.
So I see a 60% number in yellow that was added to Mr. Hickman's work paper. I don't know what the calculation of that is.
Okay. No. Would you like to take a moment and do the calculation based on the work paper numbers there that you have? Double check the 60%?
That calculator gives me a little frustration. Do you mind if I use my phone's calculator instead?
Sure.
So I see that the numbers there calculate to 59.7%. I'm trying to make sure that I understand exactly, that I refresh my memory of exactly what the data that's reflected in here is, whether that's a rate-based number or a revenue requirement number. I'm trying to orient myself. It's Mr. Hickman's schedule that I haven't looked at in a little while. Okay, it looks like it's a rate-based number, so it says it's gross plant and service. But I see that of the number on here, of the polls, 60% is allocated to the customer function.
Okay. And similarly, in the Ameren study, 57% of conductors and devices are customer related. Is that correct? Overhead conductors and devices, I'm sorry.
Will somebody clarify to me also what the term device means as it's being used?
There are a number of devices on the system. I don't know that I can exhaustively list them, but things like switches and lightning arresters and reclosers that are like fused, things, there's a variety of types of things that, are kind of accessories, I guess you would say, to the conductor that helps with the delivery of power or to secure the safety of the system or whatever.
Thank you.
Yes, I see the 57.3% is what I calculated.
Okay. Now, the minimum size of the system for the study is at primary voltage, correct?
I've heard staff make that claim, and Mr. Hickman is the expert on it. I don't know that I can articulate exactly the things that Mr. Hickman would be able to articulate about the details of the minimum size.
Okay. Well, let me ask you this. How many residential customers are served at primary voltage?
Very few, if any.
Okay. And similar question for the SGS customers. How many of them are served at primary voltage?
Served directly, I mean, for both residential and SGS, I'd say very few of them are served directly at it. They all use the primary voltage system, but they're not served at that voltage specifically.
Judge, I don't have enough copies of this, I apologize, but I would like to mark that Hickman work paper that Mr. Wills has been speaking from as exhibit. I think I'm up to 181 and offer that. I will get copies, additional copies if you want additional copies at our break.
Well, let me ask this question first. Is there any party that needs to look at this prior to me admitting it onto the record?
Council would, and just to clarify, it's not just a work paper. It sounds like there were additions to it by staff. Is that
Would
correct?
you like to take a look at it?
Yes,
Yeah,
please.
go ahead. Sorry, go ahead and get it from Steve if you will.
Because I want everybody to have a copy, but I also want everybody to be able to fairly object at this
Sure.
point. Is there anybody else who would like to look at that? And what are we calling that?
I would call it Hickman plant work paper,
Annotated by staff, perhaps?
annotated. Okay, I'm okay with that.
Did you say load work paper?
Plant.
Plant, thank you. Are there any objections to Staff Exhibit 181, which is titled Hickman Plant Work Paper Annotated by Staff? I see and hear none. That will be admitted onto the hearing record. Go ahead, staff.
Now, Mr. Hickman, would you like to verify since your counsel correctly pointed out that this was annotated by staff, would you like to to verify that the percentages shown on that in the yellow highlighting, which of the staff annotations are correct, or are you willing to accept those as correct?
Let me ask my counsel if she prefers me to go through the exercise.
And just for the record, you're asking Mr. Wills, not Mr. Hickman.
Thank you, Judge.
Correct. No, the spot checks that we did, tied out, I don't have any reason to dispute the numbers that are there.
Thank you. Judge, I think that's all the questions I have for Mr. Wills, but I did want to go back to, in your questioning of Mr. Wills, at the very end, you referred to the load data that staff filed on, in response to the Commission's April 4th order. I was just going to suggest or remind you that technically, since it was filed, I think, as a response to an order and was not filed as testimony, it's not part of the record. Do you want to admit that as an exhibit? And I can move that it be admitted as staff's next exhibit 182 if you want to, because if you're going to use it in your order or something, you'll obviously need for it to be part of the record. So how would you like to handle that?
It's my intent that it does become part of the record, that it does be entered, assuming that it survives any objections. Is this the appropriate witness to do that, or would that be better under Ms.
It'd probably
Lang?
be better under Ms. Lange, since technically it came from staff rather than from Ameren. Since you brought it up with Mr. Wills, I thought I'd mention it, so.
I'm going to ask at this point, and you don't have, nobody has to answer this right now, but at this point, are there any objections to that?
Pardon me, for it to be submitted through Ms. Lange when she testifies?
Just scratch what I said. We'll cross it when we come to Ms. Lang. It's inappropriate of me to ask right now whether you have any objections, so we'll just move on.
Thank you. I have no further questions, Judge. Thanks.
Any redirect from Ameren at this point?
Yes, and I'll try to be brief, Your Honor. Mr. Wills, do you recall questioning from staff counsel yesterday regarding the 1992 NARUC manuals excerpt on marginal cost studies?
Yes, I do.
Does Ameren, Missouri conduct a marginal cost of service study?
No, we don't. And to be clear, I wasn't saying that staff is conducting a marginal class cost of service either. I don't think anyone in the state does, or I'm not even really familiar with anywhere in any jurisdictions where that is being done. But the excerpt of my testimony that Mr. Keevil had me read, where I talked about marginal cost, implications in the staff study, wasn't to suggest that staff study is a marginal cost study. My implication was that they're kind of using marginal cost influenced thought to try to do an embedded cost study, and it's a mismatch, kind of those principles is the point that I was trying to make. So, no, I do recognize that marginal cost studies exist and they can be done validly. I just think there was some cross-pollination of concepts there that's influencing an embedded cost study that doesn't need to be there.
And do you recall questioning my staff counsel yesterday regarding the benefits of the proposed rate switching tracker and the benefits of the TOU rates being related?
Yes, I do.
So how are the benefits of the tracker proposed and the benefits of the TOU rates and tracker related?
Sure. So the TOU the rate switching tracker that we've proposed is intended to align the company's incentives to encourage more adoption of those rates. So to the extent that those rates are viewed by the commission or viewed by us or anyone as to providing benefits, which we believe they do, the rate switching tracker can amplify those benefits by getting more participation, on those rates. So create additional benefits.
And do you recall questioning by staff counsel yesterday regarding the regulatory lag discussed in the charge ahead order and the regulatory lag for TOU rates?
I do.
So from your perspective, are the source of regulatory lag and then the proposed tracker different between the EV charge ahead context and the TOU rate switching?
Yes, the charge ahead tracker that I used as an example of the commission's kind of policy considerations for giving trackers when a program that could be beneficial to customers but financially detrimental to the utility was an example of was intended to be just an example of that. It's an analogy about a circumstance where the commission sees a benefit of aligning incentives. But the two mechanisms are entirely distinct from each other. The tracker in the charge ahead case is recovering program costs. It has nothing to do with changes in usage. The reason changes in usage came into play in that is that we recognize that program could produce positive regulatory lag for the company, and we agreed that regulatory lag was enough benefit to us that we wouldn't seek to put the kind of deferred costs under that program into rate base. But there was nothing being tracked with respect to changes in revenues. There was being tracked program costs for future recovery. The rate switching tracker, again, it was only a policy analogy that I was using, bringing in charge ahead. There's no direct interaction between these trackers. The rate switching tracker is specifically identifying revenue erosion from existing revenues that give the company an opportunity to recover its revenue requirement when customers switch to a time of use rate and save money, and where the cost savings are either passed through the FAC to customers, and so the company doesn't have offsetting cost reductions, or the cost reductions are in the future associated with avoided future investment.
And do you recall your discussion with Chairman Roop yesterday regarding more data needed for a direction forward and breaking the cycle of disputes?
I do.
From your perspective, will providing the requested granular distribution data help the parties move forward?
I really don't think that it's going to make a meaningful difference in kind of breaking that cycle of disputes unless and until the commission addresses the methodological concerns. So I think that the data disputes are really kind of a symptom, but the underlying cause is just this significant methodological disagreements that we have. I think the discussion I was just having with the judge kind of illuminated some of those, and the record is kind of pretty complete on some of those. I think the methodological disputes are what is underlying this. To the extent, though, that more data is needed, or if it is needed, I think it's important that we collect the correct data. I think there's been a lot of discussion over the last day and rounds of testimony of what we call the Vandis study. I think the Vandis study is the right data to properly allocate costs based on cost causation. And if there were going to be efforts to collect data, there have been concerns raised about the age of the Vandis study. And I think, a similar effort could be made to refreshing that study and making sure for everyone that it's current, and that there's no questions about whether changes in the system since it was conducted. But to me, that's the type of data that would be most useful to collect. Again, I think we had a good conversation already about our concerns with going into customer-specific data and how it may introduce bias into the results. So I would just urge the commission to weigh in, on the methodological issues before considering what is the data that ought to be collected. Just one or two quick other thoughts. I mean, whatever data is collected, I think there's been discussion, should it be provided for the working docket going forward? That working docket, I know we don't know the timeline of it, but I believe it probably would start relatively soon, and that data collection is going to take time. So I don't know that any of that data is going to be there at the outset of that working docket. And secondly, I would just say I think I very much appreciate Chairman Roop's interest in having more data. I just want to make sure that we're thinking about getting the right data and also recognizing that, there are limits to the kind of the resources of the company's personnel, and so we need to make sure that we're targeting the stuff that's going to have the greatest benefit to customers and to accurate and reasonable studies, rather than casting a very wide net that is going to produce maybe a lot of data that's not useful to the process, where there is a lot of significant amount of data that is helpful and could instruct the commission. So I think we really just need to be focused on getting the right pieces.
Those are all of my questions. Thank you.
Thank you. I noticed that MIEC's attorney was able to make it here. Would you enter your appearance for the record?
Certainly. Diana Plesha, the law firm Curtis Hines Garrett and O'Keefe for MIEC.
And if I remember right, you didn't have any questions for this witness?
No. I think I texted you. I didn't have any questions for Mr. Wells or Mr. Mark. At least not at this point. Thank you.
Thank you very much.
So we've done.
You may step down, Mr. Wells. I'm sorry.
No problem.
One of the commissioners has a prior obligation at about 11:30. So it's my intent, well, what I would like to do is break about 11:15 for lunch. And that means depending on where we are, we may break to 12:30 or 1. With that in mind, I'd like to go ahead and take a 15-minute break now, rather than do that later. So why don't we, it's now 9:46, why don't we come back at roughly 10:01? Is there anything I need to take up prior to that? And then we'll start it when we get back at 10:01 with OPC's, or Public Counsel's, first witness. And let's go off the record. Ameren, Missouri, do you have any more witnesses for this issue at this time?
No, sir.
Thank you. Public counsel, you may call your first witness.
Dr. Jeff Mark.
Dr. Mark, would you please raise your hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Please be seated. Public counsel?
Would you please state and spell your name?
Jeff, Geoff, Mark, Marke.
Dr. Mark, did you prepare and cause to be pre-filed direct testimony and surrebuttal testimony, the direct being pre-filed on January 10th of this year and the surrebuttal being filed on March 13th of this year, that have been marked for identification as Exhibits 200C and 201C respectively?
Yes.
And would you have any changes to either of those exhibits for them to be your testimony here today?
No,
Are they in fact your testimony here today?
they are.
With that, I offer Exhibits 200C and 201C.
Are you also offering the public versions?
Yes, I mean, sure.
I guess it doesn't matter, but
That was my thought. I mean, the 2OC are the ones for the commission and the public ones are for public viewing.
all right. Is there any objection to admitting 200C and 201C, the direct and surrebuttal of Jeff Mark onto the hearing record? I see and hear no objections. Those will be admitted onto the hearing record. Go ahead.
I tender Dr. Mark for examination.
And for public counsel witnesses, for first order of cross-examination, I have the commission staff.
Just briefly, Judge, good morning, Dr. Mark. Are you familiar with did you participate in Ameren's last Missouri rate case?
I did.
And are you familiar with the order in that case that ordered a rate modernization workshop?
Yes, I am.
Has that workshop ever taken place?
It has not materialized to date.
Now, conceptually, would it make sense for that rate modernization workshop to conduct one or more class costs of service studies in the workshop?
I believe so.
As part of that workshop process, relevant data can be placed into the record rather than buried in data requests and discovery conferences. Is that your understanding?
Yes.
And is that a good thing?
No. No, ideally you want that data to be as transparent to stakeholders as possible.
Okay, so you would think it would be a good thing that if the data was available?
I think I misunderstood the question.
I think you did, yeah.
Okay.
Let me say
Sure.
it again. As part of that workshop process, relevant data can be placed into the record rather than buried in data requests and discovery conferences.
Yes.
And would you believe that's a good thing?
Oh, absolutely.
Okay. Now, if you would design time of use rates, would you consider only average embedded costs, or would you want information on certain marginal costs?
I think I would want as much information as I could have available to make an informed decision.
Okay, thank you. That's all I have, Judge.
Any cross-examination from MIEC? Any cross-examinations from MECG? Any cross-examination from Sierra Club, NAACP, and MCU?
No questions, Your Honor.
Any cross-examination on behalf of Renew, assuming that Mr. Linares is participating via WebEx? Okay, I have not heard from him. Any Any cross-examination from Consumers Council of Missouri? They are also not here. Any cross-examination from Ameren?
Yes, Your Honor.
Go ahead.
Regarding class cost of service, Dr. Mark, you agree that class cost of service studies rely on a host of simplifying assumptions in order to produce workable results, right?
I do.
And you've been involved in the Ameren, Missouri general rate cases for the last 10 years, probably, right?
Yes.
Okay. Would you agree that Ameren, Missouri's class cost of service methodologies have been relatively consistent over that 10-year period?
I would.
If I could point you to your sir rebuttal testimony, sir,
Sure.
and specifically page 26.
I'm there.
So I was just generally going to look at lines 12 through 14, but you described the various parties' class cost of service studies and recommendations at this point quite, quote, a mess. Is that right?
That's correct.
You agree that the results of staff study in this case versus the other parties' studies are materially different, correct?
Yes.
And the difference between the other parties' class cost of service studies and staff's study results, or staff study, result from the significant changes in approach that staff is proposing in this case.
Those are that is the primary difference.
And you don't disagree with company witness Thomas Hickman that the allocator used by staff for distribution assets is in effect an energy allocator?
That's a good question. My review of staff's methodology, it's been a while, but I don't know if I would characterize it as a straight energy allocator.
So you would disagree with company witness Thomas Hickman that the allocator used by staff is an energy allocator applied to distribution assets?
I don't think I can say at this moment. I think I would need to look back at it.
Do you recall being deposed on Friday, March 17th of 2023?
I do.
And it was with regard, or you were deposed with regard to this case, is that right?
That's correct.
Okay. And I have a copy of the full transcript, but do you recall the following exchange that counsel for Ameren asked, do you have any reasons to doubt that Mr. Hickman is correct, that the allocator used by staff is an energy allocator applied to distribution investments? And your answer being that I don't disagree with.
If that's what the transcript says, that's what I said.
And do you recall during or at the conclusion of your deposition, counsel's agreeing that even if you hadn't signed the errata or signature sheet for your deposition, it would be deemed signed? Do you
Yes.
remember that? Okay. Do you believe the cost driver for distribution investments like poles, meters, and conductor to be total energy consumption?
I think historically, that was a reasonable way of looking at things. I'll tell you this, staff's methodology has challenged my assumptions on a lot of that. In short, what we're experiencing here when we talk about rate modernization and rate, whether it's rate design changes, I think what we're finding, at least from the cursory data that I've seen with Evergy and to a certain extent with Empire as well, is a lot of stuff that's challenging our assumptions about how customers are using their electric bills. Some of that might be COVID specific. that we're looking at data that's maybe presents an outlier to how things are going. But I think that's a healthy thing. I mean, so what you've got are two separate things going on. We've got a methodology, the NARUC manual, it's been around since '92, that's been moving forward with certain assumptions and methodologies about how we conduct a class cost of service study, running in contrast with what's going on in the market. And what do I mean by that? Coal plants, for example, coal plants being, under the NARUC manual, I would sit there and say that that's very much a baseload plant. And we're getting closer to the point where those plants aren't necessarily operating in that manner all the time. That's not to disparage, the 92 manual. I think that still offers a good framework, but to suggest that's the only way of looking at things, I think, I think my opinion on that's changing as the evidence changes with it.
And you're aware that the class cost of service studies presented both by staff and the company are embedded, so they rely on historical costs, correct?
I am, yeah.
And do you recall, I think we've already established, you recall being deposed on March 17th of this year in this case?
I do.
So do you recall the following exchange? Ameren's counsel asked, do you believe that the cost driver for distribution investments, examples, poles, conductors, to be total energy consumption? Is that the cost driver for those investments, those distribution assets? And your answer was no. Do you recall that exchange?
If that's what the transcript says.
So based on the historical information and the embedded cost studies, you don't believe that the cost driver for those investments, distribution investments, to be total energy consumption. Is that correct?
Correct.
So I believe staff counsel was asking you some questions, but I want to make sure I understand. Do you think it would save potential time if the mess, as you called it, of diverging class cost of service studies is cleaned up with a bit of guidance from the commission on what methodologies are reasonable before that working docket it commences?
I'll tell you what changed my mind on that. Because I believe in my deposition, I said yes, that getting some guidance from the commission would be helpful. I think it was Mr. Opit's opening yesterday that really challenged that. And I think Chairman Roop had asked Mr. Opitz whether or not guidance would, if you went with a certain thing, would, this be set in stone? Would commercial and industrial customers always argue for average and excess? And I struggle with absolutes, especially in the world that we operate today. Mr. Opitz gave the example of, what if we were deregulated? I think that's an extreme example. I think what you're seeing right now that's challenging my assumptions is different load shapes, different end users, the proliferation of distributed energy resources. Now, I don't think that's stuff that's necessarily going to have a profound impact if we were to meet next month or this summer over this rate case, but to dismiss that out of hand, and that would be my concern with having the commission give their blessing to one methodology that was produced 30 years ago and saying that's what we should do. I'll take it a step further, and I think it's misleading to suggest that the industry standard is somehow average and excess. We've talked a lot about bias confirmation. And I think what you're seeing there, and I am familiar with a lot of states and methodologies that are utilized there. I think what you're seeing primarily, who files class cost of service studies outside of the company. In some states, I mean, we have a luxury here with the Public Service Commission staff devoting as much time as they do with class cost of service studies and working towards what I think is alignment in how the PSC is putting together rate modernization and the guidance that we have been given on time of use rates. In some states, you don't even have staff that produces a class cost of service study, and stop. What you do see are commercial and industrial customers that have a very vested financial interest in producing a class cost of service study with what I would characterize as a specific lens, a specific perspective on how the cost of service should be allocated. And I think because of that, you're getting a biased sample when we're generalizing about what takes place, across the area. What you have seen in the last 5 years is you've seen NARUC take an active interest in rate modernization and produce several white papers that I think align with staff's methodologies. You've seen respected institutions like the Regulatory Assistance Project move forward with that, I think. And all of that's necessary. I mean, all of that is absolutely necessary when we take in consideration our changing modernization of our grid and the customers that we serve. So I think in my deposition, I gave an answer that was largely predicated on, are we going to make any progress if we are agreeing to disagree when we get into that? Having commission guidance on that would certainly minimize that. If the commission were to say we're using this methodology and nothing else. So I agree with that. I mean, it would minimize conflict if they said, well, we're only going to do one thing and that's the only way we're going to look at this. I would recommend highly against that. Just when the facts change, your opinion should change. When the rate structures and the cost of service changes, we should have the methodology that adapts and moves towards that. So I've modified my answer, I guess, from my deposition a couple weeks ago.
Well, has OPC changed its position then on, so does OPC support staff's proposed revenue increase allocation, which is based on its direct class cost of service results, as presented in their position statement?
So I can't speak for OPC. I would have to get further dialogue with Mr. Poston on this. Our position in my surrebuttal testimony, that recognized that there's some tension between the groups that have filed class cost of service studies, and our overall recommendation was effectively an equal percentage increase across the board. And that was largely due to the overall size of Ameren, Missouri's rate increase.
So just so I'm clear, in staff's position statement, have you reviewed staff's position statement?
I have not.
If not. So you're not aware that they are not recommending an equal percentage allocation across classes, that instead they are recommending that the LGS class should receive an initial increase in its revenue responsibility of approximately 3.75%, and the LPS and SPS classes a 7.5% increase. Then the remaining increase be allocated equally across all non-lighting classes.
And Ms. Krebs, what I would say is that, public counsel always operates from the assumption that we represent all classes. We're not just a residential consumer advocate. We're looking at large power, small general, all of it. And the feedback that I received was in totality, again, against the rate increase that was being requested. We had requested that it be an equal increase across the board, across classes, with the exception of company-owned lighting.
So just so I'm clear, you haven't changed your position? Okay. With regard to the customer charge,
Yes.
in your surrebuttal testimony, you describe that from a customer perspective, costs should be avoidable, so that if a customer chooses not to purchase a good or service, the customer has no residual obligation to pay some portion of the cost to provide that good or service. Do you recall that generally?
I do.
So once a customer makes a decision to connect to the grid and take electric service, from a customer charge perspective, things like the cost of the meter, the service line, the poles, the transformer, the postage for mailed bills, that won't change based on the amount of energy the customer consumes or the timing of when they consume that energy, will it?
No.
And Ameren, Missouri has an obligation to serve any new customers that meet the eligibility requirements as set out in Ameren, Missouri's tariffs, right?
Yes.
So if the customer requesting service doesn't pay the cost to connect their residents to service, that cost is going to be borne by all customers, correct?
Yes.
And keeping the customer charge low by shifting some of the customer-related costs to the energy charge could hamper or undermine electrification efforts such as adoption of EVs, could it not?
For that niche issue, and I would caution, I guess, I don't believe I can give a yes, no answer. I guess I would say yes with qualifications.
So your answer would be it could, but you'd have caveats to that.
Oh, yeah.
Okay.
Yeah.
Those are my questions. Thank you for your time, sir.
Thank you.
Any questions from the commission? I hear none. I've got a few questions for you. Setting aside what the actual proposed customer charges are, setting aside those numbers, what's OPC's or what's Public Counsel's position on having different customer charges for different for the different residential class rate plans, such as being proposed by Ameren?
It's a good question. So in general, we take a pretty strong position on the customer charge. And there's been a couple different answers regarding that. Customer control over their bill, more aligned with cost causation. I'm going to throw out a third one that could help illustrate our position and how that relates to multiple different customer charges. And that would be, we're economic regulators. Like the whole process of being here today, it's economic regulation. I mean, that's the impetus behind this. Now, since then, there might be other policy considerations that have moved forward and other things, but effectively what we're talking about is a natural monopoly. And what this is, as I deem this whole process is, it's a proxy for the market. And we're trying to illuminate that as much as possible. There's a risk and reward that's inherent in just about every decision that we're talking about, whether that's Ameren's investments or how we design rates. And the company's exposure to fluctuations in their revenue recovery. But it's a proxy for the market. Every other company that operates out there in the free market has to face those inherent difficulties and risk. We deal with that, and through the ROE, through earned opportunities for the utility to be not only be made whole, but to make a profit. What we have seen over the number of years here is just an erosion of what I would characterize as risk or risk shifting. Every every acronym surcharge that you have on there presents more certainty for the customer or for the company, trackers, decoupling mechanisms, PISA, all of this. And the customer charge equates to that as well. And the illustration that I gave, if you think about it, we wouldn't charge you $20 to just go into Gerbs and have the ability to go ahead and buy food. But that's effectively what that customer charge is doing right now. I recognize that it shouldn't be zero and that there's good policy reasons for, making sure our utilities are healthy. And believe me, they're healthy. But the idea that it should mirror or try to mimic marginal cost and what's taking place within that market as much as possible is a priority, at least from my perspective. So with that in mind, ultimately, I don't think it matters that much. I think you can make a compelling case for different numbers. But given moving forward with billions of dollars of investment for MIA and demand-side management programs, for the whole concept of time of use rates and trying to enable customers having more control, well, by increasing that customer charge based off of one perspective of a methodology, you're diminishing that price signal. You're diminishing that ability to control that, and ultimately undermining what I believe is the effort that the commission has put forward, and really the underlining impetus behind this huge investment of AMI technology to begin with.
I'm going to ask a compound question here, but I think it's appropriate as it's done, and that is, what do you think the pros and cons of having a different customer charges are?
So the cons are potentially customer confusion over it. I would say that's probably, in practice, it's probably fairly minimal. I think most customers are probably oblivious to exactly what they're being priced because they're not being charged it on the moment of consumption. Again, giving the Gerbs example, if I go there and I buy a gallon of milk, I know how much I'm paying. With my electric bill, I'm not getting that for a month later. And there it requires, there's a bit of a disjointedness in the actual consumption and when I actually see that price signal. So I'm a cooperative customer right now, and I can tell you that we've got a very high customer charge. And that customer charge, talking to my family, my wife, because we were Ameren customers a little long, not too long ago, and we made as you can imagine, I'm very conscious of how much energy we consume. Spend a lot of time with MIA and everything else. So we've got an insulated home, it's energy efficient. So when my wife asked me that same proposition, like, do we need to be on top of this? Financially, no. We're going to end up paying the same amount whether or not you keep those lights on or not, because we got such a high customer charge. And that's going to, so our efforts in terms of conservation, our efforts in terms of controlling our bill, well, it'll be more stable. So that's what you're getting with a fixed cost being embedded and being pushed out to that. And I believe that runs counter to a lot of other policy directives. And I know you had asked Mr. Will some questions that he had struggled with in terms of, well, if your study said this, why is Ameren proposing this, something different? And in part, it goes back to those bond-bright principles that and a lot of times contradict each other. How do you, enable customer control but make sure the company's made whole? How do you, and it's a juggling act, and it's one that's constantly evolving. It will be one that will constantly be argued with long after I'm gone if we're still operating under this paradigm. So pros, Miss Grubbs makes a good one in terms of like EV consumption. If I'm a customer that's using a lot of energy, if I've got an electric space, or if I got a heat pump, if I've got an EV car that's being generated there, I'll pay less ultimately. Now, I'm struggling here a little bit because the other element to this is that time of use element, right? So I say I'm paying less. Obviously, it's going to depend on when I'm using that consumption. But all things being equal, if I'm shifting cost from fixed to variable, I'll have more consistency and probably, I mean, if you're conscious of it, probably have a perverse incentive to probably use more than you otherwise would.
You used an analogy of going into a grocery store, and I know that I've thought about this, and I've often thought about, you know, the idea of no customer charge as the idea of renting a car and thinking that all you have to pay for is the gas rather than the rental of the car itself. And I realize that's an imperfect analogy. What are you getting for your customer charge? And this kind of goes to the benefits, but I'm just trying to clarify it a little more. You said you have a high customer charge. What's your gain from that?
So I'm going to answer that like in two parts, because in both parts are somewhat very different. The first part that I'm going to answer is just the nature of embedded versus marginal cost structures that we operate in here, and how that is, because this is a natural monopoly and there are lumpy investments, it's huge capital dollars that we're putting in there that need to be recovered over many years, maybe even generations. It requires more of an adherence to accounting principles to make sure that company is made whole, that they don't, that they are financially sound, that we're able to move forward with things. That same principle does not apply necessarily to GURPS. That same principle does not necessarily apply to a pizza restaurant that is dependent on those customers coming in and making those costs. And they still have to cover their fixed cost. But if they don't, they go out of business. And that's the market at work here. What I would characterize what we do here with utility regulation is a balancing act between those two. And that customer charge, and this is the second part of this, is a way to mitigate that, in part. The second part of this is, what do you get out of this? I could sit here with a straight face and say that there are costs within that distribution allocator that are fixed, that should be recovered there. But it's a judgment call. And, you know, my testimony goes into this and quotes Bondbright directly on this specific issue. I think he used the word that, you know, analysts essentially fudge these numbers, you know, because it isn't a clear direction. That's just how it is. But the benefits from it, from a customer standpoint, it goes back to what I said earlier. If I've got more fixed cost, if I've got if I was just paying a straight $100, say, customer charge that covered and made sure the company was being made whole, it would be a buffet style pricing signal where I could definitely consume as much energy as I wanted, and that would effectively have a feedback loop in encouraging further investment and further build out. So each one of these issues builds off of the next. So, you know, I think I've got examples. I'm probably not in this testimony, but in the past I've done sort of a flow chart of a revenue requirement, and moving that revenue requirement, the next stage being the cost allocation, how you divvy up that pie, how big is the pie, how do you divvy up that pie, and then effectively how you're pricing that. But how you're pricing that's going to influence the future revenue requirement. So if we're pricing things in such a way to encourage consumption or to ensure greater recovery, depending on how you look at it, that can have the unintended impact of increasing consumption and increasing future investment moving forward. Pricing matters, I guess, is the long short of it. I'm trying to get a lot in there, and I'll stop there.
Are you aware of any other jurisdictions that have different customer charges for different residential rate plans?
It wouldn't surprise me. I'm not off the top of my head. Let me think for a second. Gosh, we might have already had some here in Missouri. Yeah. I'm looking over at Sarah here, but she said Ameren. I'm thinking even Evergy had different customer charges for space heating customers versus, I mean, if you really go back, I'm sure that's been the case. I mean, we've had, rate designs that have encouraged consumption, like space heating, so it's a declining block. Really, in the 50s and 60s, I mean, that was designed to, with the proliferation of air conditioners and everything else, it was very much I guess what we would characterize as a promotional rate now, but I wouldn't be surprised. So here in Missouri, we have.
You indicated that, at least in regard to one of the things that Ameren asked you, that since that deposition, your assumptions have been challenged in regard to certain things. Has the proposition of having different customer charges for different time of use rates challenged your assumptions in any way there?
I have not given it a lot of thought. My knee-jerk reaction is to support a low customer charge, not a zero customer charge, but a low customer charge. I can hold more than one competing idea in my head. So I can see like a rationale where you can justify having a different customer charge for a customer that might be more aligned with that. I guess I don't have a real strong opinion. I think in one of the bond buy principles really is just simplicity and getting that issue across. With that in mind, my recommendation to the commission today would be to keep the residential customer charge uniform across the board. I'll throw out one more caveat that might add some to that. I might have a different opinion on that if this was Evergy that was fully deployed with AMI meters and has done a number of studies on this. Ameren isn't as far along in that process. 2/3, I think, is where we're at in terms of full deployment. So there's room, for working towards something.
Speaking of AMI, staff has proposed moving towards time of use rates or within a month of switching to AMI. How would customer education have to change to accommodate that?
It's a good question. I've been in a fair amount of customer education, time of use workshops, conferences, meetings with all of the companies. Ultimately, I don't think the concept is that difficult to understand. We had time of use pricing with telephones before, day-night versions. This isn't, I think even a lot of customers incorrectly assume they are actually being charged different based off of the time of day. I am sympathetic to the company's considerations in terms of what they need to do on their IT side, what they need to do in terms of educating customers and making that happen. I've got no reason to doubt those assumptions. But like anything, I think it's a matter of if you want to throw money at it, you can make it happen. In terms of the education within a month, so the big concerns you're going to have here are the vast majority of their customers already have it. Really, the concern comes down here, Your Honor, how big the differentials are going to be. That's it. I mean, it probably won't have that too big of an impact if the differentials are fairly small. Customers probably won't even be aware of it. If the commission elects to go with something with a greater delta, then the risk increases, potentially. The payoff increases, the reward increases as well. So I'm not sure I answered your question really well. A month seems quick.
At the same time, OPC, or Public Counsel, indicated it did not oppose a month lead-in time. Is that correct?
That's right.
But it sounds like from what you're saying that you don't really support a shortened lead-in time either.
I don't think we had a real strong opinion on that. I'm going off of my gut reaction here. I haven't been tasked with actually trying to roll one of these out on the IT side. I think, having spoken with Ameren about it, I think that makes sense. But I absolutely understand where staff is coming from in terms of we're sitting on issues, we're dragging our feet. And intuitively, this isn't that difficult of a concept to get across. I really agree with that. Again, the issue comes down to those differentials. And then really what you're being exposed to is it depends on how it's designed. How, say, 10% of the customers that might see a real profound impact on their bills negatively, probably more than that with a number that's better. And I'm saying that based off of other utilities load shapes that I've looked at. I don't know. I can't speak right off the top of my head with Ameren, which again, kind of points away of why data is important, and hopefully that this future rate design docket, if we intend to move forward with that, can help expose a little bit more.
If Public Counsel had to propose a lead-in time that they could support, what lead-in time would Public Counsel choose?
Well, I'll split the difference. I'll say 3 months.
And kind of going back to an earlier question, what changes would need to be made to customer education to accommodate a 3-month lead-in time?
So I spoke with a utility executive about this not too long ago, and he was of the opinion that it only took 90 days to go ahead, and anything more than that is improperly working up customers maybe negatively, but 90 days was effectively what you needed to do. And that would start with an email campaign, bill inserts, billboards, any number of things. And I think reasonable minds can kind of disagree or disagree as to what the proper venue for that information is. Where you've seen it, full deployment of time of use rates. I go back to this, like 2/3 of their customers already have time of use rates. So it just comes down to the differentials and how big that is. So I think it's going to be a challenge anytime you do something first. So if we are talking about a large differential and you're moving that forward, that's going to be a challenge in conveying that information, but because it's their first time really doing it. Not to say like they haven't put out information, but, and I think Chairman Roop used this as an example that he just got information like a week ago about his AMI and how that's going to be impacted. I would imagine that rolling it out across the board would require more of a universal, a general education plan. And that might not, now that I'm saying this out loud, I could see where there could be a lot of confusion over this. Because if you're an Ameren customer in Jefferson City, you might not get that meter till later this year. So if you're getting information on that time of use rates, there's going to be the delay.
Okay, thank you. That's all the questions I have for you. Is there any recross based upon bench questions? Staff?
Yeah, very briefly, Dr. Mark, there was extensive discussion there between you and the judge about customer charges. Are you aware that staff's concern with Ameren's proposal in this case is that the ultimate saver rate would be marketed as a low-cost option for customers concerned with the size of their customer charge?
I am aware of that.
Did you agree with staff's concern?
I am, and as I understand staff's concern, it's framing it as this is cost savings, and this was a similar issue that had come up in Arizona, is my understanding, when they tried to roll out time of use rates in terms of their marketing. And this really extends even to the name of it, ultimate savers, and this concept. And in the last rate case, admittedly not a good one, I put out a suggestion for, red or blue, or calling it those sort of savers as something neutral, but framing it as something that's the really, really good savings rates, right, is somehow misleading or could create more problems than not. I think it's a valid concern.
You also mentioned in discussion with the judge early on about one of the, or I guess the primary focus of what we do here is economic regulation in an attempt to mimic the market. I think you used that phrase. Are you aware of Ameren's proposal in this case for their time of use tracker mechanism?
I am.
And how would you say that fits in vis-a-vis your discussion of the market and mimicking a market?
This is one of those issues where I just want to throw my hands up in the air and say, at what point do we just sit there and say, would it just be easier if we're going to abdicate all risk onto ratepayers? Why don't we just run it as a state entity like Nebraska and move forward with that? What gives me heartburn about this is the General Assembly moved forward with Plan and Service Accounting, SB 526 or 62, and gave them the option. You could do PISA or you could do decoupling, but not both. We actually had one utility that went the decoupling route and then said, no, we're not going to do that. We're going to go back to PISA. And that's a huge boon for the utilities. Look no further than their earnings statements over the last few years across it. It's a straight line up. That's regulatory certainty, that's cost recovery, and it's all designed to encourage investment and so forth. But it has diminished the concept of regulatory lag. It has diminished a lot of the historical mechanisms that we've relied on. Regulators have relied on, stakeholders have relied on to go ahead and provide that proxy for the market. A tracking mechanism sounds innocuous. It sounds like something, well, we're just going to track how much they've lost or gained. It's no big deal. But the assumption behind it is that they're going to get that recovery back. And that's how their investors are going to look at that. That's how that's embedded in that. Now, can the future commission say no? They could. My experience is that if it's being tracked, it almost universally does get recovered. So my objection to it is twofold. One, it diminishes that economic regulation principle by, again, shifting risk. And two, I can't remember my second one now. But yeah, it is. Ultimately, then those customers are going to end up paying this cost anyway. So, ultimate savers, parenthetical for now. It might be a more apt description of that rate design. And I'll throw a third one in there right now. We don't know. We don't know. We could very well, get into a situation where customers end up paying, a lot more. And I'm telling you as a consumer advocate, given the option between that risk of consumers potentially paying more and not, I'll take it. Because I don't want to further erode the regulatory principles that we've been operating under in this state for past 100 years.
Somewhat related to that, I think, under time of use rates, is it possible that we would see, because of the shifting of the usage, we'd actually see more consumption?
Objection, this is beyond the scope.
He was talking about the perverse incentive earlier in response to the judge, and it's
What's the
related to what he was just
Mr.
talking
Keevil, what's
about
the
anyway.
question?
I was going to ask him, well, the first question was, is it possible that we would use more, you would have more consumption under time of use rates than because of the shifting in usage? I think he said yes. Then the follow-up question is going to be, ask him to explain that.
I think Ameren's saying that's outside of the scope of bench questions. Is that correct?
That's correct.
But you talked about, in response to your questioning, he was talking about what he termed the perverse incentive under time of use rates, I believe.
I don't remember that.
Okay.
I'm going to sustain the objection.
Okay. I think that's all I have then.
Thank you. Any further cross based upon bench questions? Any redirect?
No, thank you.
Okay. Dr. Mark, you may step down.
Thank you.
Next up, I have Consumer Counsel's witness Hutchinson. Both Hutchinson's direct and rebuttal were admitted onto the hearing record yesterday, and so that witness will not be taking the stand. So next up, I have MIEC's witness Brubaker. Mr. Brubaker, would you raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony you're about to give in this evidentiary hearing is the truth?
I do.
Please be seated, and would you please say and spell your name for the record?
First name is Morris, M-A-U-R-I-C-E. Last name Brubaker, B as in boy, R-U-B-A-K-E-R.
Thank you. And I'm going to say I'm aware that there is a staff motion to strike this testimony that's still outstanding. Is it there? No, I think you're correct. I apologize. Go ahead.
I might also say regarding that motion, if the stipulation which was filed earlier, and we're going to have the presentation on tomorrow, tomorrow, if the stipulation is approved, then that motion goes away.
It's moot.
Yeah.
And I kind of thought that might be the case, but I wasn't going to inquire about it at this point. Okay, MIEC?
Thank you, Your Honor. Mr. Brubaker, by whom are you employed and in what capacity? Excuse me.
With the firm of Brubaker and Associates, and my current title is president.
Okay, and did you cause to be filed in this case direct, rebuttal, and surrebuttal testimony?
I did.
And those will be designated as Exhibits 350, 351, and 352. Do you have any changes or corrections to that testimony?
I do not.
If I were to ask you the questions that are set forth in those testimonies, would your answers today be the same?
They would.
Okay, then I'd go ahead and like to request to have the exhibits admitted into the record. At this time, 350 for direct, 351 rebuttal, and 352 surrebuttal. And if those can be admitted, I would tender Mr. Brubaker for cross.
And I don't believe I have an exhibit list from you. Is that correct?
Oh, I thought we had turned one in, but I will get that done right away.
You may have. Let me look. Was that done today?
I think it would have, if it was done, my legal assistant, I saw some emails from her about sending it several days ago, so I'll make sure that that gets into the record immediately.
Okay, I don't see it. That doesn't mean I didn't miss it. Would you go over those exhibit numbers again, please?
Sure, 350 for the rebuttal, I'm sorry, for direct, and 351 for rebuttal, and 352 for surrebuttal.
Are there any objections to admitting exhibits 350, 351, and 352 onto the hearing record? I see and hear no objections. Exhibits 350, 351, and 352 are admitted onto the hearing record. Please go ahead, MIEC.
For questions for Mr.
Did you
Brubaker?
tender your witness?
I'm sorry, I thought I did.
You may have.
Yeah, tender the witness for cross-examination. Yeah, please.
I apologize, I got off track for a second. Okay, I have the first questions for this witness from MECG.
Good morning, Mr. Brubaker.
Good morning.
In the revenue allocation recommendations in your direct testimony, those were not based on a particular revenue requirement, were they?
No, it was neutral. It was based on how I would adjust rates at current levels before it increased to move toward costs, and then overlaid with an average of whatever the increase is that the commission would find appropriate for Ameren.
And now that we do have a, I'll say a filed revenue requirement stipulation, do you have you done any calculations that would show what your recommendation, what the impact of your recommendation would be for each class?
I have made those calculations, yes.
Can you tell me I guess first off, on an overall, if it were allocated on an equal percent basis, what would the increase be based on the revenue requirement stipulation?
Judge, I'm going to object to that. I think to the extent that this is attempting to change position, which it sounds like it is, I think it's wholly inappropriate and contrary to the commission's rules on testimony. And secondly, I think it's obviously friendly cross coming from one industrial intervener to the other industrial intervener's witness.
Your Honor,
Mr. Opitz, first, before you, and I'm going to give you an opportunity to respond. Before you respond, would you repeat the question for me?
I guess that particular question isn't important, so I'll withdraw that question. I'll say, Mr. Brubaker, under your recommendation, now that we know the revenue requirement, what would be the increase for residential class?
Based on my
percentage basis.
recommendation of moving 50% toward cost of service and using an overall 5.14%, which I think is approximately correct, might be a little bit off on a decimal point, but based on an overall average of 5.14%, to move 50% toward cost of service would increase the residential rates by an average of 6.7%.
How about the SGS class?
5.6%.
The LGS class?
3.2%.
And I guess the SPS class?
I have the two combined, so they would both be 3.2%.
LPS class?
1.7%.
Ameren lighting class?
3.9%.
And customer lighting class?
14.2%.
Are there any classes that I missed?
There are not.
Okay. That's all the questions I have, Your Honor.
Sierra Club, The NAACP and MCU,
No questions, Your Honor.
thank you. Is Renew Missouri on?
Yes, no questions. Thank you, Judge.
Consumers Council of Missouri is not present. Public Counsel,
No, thank you.
Commission staff?
Mr. Brubaker, there we go. Mic's working now. In producing the new recommendations that you provided today in response to Mr. Opit's question, did you use the same rate-based values used in Ameren, Missouri's revenue requirement direct testimony, or did you adjust rate-based values to correspond to the stipulation?
I adjusted the filed cost of service study by Ameren, and then I adjusted the revenue increase to match the stipulation.
Yeah, but did you adjust the rate-based values underlying the study based on the stipulation? Because the stipulation changes the rate, Ameren's rate base, does it
To
not?
some extent, yes, but it does so somewhat proportionately. And so my approach, which I had outlined in my direct testimony, was to scale up or down based on what the overall average increase awarded to Ameren is. So I think it proportionately captures all those changes in the underlying values of rate base, expenses, and so forth.
If those costs were evenly distributed across classes, would there even be a need for a CCOS?
No, but they're not. And that's not wasn't the question that you
No.
asked me. You asked
No,
me if I
I
adjusted.
agree they're not.
Okay.
Okay, yeah. In producing the, excuse me, in producing the new recommendations that you provided in response to Mr. Opitz, did you use the same expense values used in Ameren, Missouri's revenue requirement direct, or did you adjust the expense values to correspond to the stipulation?
As in the case of rate-based values, no new cost of service study was produced that would articulate differences line by line.
Okay,
What I did is what I recommended in direct testimony, which was to proportionately adjust it. And I think that's reasonable given the nature of the stipulation and the changes in revenue requirements between the company filing and the stipulation filing.
yeah. What were the changes between the company filing and the stipulation values?
They're laid out in the stipulation. I think everybody's looked at that. If you want me to have a memory test on exactly what they were, I would fail that test, but I will tell you that they were changes across the board in many categories. And none of those changes caused me to think that the results of the cost study would change materially in relation to one class to the other.
Was there an accounting of the changes made between the direct filing and the stipulation?
I don't know what you mean when you ask.
Okay, let me rephrase that. Would you agree that the stipulation is a black box settlement?
In many respects, yes.
Thank you. Nothing further.
Any cross-examination from Ameren, Missouri?
Yes, just briefly, thank you. Mr. Brubaker, do you believe that the cost driver for distribution investments like poles, meters, and conductor to be total energy or timing of energy consumption?
No, it has relatively little, if anything, to do with energy consumption. It has to do with the demands placed on the system, which dictate the size of the cables, wires, and everything else, and the number of customers. served, which defines how extensive the network is. So it's basically only customers and demand. Energy flow has nothing to do with it from a cost of service perspective.
And just to clarify, you recommend the 4 NCP average and excess method for production allocation, correct?
Correct.
But you don't recommend that same allocation for distribution assets, correct?
Correct. They're driven by many different factors.
Okay, thank you. I just wanted to clarify that from your position statement, or your
Sure.
entity's position statement. Thank you.
Are there any commission questions for this witness? I hear none.
No questions, Judge. Thank you.
Thank you. I only have one question for you that I can think of, and it's really more of a clarifying question. You indicated that this was, that your adjustments were predicated on a 50% revenue neutral shift for the residential class, is that correct?
Yes, Judge, for all classes, to move 50% of where we are toward the goal of cost of service.
Okay, so a 50% revenue neutral shift across all classes.
Correct.
And if I understand, and you may not know, if I understand correctly, MECG's position is somewhat different, correct?
I believe it is, yes.
Do you know how it's
But,
different?
I think not, well, I'm not going to speak for Mr. Chris. He has a different approach to it. The concept of moving toward cost of service is the same, but he gets there in a different way.
Okay, thank you.
Thank you, Judge.
And you may step down. Oh, I'm sorry, I apologize. There is redirect. Thank you for stopping me. Any redirect from,
Judge, I think I have a question or two on recross after commission questions.
okay, I've just skipped over all kinds of stuff. All right. Are there any recross questions based upon bench questions? Go ahead, Mr. Williams.
Mr. Brubaker, in response to a commission question, you said that your recommendation is to move 50% to, I think it's probably class cost of service? correct?
Yes, yeah, toward class cost of service.
Whose class cost of service are you referring to, yours?
I was using Ameren's in that example. Which is very similar to mine, if I might subnote that.
Well, you are referring to a particular class cost
Yes,
of service,
correct.
are you not?
Correct.
Thank you. No further questions.
Any other recross based upon commission questions for this witness? Redirect?
Yes, thank you. Mr. Brubaker, you received some questions regarding the revenue settlement that the parties have proposed and that the commission will be considering. And I want to approach you with a document regarding that issue. He hands you a document which will become, we're going to see if we can get it admitted as 354. And I wonder if you could go ahead and describe this document and explain if you recognize that.
I'm going to ask you to go somewhere near a microphone so that, because this is being broadcast, I want everybody to be able to hear your question.
I would like to see more, Mr. Brubaker, if you could go ahead and describe the document, identify it and describe it for us.
Certainly, and this is the document that I prepared that enabled me to respond to Mr. Opitz's question. And overall, the objective is to move 50% of where we are now toward cost of service. The cost of service is based on Ameren, Missouri's cost of service study. So the first column on this schedule are the percentage increases to get the cost of service under Ameren's proposed rate increase, the 11.6% based on Ameren's cost of service study. And column 2 simply calculates the percentage increase for each class in relation to the overall 11.6 So that says that the residential class would require 1.6 times the average increase of 11.6% to get to cost of service. LPS, for example, would require a slight decrease in revenues to get to that point. So then in column 3, we calibrate those increases to recognize that the settlement increase is smaller than the overall increase that was proposed by scaling it down. So that's simply column 2, which is the relative percentage changes times the overall increase of roughly 5.14%. Then the final column, column 4, is where we determine how much the increase would be over current rates based on the settlement and based on the overall increase awarded, if it's 5.14%, to move 50% of the way toward cost of service from where we are now. So that's, the footnote explains the formula, where it's basically, for every class, it's the average increase plus 50% of the difference between the average increase and where the class is now, which is column 3. So that's how we get to 6.7 for the residential class. It's essentially 5.14%, the average, that's the average component. And then to get 50% of the way toward cost of service, we know from columns 3 and 4 that the increase to get the cost of service is 8.22% for the residential class versus the average of 5.14. So that difference times 50%, I don't mentally have that quite in my mind yet, but that difference times 50% added to the average of 5.14 gives you 8.22%. Or, yes. I'm sorry, it gives you column 4, which is 6.7%, the average plus half the difference. So if we did that twice, we'd be at cost of service. But we're only, because of the impact, that going all the way would be 8.22% for residential. Going halfway is 6.7% for residential. If we went all the way for LPS, it'd be a decrease of 1.7%. We generally don't recommend that when we have an overall increase. So 1.7% gets LPS halfway there. The same is true for all of the other individual customer classes.
Yeah, I don't have any further questions for Mr. Brubaker. I would like to ask that this exhibit be marked again as 354 and that it be admitted into the record.
Is there a 353 that I've missed?
That would be, well, let's see, 350. You're right, Judge, it's actually 353.
And what would you call this?
I would call it Brubaker Hearing Exhibit, Revenue Settlement, Proposed Spread.
Judge, I have a question related, I guess, kind of to what Mr. Williams asked earlier, and as Mr. Brubaker was explaining Exhibit 353, I didn't really, this has to have been based on an underlying CCOS, right?
Yeah, the percentage increases in column 1 are based on Ameren's filed
CCO.
cost of service study, and then I scaled it in column 2 to adjust for the difference between the stipulation revenue increase and the filed revenue request.
Okay.
Are there any objections to admitting Exhibit 353 onto the hearing record? I hear and see none. Exhibit 353, the revenue settlement spread, Brubaker's revenue settlement spread will be admitted onto the hearing record.
Thank you. I have no further questions.
And I believe that was redirect, correct? The next witness, and MIEC doesn't have any other witnesses.
No, thank you, Your Honor.
Next witness I have, and you may step down, Mr. Brubaker. I'm sorry, thank you. Next witness I have is Chris for MECG. However, as I indicated earlier, it is now 11:16, and due to a prior commissioner obligation, I wanted to take a break for lunch at this time, unless there are any objections from the parties, or in fact from the commission. So are there any objections to breaking for lunch at this time?
No objection, Your Honor, but I do want to note that Mr. Chris is, I guess, we've previously discussed about he would be available out of order tomorrow.
That's correct. That's right. I forgot we were going to take up Chris on Friday. So we'll be starting with staff witness Lang, I believe. So why don't we all come back at 12:30? That seems like an appropriate amount of time for lunch. So we'll recess until 12:30, and we will go off the record. When we left off, we had just finished MIEC's witness, and we were getting ready to start staff's witness. Witnesses, staff, you may call your first witness.
Yes, staff would call Sarah Lange to the stand, Judge.
Is it Lang or Lange?
Lange.
I apologize. Ms. Lange, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. And if you could state and spell your name for the record.
Sarah Lynn Cleathermes, LYNNE-KLIETHERMES, Lange, Lange.
Ms. Lange, by whom are you employed and in what capacity?
I'm employed by the staff of the Missouri Public Service Commission in the Tariff Rate Design Department. My current title is economist.
All right. Did you cause, excuse me, did you cause to be prepared and filed in this case direct testimony, rebuttal testimony, and surrebuttal testimony?
I did, as well as prepared information that was submitted via pleading.
That's correct. Yeah, that was the staff response to April 4th order, I believe. Is that what you're referring to?
Yes, that's my recollection of the name.
And going back to the testimony.
Sorry, did you say you prepared that?
I prepared the contents attached to the pleading.
The graphs attached to the pleading, Judge. Going back to the testimony, the direct testimony, just for the record, has been marked as Exhibit 136. Rebuttal testimony has been marked Exhibit 137. And surrebuttal testimony has been marked Exhibit 138. Now, Ms. Lange, do you have any corrections or changes you need to make to any of those pieces of testimony?
I do. Mr. Will's surrebuttal brought my attention to an error that I had in the language that I ultimately included in my rebuttal testimony. I had edited it to a point that it became inaccurate. So at page 55, lines 3 to 7, it currently reads, Ameren, Missouri requests increasing the customer charges for most residential customer rate plans to $13. Is this reasonable? Answer, no. Ameren, Missouri bases this request on finding the cost for rebuilding every inch of its distribution system at primary voltage, including every device, and then deciding each customer in each class should pay the same share of that total. That answer, beginning at line 5, should be corrected to state, no, Ameren, Missouri bases this request on approximating the costs for every inch of its distribution system at primary voltage, including every device, and then deciding each customer in each class should pay the same share of that total.
All right. That was in the rebuttal testimony?
Yes, at page 55.
All right. Are there any other corrections you need to make?
Not that I am aware of.
All right. Are the answers contained in each of those pieces of testimony true and correct to the best of your information, knowledge, and belief?
Yes.
And if I were to ask you the questions contained therein, would your answers be the same here today?
Yes.
Judge, I would offer Exhibits 136, the direct testimony of Sarah Lange, Exhibit 137, the rebuttal testimony, and Exhibit 138, the surrebuttal testimony, into the record.
Are there any objections to admitting Exhibits 136, 137, and 138 onto the hearing record? I see and hear none. Exhibits 136, 137, and 138 are admitted onto the hearing record.
Thank you. Now, Judge, based on our discussion this morning, it was my understanding that you were going to have questions for Ms. Lange on the staff response to April 4th order regarding load data, primarily on the attachments to that filing, and that we were at that time going to offer it into the evidentiary record. Is that still the plan? Or do you want me to go ahead and offer it, I guess, is my question.
I will leave that to you.
Let me go ahead and offer it. I think I'm up to Exhibit 182. Ms. Lange, you said you prepared the graphs which are attached to the staff response to April 4th order regarding load data in this case?
Yes, and to be clear, I prepared those graphs based on Ameren, Missouri's load research data that was provided as a direct work paper, which I did the requested calculations that were in the commission's order directing a filing, and then I reduced that information to the graphs that were presented.
And going back to what information from Ameren is it based on?
It is based on the hourly load research results for the indicated period, and I will defer now to what is on there. I forget if it was test year or test year is updated at the generation voltage at the class levels indicated.
Okay. Judge, I would go ahead and offer Exhibit 182 or whatever I said. I think it's 182.
Any objections to admitting Exhibit 182 onto the hearing record?
Judge, that was also pre-filed, obviously not as testimony, but it is filed in EFIS, so I don't have extra copies, but it's there electronically.
Okay, and I have a copy on me. Has everybody had an opportunity to see those graphs?
Yeah, it was filed over a week ago, so it was served on all parties at that time.
And just for information on this record, this load data was requested by the commission that thought it was critical to any evaluation of class cost of service. So with that in mind, if I didn't say it, Exhibit 182 is admitted onto the hearing record.
Thank you, Judge. I would tender Ms. Lange for cross-examination.
And in order of cross, as I have it, I have public counsel.
Thank you. Ms. Lange, what's staff's primary issue with Ameren, Missouri's class cost of service study?
Can I see clarity on if you're asking biggest dollar value difference or biggest concern?
Concern.
There are two main ones. I guess if I have to pick one, it's the way that the mismatch between the treatment of low to no cost generating resources cost and low to no cost generating resource revenue. That's the biggest. That's the most glaring. I think any objective reviewer would say, "Oh, geez, that doesn't make sense." Issue. There are of course other issues, but that's the one I just can't wrap my head around how they chose to deal with it.
What's the secondary concern?
So failing to make, I guess, acting on outdated data in the distribution system, when we see things that just clearly don't make sense, not taking a moment to think, why are we allocating, if I were Mr. Hickman and I found that 2% of overhead conductors are secondary, but I believed that 10% of poles are secondary, I think I would have to stop and say one of those numbers has to be wrong, and they could both be wrong. But I think that just failing to do that sort of reasonableness check is a big issue, as well as not making similar allocations for customers served above secondary as are done for customers served at secondary. I mean, the literal differences are all outlined in my rebuttal testimony, but those are the ones that, I just think plainly are problematic, as well as not accounting for the demand carrying capacity of the primary distribution plant. That's just a shortcoming you can't overcome.
Can I ask you to clarify that? Because I just don't understand that. And I mean, I don't understand it at all.
The primary issue?
Yeah, what you said your major concern was in regard to distribution.
Okay, so the issue with the minimum distribution plant, and this is something we only learned in 2019. In 2019, we became aware that when Ameren does a minimum plant study of its distribution system, it is considering conductors that operate at 12.4 kV. I think I'm getting my units right there. I always have to stop and think of my triangle, so I apologize if I attached the wrong unit there. But they are saying that the primary distribution system, which is as you drive along the highway, you know, the wires that you see on a pole that are going, you know, well, I'm trying to, let me break this down as easy as I can. The large primary customers and the small primary customers are typically served at primary voltages. So if you think of the sort of big customer that would be served by those classes, that is a primary voltage customer, okay? So do you have a rough idea in your head of that size? So what we learned in 2019 through some DR responses is that when Ameren says we're allocating out the cost of the distribution system existing, they are doing that at the cost of the poles and wires you would use to serve one of those customers. And now you use those poles and wires for a lot of other things, to be sure. But when, in the past, when Ameren represented that they had done a minimum size study, we thought that meant minimum size study. And a minimum size study is a customer served at, you know, 110, 220 volts. It's a household, it's a garage, it's a customer. When we learned that they were actually using, you know, these very large components that you would expect to serve thousands of those customers, that's when we said, we can't do this way. This doesn't make sense anymore. And so that's that issue. It is, how do we take this system that is designed and built not to serve a single customer, not to serve a single household, a single small business, but is instead designed to be a bulk electric transfer system. How do we say what part of that should be billed to every customer by virtue of that customer existing? That's when we started asking questions.
Thank you for that explanation. I'm sorry to interrupt, Mr. Williams.
No problem. Does that concern exist in the Bandus study that Ameren, Missouri relied on for doing its class cost of service study in this case?
So the Vanda study purports to break down for accounts 364, 365, 366, and 367. The Vanda study isolated from Mr. Hickman's work paper. You know, as those results were presented, pasted in to Mr. Hickman's work paper.
May I interrupt you
Sure.
first before you go on? What are those accounts related to?
I'm sorry, 364 is distribution poles, towers, fixtures. 365 is distribution overhead conductor. 366 is distribution underground conduit. 367 is underground conductors. And I should say 365 and 367 are conductors and devices.
Thank you. If you'd like to continue your
I'll try.
response to the prior question.
So when we talk about the Vanda study, you know, not only is it not filed in the case, what is in Mr. Hickman's main CCOS work paper is different than how Mr. Hickman implemented that study or implemented those results in apportioning out the pieces or those how he apportioned out those accounts into those different voltage buckets. So if you go back to the Vanda study that's provided in the work paper that he doesn't, you know, that he then scales these percents, I discussed that in my rebuttal testimony, but it says, you know, as of 2009, assets adjusted for 1994 data, you know, I'll make up a number. We believe that 5% of the assets in account 365 are operating at secondary, and 40% of them are operating at primary, and the rest of them are operating at HV. And again, I'm making up the numbers there, but hopefully that answers your question, provides some clarity on what the Vanda study does.
Thank you.
Any cross-examination from MIEC? Any cross-examination from MECG? Sierra Club, NAACP, MCU?
No questions, Your Honor.
Renew Missouri?
No questions. Thank you, Judge.
CCMO is not here. Ameren?
Yes, thank you, Your Honor. Ms. Lange, if you would please turn to your rebuttal testimony, and I am specifically going to ask about page 20 of that.
I'm there.
Great. So at line 16, that table that you have there, that is described in your testimony as showing the advance per customer value across the different customer classes, right? For example, if we look at
I believe it's customer advances and deposits. It is whatever it was when Mr. Hickman labeled it in his work paper.
So just to clarify, at line 14, where it describes that the advance per customer value as indicated below, and then you have your table, that should be deposits as well as advances?
It is whatever Mr. Hickman included in his table. I think the sentence before that has the full term. I'll defer to whichever of those is the more accurate, as I believe I indicated in my deposition.
Thank you. Those are all my questions, Your Honor, at this time.
Thank you. Any commission questions? I hear none. I have.
No questions, Judge.
Thank you, Commissioner Holzman. Before we delve into other stuff, what you just explained to me about using customer infrastructure not designed under the minimum use to serve one customer, but as you said, serve thousands. So it sounds like the study does kind of an overreach there.
If what you're trying to do is find the minimum system that would exist if all customers were the smallest size a customer reasonably would be, which I think is what the minimum distribution system sounds like it's trying to do. Using a primary voltage is not a reasonable place to start. So I guess it's an overreach in the extent that it's not what a rational utility would ever do, and it's not a reasonable exercise an analyst would take to try to estimate something in lieu of, sometimes in rate making we have to say, we know this isn't how you would do it, but we're going to make some assumptions to come up with what a relative cost ought to be. It's not a reasonable way to do either of those things.
And that leads me to two additional questions. What would you cite to as a source for the idea that it isn't unreasonable to use that primary voltage?
I believe in my rebuttal testimony, I went into quite some detail, pulling from the NARUC manual, that it's not reasonable. I would say that more recent publications, such as the RAP manual, the Regulatory Assistance Project Manual, say that minimum distribution system is a bad idea to begin with, that it's not a question of how you do it, it's a question of it's just not an appropriate thing to do. And In fact, that's been the trend. Missouri has moved away from minimum distribution, certainly for customer charges. We've been using the basic customer approach for quite a while now in Missouri, and there's really not a reason to continue that artifact of that in distribution allocation either.
And why is the minimum distribution study inappropriate?
So why is it an inappropriate study to do, or why is the way that Ameren did it inappropriate?
The first.
It's an inappropriate study to do if you don't have the data to do it reasonably. So if you think about it, the minimum distribution study is asking, if we were just running extension cords from everybody's, from all of our power plants to all of our end-use customers, what would the cost of that be? That's effectively what, and if you want to take it in specific utility terms, if we were running the smallest pole we run and the smallest conductor we run, what would that cost be?
And that would be what Mr. Wills was talking about when he indicated the system minus demand?
Well, except the problem with that is, sort of, but what Mr. Wills, the way his testimony was presented in the context of the Ameren study was incredibly misleading. So, as we just said, that demand that would be served by what Ameren used as the minimum system far exceeds what 90% of the customers on the system can physically take. If you ran a primary voltage line into a Subway restaurant, you'd have a fire. That's so what NARUC talks about is if you're going to do a minimum distribution system, you have to account for the demand that is served by the minimum distribution system. And so when it says that, what it's assuming is that you're using effectively what a service line would be for a residential or an SGS customer, and a small residential or SGS customer at that, because that is the smallest level of infrastructure that you can use to serve a customer's load. But what Ameren does is, because services are recorded to one account and overhead conductors and devices are recorded to a different account, which that's fine, but what it does because of that is it sizes its minimum at far above the minimum. So in other words, adjusting for demand, you would end up with a negative number. You would.
And one of staff's complaints about the way Ameren did their class cost of service study was that it didn't comply with the NARUC manual that they say authorizes it, or promotes it, should I say. Is that the major reason that staff believes that it doesn't comply with the NARUC manual?
There are multiple failures. And to be clear, there's no statute or other requirement that for a distribution study you're in strict accordance with the NARUC manual. But what we did is we said, is what Ameren is doing making sense? And the answer was no. And it was, well, is there some other entity out there that is in the NARUC manual that says it makes sense? And the answer to that was no. If you'll give me a moment, I can give you a more specific. Looks like it's at page 34 of my rebuttal testimony, where I kind of walk through where NARUC has, the manual contains specific instructions on how you would apply, these factors when you're doing a minimum distribution system study that Ameren didn't do. And the reason I had to go back to NARUC instead of using something more recent like RAP is the RAP manual simply says don't do a minimum distribution study.
Has staff attempted to quantify what I'm, for lack of better terminology, the degree of overreach?
So yes. So we have, what I've done in my rebuttal testimony at page 52. So I say you can't fix everything Ameren's done wrong, essentially. But if you address the ones that we can address, that you'll end up with these CCOS results. And so at page 52, at line 10, I provide a chart where I have taken the Ameren results and adjusted the production and distribution allocators to correct for those examples that I lay out in my testimony. And under those results, you get, if you look at the bottom line of that table, it's all on row 10, but this is right next to the number 10. It'll say under, paren, over, contribution, paren staff percent. So this is taking the results and correcting them for those very significant issues. And when we do that, the classes all fall within that 10% band that would indicate to staff that results are as close as we can expect in a CCOS study, and you don't tinker with results that are within 10% of correct, has been staff's policy for at least the last 30 years.
Let's get away from Ameren's class cost of service study. Now Ameren's termed staff's approach as novel. And I'm going to ask you a question that I've asked several of the other witnesses, which is, what is modern rate design?
I think that in the year 2023, modern rate design is actually getting around to doing what we've been talking about in detail since 2017 and conceptually for a long time before that. And that was a somewhat vague answer while I try to find the site back for where I tried to lay this out in my testimony. So we had a EW case, a working docket case to deal with distributed generation a number of years ago. And in that filing, staff laid out its recommendation of the steps to take to modernize rate structures and rate design. I'm hoping it is at page 60 of my rebuttal testimony based on the table of contents I just looked at. But essentially, it is the concept of you have across classes, you end up with customer charges that collect customer costs, facilities charges that collect facilities costs, and then what you probably end up doing is having these may be combined on a bill, these may be combined on a tariff, but where you're studying over time energy costs and demand costs and using those to come up with a time-based rate. And it is not at page 60 as I had hoped. But that's the foundation of it. Is those are the costs. Those are the rate elements that you're trying to cost out across classes.
But you believe that's in your rebuttal testimony?
That's what I'm checking, if it's in my rebuttal or my surrebuttal. It was in this EW case, quite a while ago, but I'm looking, where am I specific? Sorry, I had some, when I printed it, put things, I told it to do short edge instead of long edge or long edge instead of short edge, and I'm paying the price. Page 38 of my surrebuttal. Again, I apologize. I have a lot of papers. It'd be silly if I'd put it in direct, but I'm wondering if that's what I did.
The section on rate modernization on page 38 of the survey.
Yeah, that wasn't it. That's what I thought was it. Oh, hi. I apologize, Judge. I'm confident I can provide an exact citation of that, but what I just described is essentially what those elements are.
But it is in your testimony in
It
this
is,
case?
I am confident it's in my testimony in this case. I am just struggling to find it right now.
Okay, well, let's move on. Would you say that what staff's attempting to do in this case is rate modernization?
Staff is attempting two things. We're attempting to get the information that we need to develop those sorts of rates, and we're also, through the TOU overlay for the CNI customers, attempting to get that information about how those rates might impact them into the hands of customers. So I think what we're doing in this case is we're laying the groundwork that's going to be needed to make good choices as time goes on.
Now, bear with me just a second. In your direct testimony, you're asked, for the purpose of this case, should the relationship between these elements within the rate schedule be maintained? Yes, the inclusion of, and to get to the part that kind of stuck out to me. For the current non-TOU, SGS, LGS, SPS, and LPS rate schedules, staff recommends minimization of interclass revenue responsibility change for the non-residential, non-lighting classes in order to mitigate unexpected bill volatility as staff's recommended time of use overlay is introduced. And I'm kind of left wondering why would we do something that is going to introduce volatility into the business classes?
We are not intending to introduce volatility. And if I could maybe clarify something my counsel said in opening statement.
Please.
So in opening statement, we indicated that given the revenue requirement stipulation that was agreed to, that we are not opposed in this case to going with an equal percent across the board increase to the rate class revenue responsibility. And that would be coupled with introduction of this overlay. So we feel that getting this time of use overlay out there and onto customer bills, getting them that information about their usage, getting staff and all of the parties relevant billing determinant information, we feel like that can take a priority over bringing these relatively minor differences in class cost of service results. Again, bearing in mind, CCOS, if you think it's accurate within 10%, you're wrong. That we think that prioritizing getting that CCOS overlay out there makes a lot more sense than tinkering with class revenue responsibility or with the rate design recommendations that Mr. Chris has brought out.
Thank you. If you're trying to mitigate unexpected bill volatility, where would that volatility come from then?
Could you direct me to where you were reading that from?
Page 39 of
Page
your direct
39.
testimony,
Okay, I just want to make sure that I didn't.
starting at line 9.
So we're recommending minimizing revenue responsibility changes to mitigate unexpected bill volatility. So in other words, if you just followed CCOS the way that Mr. Brubaker and others say, of saying we take our CCOS results and we apply X% of what we think the change is, I don't think this is the case to do that. I think that would introduce too much bill volatility. And so instead of trying to go all the way to CCOS results, I'm saying, at this time, I said we make some movement, but we focus on getting this time of use information out there. And at this point, given the overall given the overall revenue requirement increase, I'm saying, fine, we'll just kick that out the window and we'll focus on rate design and getting this overlay out there. So I apologize if my answer was both lengthy and unclear, either in written or spoken form.
No, it is clarifying to me on a lot of things. And if I misunderstand this, please correct me. My understanding from staff's approach in this case, in their class cost of service study, this is an attempt to more closely align the infrastructure, and the utility infrastructure to the class that is most using that infrastructure. Is that correct?
It is correct, but it's important to understand that this is only an interim step. And if I may explain what I mean by that.
Please.
So, for the last 130 years, class cost of service has been taking monthly bill data at best and handwritten records in many cases, and trying to reduce that without a spreadsheet, without computers, into a reasonable bill or into a reasonable rate elements to charge customers. So when analysts talk about customer-related, demand-related, energy-related cost types, that's silly. No cost that we allocate is purely any one of those, other than maybe meters, and any analyst who will tell you otherwise is wrong. Many are a mix, many are none of those. So what staff is wanting to do is to get the data to do a ground-up study, to say what is the cost of serving a customer with these characteristics, regardless of what rate schedule they're served under. So we want to, not in this case, but what we hope to do through rate modernization and through future cases as that data becomes available, is to look at what are the actual costs of serving customers of a given size, a given voltage, a given, various sets of characteristics that could be considered in a good workshop. What are those characteristics, and how do we build those into revenue responsibility? So to say, these are the classes, let's come up with revenue requirements for each classes, and then let's come up with rate elements to recover those within the classes, is really where we're missing some of the similarities and differences that exist across classes, because none of the classes are as homogeneous as a CCOS makes them appear to be. And that's a big driver of the weighted energy allocator used for distribution that has been very misrepresented by witnesses in this case.
You indicated that staff has been trying to get information to do this. Is this the information that Ameren says they either don't have or can't get?
To a large extent. And I think that this is something that would appropriately be considered in a rate modernization workshop. I think that if we use that workshop as an opportunity to involve the commission in the calculation of a few CCOS studies, because in my opinion, the best way to do a CCOS study is to do 3 or 4 of them and see where you have consensus and see where you have divergence, and use that to inform your costings. I think that a good collaborative approach in a workshop environment that can involve commission input. But what we've really struggled with Ameren, and to be blunt, with some other utilities as well, is we don't know the universe of what information exists. So if we ask a general data request, we're told, well, we don't have that. Ask something more specific. And then when we're told, well, here's a more specific data request, we're told, well, that's too specific. That's not what you really want. I think that a workshop environment with an open and robust exchange of information is a good way to ferret this out and get results that are reasonable from any perspective.
And that would be the supposed upcoming rate modernization?
I think that is limited to non-residential rate structure. I would suggest it should be broadened to all rate structures and all rate classes.
Okay. I want to step back to something you said there that kind of caught me. You said that you like the idea of doing several class cost of service studies and seeing where there's consensus. Is there any areas where staff's class cost of service and Ameren's class cost of service are in consensus?
Well, so the two studies in this case are starting with different revenue requirements, which is an area that would be cured if we're starting with a new CCOS and a new docket. But just to maybe understand what may be a misconception, in a class cost of service study for a vertically integrated utility, you allocate distribution costs, you allocate production costs and energy costs and revenues, and you allocate sometimes some billing and some class-specific customer costs, and then everything else is just grossed up off of those costs. So to say that we allocated two different things differently, honestly, in the range of CCOS studies, our results aren't that different. You know, we're following the same trend of what classes are overall higher, what classes are overall lower. That said, staff's is far more in line with what Mr. Hickman has presented as averages than Ameren's is. But outside of those two areas, you know, those are really the only two areas where decisions are made about how to allocate. At this time, everything else is virtually grossed up. And I would encourage you to take a look at page 9 of my direct testimony. So at page 9 of class costs of service direct testimony, I have a chart, functionalized Ameren, Missouri cost of service.
I see it. It's the above and below line.
Yes. And so if you look at production, there's a lot of costs there, but there's also, that's the above the line, but there's also a lot of offsetting revenues. That's the green below the line. So transmission, I did overlook transmission. What I said, at this time, staff and the company both allocate that on a 12 CP. That is consistent in how we allocate that. And then there's distribution. And those are big buckets of cost, to be sure. But if you look at this other in general, that's a non-trivial amount of cost that gets allocated out. And that is simply done by grossing up how everything else was allocated. And so, you know, when we have little disagreements on billions of dollars, it appears as a very big disagreement.
The class cost of service approach that staff is doing this time, is this the first time that staff has attempted to do a class cost of service study this way?
So every case, we're responsive to the data available in that case. For production, what we're doing here is very, very similar to what we did in the Empire case, which we use the 100 highest hours to allocate the non-variable costs, or in Empire, we use the 100 highest hours approach for the portion of the production capacity that we used the RA hours approach in this case. So under NARUC, that falls under the same methodology identification. We're doing the same thing with renewable and low variable cost resources in this case that we've done in at least the last Evergy cases and the last Empire cases. It may have been before that. And really all of this is an outgrowth of the detailed BIP method that we've been doing since about 2014. So, you know, for production, no, this isn't, you know, is it literally the same exact allocation? No, but if you go back to what staff was doing in 1985, which is the last time TOU made its way up to the the last time that cost allocation made its way up to the appellate courts, what we're doing in this case looks a heck of a lot like the staff TOU That's what it was called in that case, the TOU method. Capacity utilization method is another name for it. We're not breaking new ground, unfortunately, to the extent that it's represented. We are on the production side. On the distribution side, I can say without hyperbole, having been involved either as an attorney or a staff person in staff CCOSs since about 2007, we're doing now what we thought we were doing in 2007. We've learned things since then, that the information we're getting from Ameren isn't what we thought it was, and so we're responding to that. Now, there are two exceptions to that. One of those is in treatment of distribution generation. So what I mean by that is community solar and landfill gas is generation that's cited on the distribution system. Were that recorded in a production plan account, the transformers and switches associated with that generation would be recorded in the account with it. Because it is not, it's recorded in a mass asset account. We have done a separate allocation to deal with that. And, you know, I said two things, but I think really that's the only thing that we're doing different that isn't what we thought we were doing historically. We've learned some things about contents of service accounts. We've learned some things about the Vanda study. We've learned some things about what is in a minimum study as Ameren represents it.
Given what you've said and what I've looked at, just to give you kind of an overview of what I see, it looks like staff is requesting a lot of what Ameren's termed granular information with the idea of being able to more closely align customer, what did you call it, capacity utilization?
No, so capacity utilization is the name of a historic production allocation study. This is the customer-specific, what I think you're referring to is what has been called the customer-specific infrastructure issue.
Thank you. That is a much better term, and I think I can remember that. The customer-specific infrastructure. Is that correct? So I'm looking at this, and it looks like staff is requesting all this granular information that they don't have in order to better do this. And it looks like you've indicated that there, on the other hand, here you have recently discovered that some assumptions that were staff made about how Ameren was conducting its study were in fact wrong. And so this appears to be somewhat of a response to that, to kind of rein it in a little bit. But the problem, the thing I'm having difficulty getting over at this point is you called it an intermediate step, and it looks to me more like fumbling in a direction in the dark without some necessary data, kind of knowing which direction you're going, but not really having the data to do this. So I guess the question I'm left with from that overview is why would we do this now? Why wouldn't we do this? Why wouldn't the commission order Ameren to give you the data you want and then do this next rate case? Why are we doing it this rate case?
So to be blunt, while I disagree with fumbling, I think we've done a little better than fumbling.
Not the best choice of words,
Sure.
I'll give you that, but you understood what I meant.
I do, and I don't entirely object to that. I would submit that the rate, what I would suggest, and I haven't discussed this with my counsel, so I'll be prepared to be yelled at. You could order what we've asked for under the data retention and hold it in abeyance, if you will, and say, Ameren, file this information by the next rate case unless you adequately address these concerns through the fair exchange of information in the rate modernization workshop. And I have, you know, this is nothing new and groundbreaking, but I have, you know, the things that I think are bare minimums that we would need to facilitate that workshop. And I think that that's the sort of information I believe it's largely contained in my positions, in the staff position statements, and it's all outlined in my testimony, but I think it's maybe in some more user-friendly language here. But I think that if the commission,
When you say here, what are you referring to?
I'm referring to a thing I printed out over lunch that my counsel hasn't looked at. But I think that if something like this were ordered for Ameren to have available at the rate modernization workshop, that works for me. And if there are things in here that Ameren says, well, this isn't really what you want, here's what you want instead, we love hearing that kind of thing. You know, we don't know what we don't know, so we've had to, I liken it to if you walk into a McDonald's and you have to order by value meal number, but there's no menu. You know, so I say, you know, hey, Mr. Hickman, give me a number 5. Oh, you don't want number 5. Okay, well then can I have a number 4? No number 4s. You know, well tell me what you have and I can work with you on seeing what meets our needs. So again, this has not been reviewed by my counsel, so my apologies, Mr. Keevil. But this is what I would view as the bare minimum that we would need to have a reasonable exploration of how these costs are allocated to customers and to classes.
Thank you. Well, unfortunately, you're on the witness stand, so what would that minimum information be?
I think you could, putting my staff counsel hat from a decade ago back on, I think if you'd like to, you could instruct this to be marked as an exhibit, and I doubt that my counsel would object to its admission.
I don't think anybody's seen it yet, though. That's the difficulty there, and I want everybody
Sure.
to have an opportunity to look at it before we do that.
Well, I can represent, I can describe it in a way that I think will, so I could read it in if you'd like, but this is, I believe the cost by account data request that I've submitted to Ameren, it's the table from that. And it is, the second page of this is, I think, almost verbatim from my position statement. It just didn't have times in it. And so this has language like beginning immediately and in its next rate case and that sort of thing. But to be clear, for what I'm suggesting, the purpose of this would be in lieu of the beginning immediately and in the next rate case language, it would be this is what we would want to see to facilitate a rate modernization workshop.
Well, I'll leave it to your counsel if they want to try and enter it in. I'm not going to order it because I think that would be inappropriate. But if you do want to just tell me what the information is you believe you need, we can start there.
So sure, and again, this is going to sound more exhaustive than it is.
And this is the minimal information, correct?
Yes. And to be clear, this is, I think it would be good to have an embedded cost view on these, and I think it would be good to have a marginal cost view on these. So what I'm describing is a table. And so going across the top, we have a row that is, or a column that is a type of information, and then we have account 360, 361, 362, all the way through 370. And so the intent would be for each of these accounts, what would Ameren typically record for the cost of a mile of HV overhead line? What would Ameren typically record for the cost of a mile of HV underground line? And that what would Ameren record will be the same throughout all of these. Cost of a mile of primary overhead line, cost of a mile of primary underground line, cost of a mile for secondary overhead line for approximate 270 to 600 volt service, 3-phase. Cost of a mile of secondary underground line for approximate 270 to 600 volt service. Oh, sorry, that one was overhead and this one is underground, 3-phase. Each of those again, but for single phase. Each of those again at 3-phase, but for 110 to 240 volt service overhead. Each of those again, but for 110, 240 volt service, single phase, underground and overhead, single phase. Cost of adding a customer served overhead at 120, 208 volts. I don't think that should have said 208, I think that should say 240 volts. Cost of adding a customer served overhead at 120, 240 volts. Cost of adding a customer served overhead at 277, 480 volts. Cost of adding a customer served overhead at 4 kV. Cost of adding a customer served overhead at 12 kV. Cost of adding a customer served overhead at 13.2 kV. Cost of adding a customer served overhead at 13.8 kV. Cost of adding a customer served overhead at 25 kV. And then each of those again, but for underground.
Thank you.
And then the second page of that, I won't read it because that one is from the position statement, but it is, I think it is in the position statement as here's what you need for a rate modernization workshop.
Judge, I'm somewhat at a loss here, but let me ask, if I could ask Ms. Lange a question or two, and then I offer to introduce this as an exhibit, just to make things clear, because I think that's going to be a lot clearer than having it read in the transcript, especially on that, if it's taken from the position statements anyway.
Any objections to Mr. Keeble asking a few questions?
Well, I guess it can't wait till redirect?
I think it would be fine for it to wait to redirect. I'll remind you when we get there. Okay, let's move on to a different subject for a bit. On page 52 of your rebuttal testimony, you indicate there's a table, and on lines 9 to 10,
If you'll give me one moment, I'm trying to find my rebuttal. I'm sorry. Okay, I'm sorry, what page?
52.
Yeah.
You indicate with the table on lines 9 and 10 that the reduction in return based on staff's revenue requirement reduces the class contribution percentage to where staff, as an alternative, would agree that an equal percentage increases to all the classes other than customer-owned lining. Is that correct?
I am not seeing that on my rebuttal at page 52, but I think that that is an accurate statement.
I'm sorry if I have the page incorrect. Let me see if I can find that.
Perhaps if you just ask your next question, I may be able to answer it without the reference.
Now, the stipulation as put forth by the party agrees to a $140 million revenue requirement. And I guess my question, and you may need the table for this, is how would it change the percentages on line and 10 of that table? So we may need to find the table anyway.
Okay, so the table, yes, that is the table being referred to there. Just the language I didn't catch.
And I'm picking up some background noise from the WebEx. If somebody's got, is not muted, they might want to mute.
So unfortunately, you cannot adjust the results of a CCOS in that matter with any expectation of accuracy. The premise of a CCOS is that rate base and expenses are allocated differently to classes. So you can't just sort of lob off a percent similar to the exercise Mr. Brubaker attempted to achieve reasonable results. It's just not how you can use percentages.
Now, you had indicated you did think it was correct that staff would agree to an equal percentage increase in all classes other than customer-owned lining, right?
Yes.
Is that still staff's position? as an alternative?
So it's staff's position so that we can ensure minimization of customer volatility for our recommended C&I rate structures. You know, depending on the robustness of the rate modernization docket, it might not be a bad idea, I guess, in general, but really we're recommending that in order to take away that concern about customers being impacted by the time of use overlay for C&I customers.
So is that a yes?
I'm sorry, I don't mean to be a pain. Could you restate the exact
With the exception
question?
of customer lighting,
Oh.
is staff still okay with an equal percentage increase?
Yes.
Now, you were here for, there were some bench questions for Mr. Hickman on the 4 NCP method. Do you remember those?
Yes.
Do you agree with how Mr. Hickman answered those questions?
A lot of discussion has happened since then. If the premise is, do I think that the A&E 4 NCP is a reasonable allocator to use for Ameren, Missouri's production fleet in this case, the answer is no, I don't.
I think I asked 5 questions, and one was, has Ameren used the 4 NCP method for the last decade? Does the 4 NCP methodology include any consideration for renewable generation plant characteristics that are different from baseload generation? Does the 4 NCP methodology include any considerations or use of AMI data that can differentiate between rate class energy consumptions during the hours of the day? And that appears to be my last question on 4 NCP.
Yes, and those are actually really good questions. And in general, I think I disagree with Mr. Hickman's answers to those. So I would say that calling the A&E 4 NCP a traditional method is kind of like calling the Dave Matthews Band a traditional band. They were popular in the 90s, and you got a couple people who are really loyal following right now, but that doesn't mean it's all that's on the radio. Missouri's never really been an A&E state. I agree with Mr. Mark's characterization that some groups come forward with those, but it's important to understand that you do get very different results in various cases with a A&E 4 NCP, an A&E 4 CP, an A&E 1 CP, an A&E 12 NCP. I mean, there are all sorts of different flavors of A&E studies, and various ones have been used. Various BIP methods, base intermediate peak methods, have been used. The average and peak, or the peak and average, depending on who you're talking to, has been commonly thrown around. But going back to 1985, I can tell you that the Commission has never affirmatively said in an Ameren order, golly gee, we think this A&E study was great. There have been a couple studies where they've said, well, this A&P study didn't make sense, so we're going to use the only thing that's left. But I am not aware of an Ameren case for the Commission where they have said, we think this is the right way to do it. There have been cases, I believe 3 at most, since 1985. So in 2010-0036, the Commission threw out a couple of studies and was left with A&E studies. In 85, ER-85-17, ER-85-160, the Commission approved the staff TOU method and rejected the coincidental peak and peak responsibility methods. The peak responsibility method is another name for the A&E that preceded the publication of the NARIC manual. And then in this most recent case, the Commission made the statement in looking at CCOS that these differences would only be relevant if the Commission were relying on these differences in making its decision about how to allocate the rate increase to the rate classes, which it didn't. So I think that part of the shortcomings of the A&E, and some of these apply to CCOS studies in general in the area of production allocation, But the A&E, with the way that we get load research from Ameren, does a really terrible job of dealing with solar and net metering. You're effectively going to be billing classes that are contributing generation for full production. You're not giving them credit for that generation they're providing. It's pretty terrible in dealing with demand response events that have been called through MIA or through other demand response activities. It's at odds with what the utilities have been telling us about why they're adding generation capacity. And specifically here, if you go to the Ameren Boomtown case, we had Mr. Aurora testify that if you'd like me to read, I can read. If you'd like me to paraphrase, I can paraphrase.
Paraphrase.
In Boomtown, Mr. Aurora testified that Ameren needs energy as well as capacity as well as ancillary services, and the paradigm of planning has shifted, and so they're now looking at energy and capacity separately and ancillary services separately. And in general, it just makes more sense to look at how the system is both operating today and how we got to the position we're in. And that's where across the utilities in Missouri, we've gotten to the current fleets in very different ways. And Ameren is a unique utility in that respect.
To change subjects again, I've asked a couple of witnesses about paragraph 8 of the stipulation and agreement in case ET 2018-0132 regarding whether Ameren, Missouri has complied with that provision of that stipulation and agreement. And I have, Mr. Wills indicated that Ameren had and that they had retained that data. I'm going to ask you the same question. Has Ameren complied with that, that part of the stipulation?
No, what they were able to provide to us in response to 591 does not comply with that stipulation, and it certainly isn't in a form that it's been discussed with Ameren or with OPC and staff, even if it was the appropriate data.
And why is it not the appropriate data?
Well, what we can tell of what it provides is that it does not clarify what the contribution actually was, whether that contribution, I guess, one, it's in a bunch of separate pieces that you have to kind of mix and match across data sets to fit together. But from what we can tell, the dollar values presented, it's unclear what those dollar values are representative of. And it certainly isn't giving us any sense of the total dollar value and the portion actually contributed by the customer, how those two relate to each other. Because if you go back to that ET case, this data was supposed to enable us to audit whether or not their line extensions costing were making sense. And if you only have $1 value ever, you really can't evaluate a heck of a lot with that.
So it was insufficient for its purpose.
Yes.
On page 17 of your, I'm sorry, on page 14 of your direct testimony at line 17, just a clarification question. Should account 346 actually be account 364 poles, towers, and fixtures?
Almost certainly, yes.
So that would be a correction?
Yes, my apologies.
I asked Dr. Mark that disregarding what the actual proposed customer charge is, what staff position on having different customer charges for different residential rate plans, as is being proposed by Ameren in this case?
As it's being proposed by Ameren in this case, staff is deeply concerned that Ameren will market the rate plan with the highest bill risk. That is, bill risk is hyphenated, not highest bill hyphenated. We're concerned that customers who are least equipped to deal with high bills will be marketed to the most risky plans. And that's based on Ameren statements that, you know, if customers are concerned, and this was in Ameren, this was in Steve Will's testimony, and I also heard him say it at local public hearings, that if customers are concerned about paying $13 a month, they should just hop on Ultimate Saver, or they should consider hopping on Ultimate Saver.
Objection. I believe that's hearsay, and the record from the transcript, or the transcript from the local public hearing, will speak for itself.
I'll sustain that.
Now, to be clear, that was in the question and answer session, so it would not be, but I accept that. If you look at my rebuttal,
Well, let me ask real quick. You said that there was a danger of putting customers in the riskiest time of use plans.
Yes.
What makes a time of use plan riskier, one time of use plan riskier than another?
So specifically, the Ultimate Saver plan has a demand charge component, and that is effectively an adder to the customer charge as far as an unavoidable amount once you've used some usage goes. And that's what I was hoping to find.
Is that the $25 plan, or is that the higher? I can't remember what the actual numbers
It's
for
the
plan.
$8 plan.
That's the $8
Or the,
plan.
I'm sorry, is it, now I'm misspeaking. I want to make sure I've got the right dollar value. It's the plan that they're proposing to have the lowest customer charge.
Okay.
But from the customers, I reviewed 100 residential customers to try to see, you know, if you were on this, what would happen to your bill? And what I found was that it was a very risky, from a bill perspective, proposition for customers to go on that plan. So if a customer is worried about being able to spend $13 a month, this is not a good plan for them, is the short answer there. And the longer answer is presented in my testimony, rebuttal page 55.
Okay, thank you. Can you open your rebuttal to page 6? There's a graph there. And that graph shows the average rate per kilowatt hour under the Ultimate Saver, Smart Saver, and Anytime rates.
Yes.
Would you explain that graph to me?
Oh, this is actually the section of testimony I was just trying to direct you towards. So wherever I said it was, that's not where it is. It is page 4 of my rebuttal. Sure. So what this is showing is
4 or 6?
the discussion starts on page 4, but it continues.
And the graph's on page 6.
The graph is on page 6. So what this is I got 100 customer hourly usages from Ameren for residential customers, and I plotted out what their bill would be on a per kWh basis and plotted it on this graph, and that's what that is. And so you see the anytime flat rate is that sort of the gray sort of trend towards the middle. And then, again, this is a random placement of customers on this rate, so this isn't customer self-selecting. But you'll see that the blue, there are some way above, there are some way below. The orange, there are some above, there are some below. And so that's what we're talking about in terms of bill risk. So not necessarily, this is not necessarily a total random sample across the customer classes, but this is removing the self-selection that does occur in Ameren's distribution of these plans.
And just to clarify, because I want to, this is 100 dots, right?
Yes.
what this is not showing the same 100 customers' bills under the 3 rate plans.
Oh, I apologize. This is 300 dots. Yes.
Okay, that's what I wanted to
No,
know.
no, I'm sorry. My apologies. Yes, this is 300 dots.
Okay, so this is showing the same 100 customers' bills under each of the 3 rate plans?
Yes, yes, it is. I apologize.
And were the customers selected randomly?
So they were the customers that Ameren provided when I requested 100 random customers. Well, 100 random customers who have 12 months of TOU data, I think is the more accurate way of saying that. Or of AMI data, not TOU data.
Do you have any idea how these same customers would perform under the evening morning saver?
So the evening morning saver and the anytime saver are virtually on top of each other. I took them out of here because 400 dots is even harder to see than 300 dots.
Another question I also asked.
Oh, I apologize. You said evening morning saver. Sorry, there's so many. Oh, yes, evening morning saver is very similar to anytime saver. And the overnight saver is very similar to the smart saver. Again, not identical, but in the ballpark.
Given staff's proposal to have customers transition to AMI meters within a month or in the next billing cycle from having those installed, how does staff picture that education materials would have to be changed to accommodate the shortened time frame?
So if I can answer the question you didn't ask, for transition to the evening morning savers, as staff has recommended, I don't believe anything needs to change. I believe that we order bigger customer impacts all the time. You know, we might be ordering a $3 customer charge increase in this case with a month's notice. That's a routine thing. If what you're looking at doing is something comparable to what was done in the Evergy case, what I would suggest, resources permitting, would be to modify the time periods of I don't want to get these rate plans confused. I would modify the evening morning saver overlay plan to align with the time periods that you're wanting of a higher differential plan. And I would, starting immediately out of this rate case or upon installation of an AMI meter, I would order those customers onto that lower differential plan with those same time periods and give them a year and then move them to the higher differential plan. That's not my recommendation, but if you're looking to do something similar to what was done in Evergy, I think that's a way to do it that's going to give customers education for what is their actual time periods of usage. It's going to start giving them a mild, maybe a penny, maybe a 2 penny differential over that time period, but it's going to retain that winter decline block element over that time period to give them an opportunity to make decisions they need to make about what they want to do in future heating and cooling seasons.
And for the record, what was the question I didn't ask?
I think the question you didn't ask is, would it be the same if it was for a higher differential plan? And I think that if that's the commission's decision on where to go, that's a decision the commission can make. I would give customers a moderated price signal for a year so that they are getting a price signal, so that they are getting that information, rather than relying on some sort of utility marketing effort. And to the point Mr. Mark raised this morning, that could be confusing with Ameren with different customers in different states of deployment. So I think that if you're going to do that, I would make a low interval or a low differential rate. Well, we don't need another rate out there. I would modify the existing evening morning savers rate to a moderate version of where you want the rate to be. And I would order all customers with AMI meters onto that rate for a year. Then after that year, you would transition them to that higher differential rate.
That would mitigate certainly any need for customer education.
Well, it would, in effect, it would be the customer education.
Yeah.
You're not sending them a separate mailer, you're not directing them to a website. They're seeing, okay, here's how much energy I used in this time period, here's how much energy I used in that time period. And whether you're going with a 3-period or a 2-period rate would indicate exactly how you would design that. But you would want your transition rate, one, I think you would want a transition rate. And two, you would want it to mimic the time periods, but retain the winter decline, to ease customers over to that.
And I've only got a few more questions. Based on staff's proposed changes, what residential plans would be available to customers with net metering?
So, I will say that we've had some turnover in staff counsel's office. And so I'm not sure exactly legally, although I suspect we could address it in the brief, where we are on that. But I think with how the evening morning rate structure is being dealt with net metering customers, I think that barring a differing opinion from staff's counsel, I think that you could modify rate structures of other plans to produce similar rate impacts while dealing with the issue that Mr. Wills has pointed out about the billing period issue. And I think that if you're going to do a mandatory time of use rate, similar to what was done in Evergy, I think that we would just need to be cognizant of how that's handled.
Now, the proposed, or Ameren's evening morning saver plan has a peak rate from 9 a.m. to 9 p.m. every day, including weekends. Is that correct?
That's correct.
Is a 12-hour peak period effective in reducing customer usage during peak periods or shifting usage from peak periods to non-peak periods?
I think that presupposes that that's the intent of that time period selection. And one, it's not, but I do believe it is consistent with that movement. It's probably in and of itself not enough to encourage it, but I believe it is at least directionally consistent. And so to the extent you have a customer who's charging an electric vehicle, a customer who's considering pre-cooling their home, pre-warming their home, I think that those are elements that if a customer is paying attention, at least it gives them a hint of what to do. But the evening morning savers was never intended as a long-term solution.
Now, you said that wasn't the intent. What do you believe the intent of it was?
Well, it's a couple of things. We picked up the nomenclature of training wheels. So first of all, it's just to make customers aware that the time at which energy is consumed is a factor. Number two, it's designed to make customers aware of how the energy they use broadly fits in to time periods. And number three, it's to begin the alignment of cost causation with revenue responsibility. Now, when I proposed that rate in 2019, it didn't look like what's on the tariff today. Due to some stipulations, some differentials were reduced. I think that something more like what we proposed in Evergy with the 3-period, I think that makes a little bit more sense than the Ameren design does sitting here today. Now, in the last case, we proposed some changes to that rate. We were told now's not the time to tinker with it, so frankly, I didn't bother in this case. But if I were to tinker with it, I would probably make it look more like what we recommended in Evergy.
Okay, given that you said that that wasn't the intent of that rate plan, was to either reduce customer usage during peak or shift loads, what's the benefit of eliminating the anytime plan available to AMI customers if the evening savers plan is not to reduce peak usage or shift load?
To better align cost causation and revenue responsibility. And I grant you, it's not huge. I would personally like it to be a little bigger. I do think as an interim step to customers who have gone from, a buffet, if you will, as far as timing goes, that small is good. I do think a training wheels approach is a good approach. And I think Dr. Faruqi has got a little, he's traveled the country talking about what a great plan Ameren has, that we had to drag him kicking and screaming into. But I do think that for a mandatory time of use rate, that starting small to give customers information is a good step. And I do think that this approach that doesn't just change how customers are billed 8 months of the year is a good one. And I think this has probably been lost on the commission for how information's presented. There are a huge number of the customers on the Smart Saver and Ultimate Saver and Overnight Saver rates who are only paying TOU bills 4 months of the year. They've opted out of doing that during the non-summer season, and I can give you those percentages, but it's non-trivial. In overnight savers, there are 6% of energy sales are not on TOU during the winter. In smart savers, there's 14% of energy sales that are not on TOU during the winter. Oh, and I apologize, ultimate savers is year-round. But those are for those two rate plans. There's, that's not nothing in terms of such a small number of customers to begin with. So I guess to expound on answering another question that wasn't asked, if you are going to order, and again, staff is not suggesting you do, but if you're going to order that customers be moved to, for example, the Overnight Savers plan, I think the commission, to achieve the result they are trying to achieve, would want to clarify that that is without the option to remain on a conventional rate for 8 months of the year.
And that's to achieve peak reduction.
Well, that's to actually put them on the rate.
Okay.
So you can opt in to Overnight Savers and Smart Savers in a way that only puts you on those rates for 4 months of the year. There's options under the option.
Thank you. Those are all the questions I have. Any recross based upon bench questions?
Judge, it's Commissioner Roop. Can
Oh,
I,
I'm sorry, yeah.
toss a question in?
Please go ahead.
Thank you very much. So we had previous testimony from the company when they were discussing I forget the name now, the Vols distribution study from 2009.
Vandus.
That was it. Thank you. And the company had stated that they would be open and find benefit to updating that study and providing that information to staff in lieu of doing other different data collection. My question is, would staff welcome an updated version of that study, and would they use that, or would it be something that they would still find not as a valuable resource for the planning?
I've got a two-part answer to that, if you'll permit. First is it depends. If the study means just literally 3 sets of percentages by account with no underlying work papers or data, no, we can't just take their word for that kind of thing. And if we did, you probably ought to, hire some staff who do their jobs. And two, another issue that's come to light, and I guess a preview of later this afternoon, is staff has some real concerns about the reliability of the actual underlying accounting data, the continuing property record for these accounts in particular. So I think that a study of the assets as recorded in a continuing property record is only as good as the continuing property record. So it's hard to say, one, if they would do a robust study to begin with, and two, if the underlying data is reliable. But if they can shore up, those 15 years of missing retirement data, and if they can show us their work, I think that could be a reasonable thing to do to answer those questions about the cost of the high voltage system, the primary system, and the secondary system, and those are the only questions that are answered by the Vandis study. Okay, so it's not a fix-all for everything, but that is the distribution classification question.
Okay, great. That was exactly what I was looking for. Thank you.
Thank you, Chairman. Are there any recross questions based upon bench or commission questions? Mr. Williams, go ahead.
Ms. Lange, do you recall whenever you said that class members are not as homogeneous as they're treated in class cost of service studies?
Yes.
Could you elaborate on that a bit?
Sure, and I guess the easiest way for me to explain this is actually to talk about customers who may be homogeneous across classes. So let's give the example of a data center. So let's say that you have a data center that uses, a 99.9% load factor of energy consumption. Obviously, there's going to be differences in a data center that is, operating at a home office, a small commercial center, a large regional center, and a sort of mega center. Okay, those are all going to have different customer facilities, but the average cost of energy that they're paying over time ought to be pretty similar. Well, in fact, under Ameren, Missouri's rate structure, they're incredibly different. Okay, so if you look at that as here's how customers could be the same and just at different sizes, and they're being billed very different under the rate classes, the same is actually true within a rate class. So using LPS, for example, there are LPS customers who are being billed, below 5 cents a kWh on average. There are LPS customers who are being billed almost 9 cents a kWh on average. The LPS rate design is incredibly simple. Once you have a facilities charge and a demand charge, all kWh in a month is billed at the same rate. So there's no recognition given to customers who may be operating around the clock. There's no recognition to customers who may be operating entirely off peak. We are assuming that this average class load that is presented out of a load research data is representative of individual customers within the class, and frankly, that's just not a reasonable assumption to make, especially now that we have AMI data that proves it's not the case.
That sounds like you're saying that some of Ameren's current rates are unduly discriminatory for similarly situated customers.
Well, we don't know what we don't have data for. I suspect that is the case, or I suspect that to design good rates would result in rates that are very different than what we have today, or at least different than what we have today. I certainly wouldn't be proposing any new hours use rate structures in the year 2023.
There was quite a bit of discussion about rate modernization earlier. Took the opportunity to look through your testimony, and I think you may have omitted explaining how you view that in more detail than what you testified to here. If you take the opportunity to, I don't know, either find it or explain in a little more detail than you did earlier.
So what I mean by rate modernization is using the information that we have available and the billing systems that can exist in today's time frame that are different than what existed in the 80s and 90s and before, and using that to come up with a reasonable customer charge based on the customer-related costs that a customer exerts, a facilities charge that accurately reflects the costs that customer is imposing on the distribution system, particularly in regard to its customer-specific infrastructure, and then some combination of a coincident peak demand charge, meaning demand during what are identified as appropriate peak hours. And I think I threw out in this case an example of that, as well as a time-based charges to recover the remaining revenue requirement. Did that answer your question?
I think so. You referred to billing system information, or do you mean usage, or did you mean something more than that?
So what I mean is, in the past, well, it's kind of ironic. Ameren's one of the biggest utilities, and it has about the smallest number of rate classes. So in the past, there was limited information that could be handled in a given month to bill a given customer, and complex billings had to be done on a manual basis. So what I mean by that is that it may be what I foresee happening over the next 10 years is where a customer of a given size is charged a particular customer charge based on that size. It's charged a facilities charge, multiplying its non-coincident demand by a set rate that may be the same or virtually the same across all classes, adjusted only for line losses. It's billed energy charges that may be the same or virtually the same across all classes, adjusted only for line losses.
I'm going to turn to something else. You said that the current fleets of the utilities, including Ameren Missouri's, differ because of historical differences. Would you elaborate a bit on that?
Yeah. So Ameren, the big Ameren rate case that kind of set in motion the rate structures and rate designs that Ameren has today was the Callaway case. In the 80s, a framework was laid, it was refined in the 90s, and those rate structures have been in place since, I believe, the late 90s. And since that time, we had Ameren acquired virtually no generation, maybe a peaker or two from, I believe it was about 1985 until early 2000s. I want to say around 2003, 2004, when they picked up what are referred to as the Aquila fire sale CTs, which, as the name implies, were acquired less because they made sense to them as a utility and more because they were close by and they were at an affordable price for a international utility that, made international news for going bankrupt. And since that time, we've seen coal plants retire. We've seen renewables being added that, we're not saying they shouldn't be added. We're not saying that they don't serve capacity, and certainly in the way I allocated them, their capacity contribution is recognized. But they're not being added to meet a peak capacity, which is the premise that is underlying, what you want to call some historic production allocation approaches such as the A&E.
Thank you.
Any other recross based on commissioner bench questions?
Yes, Your Honor, if I may.
Please go ahead.
Just briefly, to your knowledge, Ms. Lange, are billing units available for the alternative, or I think you called it transition rates? Or rate?
The thing that I suggested we ought to develop as an interim step if the commission is going to enter an order similar to what it entered in Evergy.
Correct. That was my understanding.
No, we'd have to work on those.
That's all. Thank you.
Any other recross based on commissioner bench questions? Any redirect from staff?
Very briefly, Ms. Lange, in response to a discussion you were having with the judge, if I wrote this down correctly, you made the statement that the weighted energy allocator has been misrepresented by other witnesses in this proceeding. Did I get that basically correct?
That is certainly true, and I do recall telling the judge that, yes.
What, can you explain that? First of all, what is weighted energy allocator? How's it used, and how has it been misrepresented?
So, to allocate the costs of the network distribution system, I took the demand of each class from Ameren's load research in each hour, and I squared the values of the hour so that what I would end up with is the relationship between let me put it this way, the hours with the highest demand had the highest rating, and the hours with the lowest demand had the lowest rating. And I think that while the parties have seized on, this belief that it's producing an energy result, it doesn't. I can state the differences if that's helpful, but it's not the same. But what it does show us is that when we've had these assumptions for years that have said, well, these classes cause these costs, these classes are peaky, these classes whatever, what that ignores is that some of the classes with high load factor, it's not only that they're using energy in hours with low load factor or with low demands, it's that they are also causing contributions to demand in hours with high demands. And I think the easiest way to look at that is if you rank the hours from highest to lowest, what you see, and when I say that, so you'd have 8,760 hours, you have class load in each of those hours at a consistent voltage. And if you rank those from highest to lowest, the highest overall we have is for 6/13/22, hour 17, total demand of 6,990,997. Well, in that hour, LPS is contributing 515,384. SPS is contributing 585,274. LGS is contributing 1412834. SGS is contributing 670,007. Res is contributing 3807498. And while those numbers are, they are what they are, but let's skip down roughly 50 hours. And I apologize, I didn't number the hours when I pulled my information. But okay, so let's go to where the total demand is 662,328, which is probably 40 hours from the highest hour of the year. We see that LPS has a demand of 518,990. And that's not to say that they should be penalized for having a consistent demand. It's just that if you're looking at a system that has to exist in every hour of the year, I think that you need to start looking at what the requirements are on that, because it's not just peak demands that drive the distribution planning. And where this kind of ties back into what Mr. Williams was getting at, and this is very important, when you do this on a class level, you do get numbers that aren't too far off of the energy allocators. But if you do this on a customer level, you see huge differences in customers. And this is a method that I developed in costing out distribution costs to time periods for TOU rate development. So if you want to have a higher differential TOU rate than what staff has proposed in recent cases, you have to look at costing out revenue requirement to those hours to reasonably allocate cost to those hours to see a cost difference. And what you find is that, you have some customers who are using exclusively in high-cost hours. You have some customers who are using exclusively in low-cost hours, and a lot of customers are somewhere in between. And that's true across all classes, which is what gets missed when it's aggregated at the class level.
You also had a discussion with the judge about, actually rather lengthy, about the minimum distribution system study that Ameren has done. Do you recall that generally?
Yes.
And you said something about Ameren's, is this a model or a study, or I guess I should call it a study, right? Ameren's study is based on a minimum distribution system that's primary voltage.
Correct.
What's the effect of that?
The effect of that is that you are assuming a per customer cost as though every customer were a primary customer. And what I mean by that is that if you were building a distribution system to serve your house, or let's say that the judge has law office up the street, you would not run a primary line from a generation facility to that house or that business. That's why the secondary distribution system exists. So if you're going to cost out the distribution system on what you're going to claim as what you would build if you weren't serving any customer demand, which is the, or the minimum level of customer demand. I'm sorry, it should reflect the minimum level of customer demand, which would be, well, frankly, it'd be a lighting customer, but realistically it would be a 110, 240 volt secondary customer, not a primary customer.
So does Ameren's study then allocate greater costs to the smaller use classes than it should, or?
So Ameren uses that portion of its study to decide how much cost should be allocated to each customer, which is aggregated at the class level. So the effect of this study is that you're allocating the same costs to one unit in a triplex as you're allocating to a lead smelter. And if you go back to that exhibit we had earlier today, I don't have it in front of me, but for 60% of poles and for, I believe it's 57% of overhead conductors and devices, that is the portion that they're allocating based on the number of customers under the premise that each customer should pay the same amount.
Okay. There was also some discussion about scaling a cost of service study based on percentages or something, some reference to Mr. Hickman had scaled the Vanda study based on changes in something. First of all, what is meant by scaling the study, and second of all, how is that done?
Well, I think there's three issues where this has come up. One is with Mr. Hickman's adjustments to the Vanda study results to fit his minimum system study. One is with the adjustment Mr. Brubaker purported to make this morning of scaling his study results to fit a different revenue requirement composition. And the third is with Mr. Hickman's TH1 table. And it's the same issue across all of those, which is to say that mathematically, you can't adjust an average when the contents that made that average changed and get results that are accurate. So using the example of the Vanda study, I believe I outlined this in my rebuttal testimony, but Mr. Hickman didn't, if you will, sorry, let me see if I can potentially get the right percentages in here. Sure. So if you look at page 44 of my testimony at the top, we have what are called the Vandis study results, and this is a direct copy and paste out of Hickman's work paper. And in here, in polls, he says he has 19% HV, 38% primary, and 19% secondary. Well, if you total those up, there's not 60% that's missing. But he finds that 60% of the polls account should go on minimum system. And so then he just adjusts these percentages down. Well, with these values, if you're doing a minimum system that takes up 60%, that wipes out the 19% that is allocated to secondary when you just adjust that minimum size that Vandis found in, I guess 1994. When you replace that minimum size with a 60%, that wipes out what is here is the secondary percent. That wipes out a chunk of what's here is the primary percent. But instead, he just adjusted those percentages while changing what the fourth component of that study result was.
Excuse me. A lot of discussion about the rate modernization workshop or working group. When you think of the rate modernization working group, do you see that as an opportunity to perform actual work on actual data, or is it just sort of a academic exercise in your mind?
I sure hope it's an opportunity to do actual work on actual data. If the intent of this process is to sit in a room and be read a PowerPoint, I'd submit that's a waste of everyone's time. I think that if we, looking back to how some of the working dockets were done, as the FAC was being developed, as the MIA rules were being written, where people came with their laptops, they came ready to do math, they came ready to do work, I think that could be a really productive exercise. If it's, if it's a meeting of spreadsheets, great. If it's a meeting of PowerPoints, frankly, it's a waste of everyone's time.
All right. How does Ameren's CCOS method coincide with the reality of Ameren's MISO participation?
It doesn't.
Objection beyond the scope.
That's not beyond the scope, Judge. There were tons of questions about Ameren's Ameren's CCOS study. I'm not limited to bench questions. I'm doing redirect. That's based on all questions.
Go ahead.
Thank you.
That'll be overruled.
Ms. Lange, let me restate or repeat the question. How does Ameren's CCOS method coincide with the reality of Ameren's MISO participation?
It doesn't, and that's especially true now that MISO has moved to a seasonal capacity construct. Now, there was a brief time, I think after testimony closed, but before this hearing, when that construct was in question. I think that MISO has come out since then, indicating that the auction will be slightly delayed. But as I understand it, 4/18, so 5 days from now, Ameren will be Ameren will be participating in a MISO capacity auction that's based on 4 seasons rather than one coincident peak, which has been the historic practice. And the way that I allocated the costs of the costs and the revenues associated with production facilities that are not low, no variable cost, net of the capacity contribution of facilities that are low, no variable cost, is explicitly designed to account for that MISO function, whereas what Ameren's doing has been something the industrials have been pushing since at least 1985, which necessarily does not account for that.
Now, OPC, Mr. Williams of OPC asked you about your two biggest concerns, I think it was, with Ameren's CCOS methods, and you gave some examples. Are there other concerns you have that make Ameren's CCOS study unreliable?
I'm just going back. I know I addressed several of them with Mr. Williams, so I'm trying to not be repetitive. Oh, one of the biggest things, and we kind of take it for granted because it's just always been this way in utility studies, is that they're using an around-the-clock cost of energy average. And so this is coming from their direct. So they're using a year-round average for the cost of energy. Every hour of every day of every month is the same cost of energy in Mr. Hickman's study. And that's the cost of actual energy net of the revenues they get from selling energy, which, using their FAC tariffs, they were looking at 14.48 cents per kWh in the summer and 13.12 cents per kWh in the winter. And those just aren't reasonable estimates of the cost to use for energy. So what staff did is staff takes the hourly load on each hour and the LMPs in each hour, and it multiplies those two to look at the cost of energy, which seems like a pretty obvious way to solve for the cost of energy. So that one, I don't understand why Ameren keeps doing this when the information to do it better is pretty darn easy to do.
Chairman Roop asked you about the Vandus study and certain information that Ameren had offered or something. Are there specific pieces of information needed in that study to make the study useful?
To redo the Vandus study as the Vandus study was done in 1994 is going to be using information pretty similar to what I've suggested the utility should be providing, either pursuant to a commission order in this case, or as developed through the rate modernization docket. There may be some differences, but I would think they'd be minimal. The biggest issue is that Vandus study is necessarily going to be based on the assets as they're recorded in the company's continuing property record, which we've learned are only reflecting coincidentally accurate retirement data.
Is it possible that the percentage of distribution plant used to serve various voltage levels have changed over time, especially considering Ameren's smart energy plan investments?
Oh, especially considering the smart energy plan investments. And frankly, I think the data, or at least the analysis that's being relied on, precedes the Metro East transfer. So Ameren has, since this Vandus study was originally done, possibly even as reflected in the what they call the refresh in 2009, that may or may not be accounting for distribution plant that's sitting in Illinois, and it may or may not be. I know since then they've picked up, was it Owensville Municipal Utilities? I think they've picked up a couple other smaller systems since then that is just left out of this study, not to mention the growth that's happened. There's been several ice storms since then that have resulted in significant rebuilding of areas of the distribution system. There's been significant undergrounding efforts. I mean, if you just look at the mismatch in the percents between the polls account and the conductors and device account, that tells you right off the bat that something's not making sense with the approach they're taking, whether that's the underlying study or whether that's the way they're applying it to the day-to-day. It just doesn't make sense.
In the very beginning of your answer there, you used the phrase the Metro East
Metro East transfer.
The Metro East transfer. Just for the record, what is that?
I'm gonna get the year wrong here. Sometime between 1999 and 2005, and I apologize. I'm gonna get the year wrong if I try to be more specific. Ameren, Missouri, Ameren, Illinois, got some legislation that resulted in their need to divest of generation assets that coincided with Ameren's Missouri's need to get out of the business of being in Ameren, Illinois. And so there was a case filed. I think this was done in one case. It may have been spread over two, where Ameren, Missouri ceded a significant amount of customers and load, primarily industrial load factories, in East St. Louis and the area around East St. Louis in exchange for picking up the Noranda smelter as a customer. And I apologize if that was done over one case or two, possibly more, but that's broadly referred to as the Metro East transfer. And whether this is allowed or not, Mr. Wills, am I generally right on that? If I've said something terribly wrong there, I don't want to have the record terribly wrong. Okay, I will, yeah, I'll stop talking there then.
Going back to, in response to the judge, you read something from something you printed out over lunch, and I offered to offer it, and Ms. Grubbs didn't want me to offer it at the time. Do you know what I'm talking about? The exhibit thing, 183, I believe it was marked as 183. Could you describe that again just for the record?
So visually, the first page is a table of some account names and some rows consisting of descriptions of costs. The second page is an email from myself to Mr. Lubert and Mr. Jim Bush, dated Monday, April 10th, 2023, 4:46, as well as one handwritten line.
And then this represents data that you believe to be needed?
If I was going to start from, if I was going to pretend the last three cases hadn't happened, and I was going to ignore various representations, orders, stipulations that have been achieved about what data we need to do things, and I was to say, let's all put that all behind us and start from scratch, this is the data that I believe we need as a bare minimum to have a productive discussion of reasonable rate structures and the costing thereof for Ameren, Missouri.
And would this be for purposes of the the modernization workshop that we've talked about, or a future rate case, or for what purpose exactly?
Either of those, I guess it depends on timing. If they file a rate case, July 3rd, as has been something of a tradition, and I'm not speaking from knowledge if that's proposed or not, then we would want it for that. Ideally, this is something that we would take a little bit more time with and work through in a rate modernization workshop.
Judge, I'd offer this exhibit 183, I think it's called.
Can other parties
I
see a
don't think-
copy of it? Sorry.
I was actually getting to that. I don't think anybody's had an opportunity to see that yet.
It should look familiar, Jermaine.
Judge, the only thing I'd add is my recollection is that there was a correction to that exhibit on one of the, I don't remember if it was an account number or a description, but just so it's in the record near to when the exhibit's being offered.
The account number correction, I remember, was in the testimony.
There was a voltage correction. There's a typo in one of the voltages, and I would submit that the literal voltages and that sort of thing that are referenced in this document, staff has flexibility on what reasonable voltages would be to use in lieu of that. If the Ameren distribution engineers, who are obviously closer to the system than staff is, if I said, 600 volts and it should have been 575 volts, we're not being a stickler on that.
Judge, I'm a bit at a loss as to what we're doing right now, because, if this is Ms. Lange's opinion as to minimum data necessary, whether other parties have seen it or not, I don't get the connection.
Well, if you're
Judge-
planning to offer it as an exhibit, the other parties get a chance to look at it so they have an opportunity to object to it if they want to.
Well, that's okay. That's true.
I guess if I can clarify with counsel for staff, for what purpose are you offering this? Didn't she testify everything that was on there?
I don't believe she testified to the second page.
I don't have any objection to it.
Don't ever do this again.
May the record reflect, I have been chided.
We'll make some additional copies now, Judge, and she works for you, don't hand it to me. We'll make some additional copies, come back from the break, I assume that will be taken soon, and so everyone can have a copy.
Well, I'm going to ask right now, has everybody had an opportunity to look at it that wanted to look at it? Are there any objections to admitting Exhibit 183, what I'm calling staff's minimum proposed data for modernization, onto the hearing record?
None from the company, Your Honor.
I see and hear no objections. Exhibit 183, staff's minimum proposed data for modernization is admitted onto the hearing record.
Judge, I did also have one question for you. After all of your questions for Ms. Lange, I don't remember you asking her anything about the graphs on the staff response to the April 4th order. Was that intentional on your part, or was that, did you forget?
I forgot.
Oh, okay. I thought you might have, but I just wanted to bring that up while she's still here.
Well, why don't we just do that real quick? You prepared those graphs?
I did.
And are they true and accurate to the best of your knowledge?
They are as good as the underlying Ameren load research data. So to the extent that there's any issue with how solar is represented, I can't vouch for that, but they are accurate to the data that all the parties were using in this case for load research.
So this was compiled from data that was supplied to you from Ameren?
Yes, this is Ameren's load research data, which is the only data that we have for hourly energy by class, hourly demand by class. It's the same thing at the hourly level. It has not been normalized or annualized for weather impacts, customer growth, anything of the sort.
Well, why don't we, do you have it in front of you?
I do.
Perchance? Can we just go through really quickly for the purposes, even though this has already been admitted onto the record? Why don't you just tell me what each graph represents?
Okay, the first one, it's labeled max hourly load in 24-hour period at generation voltage, July 2021 through June 2022, per Ameren load research. So what I did is I took the Ameren load research at, I believe, generation voltage. I set up in row 1 a solve for maximum value in each class. I then selected an array of cells that was 24 rows long, and I drug that for the length of the 8,760 hours indicated on this. That then produced a maximum daily demand, which I guess if you want to account for the daylight savings time, there's I guess a variation there if any maximum demand occurred at midnight or 1 o'clock, but I would not expect that to be the case. I then removed the non-value cells, and I provided the total and residential values produced by what I just described.
Okay, next graph. And that's June 2022.
Yes, June 2022. So using that same data set, I created, so the data set is arranged by month, day, time. So I created a row that established for each hour on that 8,760 hours. I established a month-hour valuation. I then created an array of months and hours and used that to draw out of the data set of 8,760 hours, the average across those hours within that month for the total and residential is indicated for the month of June 2022. I followed the same process for each of the other months as indicated.
That would be July, August, December, January, and February.
I believe you read those accurately, yes.
Judge, one thing I noticed, that because of the way the test year fell, and you go from, like, on the charts, you go from June 22 to July 21. So I just want to point that out because of the way the test year fell and everything. So the months don't go consecutive, even though it sounds, June, July, August, sounds like they're consecutive. They're not, because some are from a previous year.
Thank you for pointing that out to me. I didn't notice that right off. Okay, did you have any other redirect for this witness?
No, Judge, that was it. I'm concluded.
Okay, I think you were right on the money that it's a good time to take a break. It's 2:43 right now. I propose we take about a 15-minute break and come back at 3. During that time, if you can get copies of that exhibit for the other parties and for myself, I would appreciate it. With that in... Thank you, Mr. Lubert. With that in mind, we will recess until 3 o'clock, and let's go off the record. All right, we're back from break. We just finished with staff's witness Lang for issue 1. Does staff have any more witnesses at this time? Not on that issue. Is your microphone on?
Not on that issue.
Thank you, Mr. Graham. And I believe off the record, Ameren had indicated that there was a housekeeping matter. Would you like to talk about that now?
Yes, thank you, Your Honor. During this morning's discussion, or maybe earlier this afternoon, I'm sorry, I'm losing track, we had reserved, I think it was exhibit number 52 for the data request response that provided the information pursuant to the ET 2018 case. And so I just wanted to move that into the record. I would note that there are 3 attachments, and those are confidential as they contain customer specific information. So we would have 52C and 52P to be added, and I believe that has been emailed to the court reporter.
Okay, would you say that again? You have 52C and?
52P.
Okay, public and confidential. Okay.
Yes, sir.
And what would you use as a description for that?
Company response to DR MPSC 591.
Say the DR number again, please.
591.
Company response to DR 591?
Yes, thank you.
And has that already been offered? Are you offering it now? Or
Pardon me, I would ask that it be moved to the record.
any objections to admitting the company response to DR 591 onto the hearing record?
I don't have an objection, but I would appreciate receiving a copy of it as well.
Absolutely. Can you get a copy to Mr. Williams?
Yes, we can email that. It is also available in EFIS.
Okay.
It's-
Mr. Williams, would you like to see that before I close the time for objections?
No.
Okay, hearing no objections, Exhibit 52P and C, company response to DR 591 is admitted onto the hearing record. Any other housekeeping matters at this point?
Just a scheduling question, Your Honor. I wasn't sure if there was a hard stop this evening at any point, but company witness, Mr. Spanos, will need to be presented today, so I don't know how long openings or such will take, but I just wanted to present that. If we're getting close to any hard stops, perhaps we could take him out of order.
And I have Spanos listed as the first witness, so we should get to, depending on how long openings are, we should get to him pretty quickly.
Let's hope. Thank you.
But I'm certainly willing to accommodate. With that in mind, is there any reason that we need to stay on issue 1 any longer, or can we move to issue 2?
I would just clarify, there will be a witness presented on issue 1 tomorrow, is I believe the expectation for MECG witness, Mr. Chris.
And I was aware of that. I just talked to MECG, and I believe that we're going to try and do that. I said to make him available in the morning. Now, for issue 2, are we going by in the same order that we went for mini openings for issue 1?
That was my understanding, Your Honor.
Okay, let's
Your
do
Honor,
that.
I wasn't here for that. I looked at the schedule, but I can't make the comparison in my mind, so.
Staff filed an updated
Right.
issues list, and under issue 1, Wednesday, April 12th, they had mini opening statements. When you move on to issue 2, it says mini opening statements on issue 2, but it doesn't list an order, so I assumed we were going to use the same order we used for issue 1.
Well, I hope someone will tell me when it's time to stand up. Okay, thank you. Thank you.
Well, let's start issue 2, which is formerly issue 24B, which is depreciation continuing property record, which is the CPR. And it's should the company be ordered to change the manner that property retirements are recorded to its continuing property record. And with that in mind, first person to give an opening on, or first party to give an opening on this mini issue is Ameren, Missouri.
Thank you. Good afternoon. May it please the commission. While the depreciation rates were agreed to in the stipulation that's going to be presented on the record tomorrow, and the signatories, among the signatories, and no parties have otherwise opposed the stipulation, it's helpful to understand the context that the continuing property record, or CPR for short, is used in a depreciation study. And within a depreciation study, there are recorded retirements by account. Depreciation rates are estimates of the reduction in value of an asset over time, just generally speaking. In other words, how assets depreciate over time. Issue 2, the continuing property record issue, comes down to the manner of recording retirements of mass property assets in the CPR. Mass property, like the title suggests, are assets that are large in number of units and homogeneous in nature, so that detailed accounting for each individual asset is simply not practical. The uniform system of accounts, accordingly, does not require the same detailed information for mass property assets, namely the location of the unit, as the record-keeping requirements for other types of property. The company appropriately relies on survivor curves determined from the most recent depreciation schedules to statistically select the mass property values to be retired, and deploys this method through its software system. Just as the depreciation rates are estimates based on informed judgment, so are the retirements. The company is following the methodologies outlined in the FERC Uniform System of Accounts and the Commission's rules for its continuing property records, including its retirement of mass property assets, in the best interest of customers. In fact, as noted in the surrebuttal testimony of company witness Mitch Lansford, the Uniform System of Accounts electric plant instructions, specifically 10D, allows for the use of estimates in determining the electric plant to be retired. As explained by company witness John Spanos in rebuttal, the company's processes and methods for retirement of mass property assets are the same or similar to those of many other utilities. And the technology solutions and accompanying statistical analysis relied upon by the company and many other utilities to process retirements for mass property are a practical necessity for keeping the property records accurate and as current as possible. The process for retiring mass property assets, as proposed by staff, which, to reiterate, is not required by the FERC Uniform System of Accounts or the Commission's rules, is impractical, would create unreasonable, extreme administrative burden with negligible, if any, benefit. So I encourage you to ask company witnesses John Spanos and Mitchell Lansford about the unreasonable burden that would be created and the lack of corresponding benefit. In conclusion, no changes in the company's recording of mass property assets should be ordered. And I'll try to answer any questions, but I may have to defer to an Ameren, Missouri witness who may best answer.
Any questions from the commission? I have no questions. Thank you.
Thank you.
Next opening from the staff of the commission.
If it please the commission, remember that number, 10D, the rule that was invoked by staff, or by Ameren. The issue before the commission today concerns record keeping. Ameren, Missouri is required by regulation to track additions and retirements of its assets in a continuing plant inventory record. Here we will refer to that record as the CPR. Staff has been made aware that the company is not tracking the retirements of assets accurately and is instead allowing the power plan software to simulate retirement data. This simulated data is then being used in subsequent depreciation studies to determine depreciation rates for those accounts in future rate cases. The specific question before the commission today is, does Ameren, Missouri's current practice adhere to the commission's regulations? The answer is no. Should the company be ordered to track and record retirement in its continuing plant inventory record, the CPR, instead of simulating data? The answer is yes. Let's take a look at the rules, starting with the rules, and we will end with the 10D that council referred to. 20 CSR 424.020.0203A states that an electric corporation subject to the commission's jurisdiction shall maintain plant records of the year of each unit's retirement as part of the continuing plant inventory records, as the term is otherwise defined in Part 101, Definitions 8, and paragraph 15.001.8. This reference refers to 18 Code of Federal Regulations, Part 101. 18 Code of Federal Regulations, Part 101, Definition 8 states the continuing plant inventory record means company plant records for retirement units and mass property that provide as either a single record or in a separate records, readily obtainable by references made in a single record, the following information. For each retirement unit, the name and description, or the description of the unit, or both. 2, the location of the unit. 3, the date of the unit was placed in service. 4, the cost of the unit as set forth in plant instructions 2 and 3 of this part. And 5, the plant control account to which the cost of the unit is charged. And B, for each category of mass property. 1, a general description of the property and quantity. 2, the quantity placed in service by vintage year. 3, the average cost as set forth in plant instructions 2 and 3 of this part. 4, the plant control account to which the costs are charged. As council has alluded, Ameren's council has alluded, we are talking about categories of mass property in this instance. What constitutes mass property? The mass asset convention of accounting applies to the accounting for large numbers of homogeneous assets in situations in which the accounting for individual assets is not practical. Under this convention, homogeneous assets are aggregated and depreciated by applying a rate base on the average expected useful life of the assets. So simplified, a category of mass property is a grouping of many similar asset units into one group for accounting purposes. Now, going back to the rule, Part 101, Definitions 8B requires the recording of the quantity placed in service by vintage year, and the average cost be recorded for each category of mass property. So in a nutshell, what does the rule require? Stated succinctly, the rule requires that when a widget is retired, certain things be recorded in the company's continuing plant inventory record. One of those things is the widget's vintage year, as previously recorded. As previously recorded. I said it twice for a reason. Another is average cost as previously recorded. The Ameren, Missouri method of recording Ameren, Missouri is not recording this for all accounts, but is instead simulating retirement data. In response to staff data request 0209.3, the company stated the following. Ameren uses the power plan system to select assets for retirement based on an Iowa survivor curve for mass property accounts based on the type of asset. The survivor curve reflects current dispersion patterns of the assets, which has been determined in the most recent depreciation study or studies. As other interveners, including the staff study, the appropriate appreciation parameters for our investments, close quote. So the company is in violation of the rule. When the company retires an asset, it is not recording the vintage year or average value of that asset as it was previously recorded in the company's books. Instead, it is randomly recording a different vintage year, and most importantly, a different average value for that asset. It is doing this on the basis of a software analysis of an Iowa survival curve. And let me illustrate this point, and I've got a page from Mr. Cunningham, Cedric Cunningham's rebuttal, true-up direct testimony, page 4. If I may approach the bench.
Please.
I'll give you one of these.
Is-
Mark it, I think I'll just leave it behind the recorder so it's nearby her.
Are any of these numbers confidential?
I've checked with Mr. Cunningham, he says no. But before we do anything, if other people would chime in on that question.
Before we put anything up on display, I'd like to.
I didn't intend to put it up on display.
Okay.
But I will be reciting numbers. And so your point is. I think that it's not being I've talked.
Ameren, is this in any way confidential?
No, thank you. We have confirmed we're good. Thank you.
Thank you. Go ahead, Mr. Graham.
Thank you. Take a look at the chart on page 5 of the testimony, which will be placed in evidence later when Mr. Cunningham takes the witness stand. This is 5 of Cedric Cunningham's rebuttal true-up direct testimony. This chart tracks 6 data points for an asset. Its ID, the utility account, the retirement unit, the asset location, the activity quantity, the activity cost, and the average cost. Look at the first line with me. Now suppose one of those poles is retired for whatever reason. Might be a lightning strike, can be anything, but it's retired. When that happens, the regulations require that the number 5, see that 5 under activity, be reduced to 4. And that the number $291,080.76 be reduced by $58,216.15. With the company approach, however, this does not happen. Or it may or may not happen. Applying its software to a survival curve, the company may jump down 6 lines and lower the number 80. If you look down the page to the last row on that chart, the number 80 to 79, and subtract $169.37 from $13,549.83. Cutting to the chase, so what? The answer is that rates and shareholder returns will continue to be calculated on the assumption that $58,216.15 minus $169.37 remains in used and useful plant when it is not there. What does the company say about this? Now we get to 10D. Witness Lanford says that this procedure is allowed as an estimate. He states, and I quote from page 11 of his surrebuttal and true-up testimony, and from Ameren's reference to this rule, quote, specifically, the US of O allows for the use of estimates in determining the book cost of electric plant retired. And here comes the rule. The rule is the book cost of electric plant retired shall be the amount at which such property is included in the electric plant account. That's where you start, including all components of construction costs. And that's what goes over into the retirement record. The book cost shall be determined from the utilities records. Now, what's next is the cutting edge of this case. The rule goes on to say, and as I understand it, Ameren is hanging its hat on this. The book cost, if this cannot be done, it shall be estimated. Utilities must furnish the particulars of such estimates to the Commission if requested when it is impractical to determine the book cost of each unit. Due to the relatively large number or small cost thereof, an appropriate average book cost of the units with due allowance of any differences in size and character shall be used as the book cost of the units retired. Stop. The rule requires that if a widget from line 1 worth $58,216.15 is retired, that it be recorded at that line unless that is not possible or it is impractical. Rule exception. Rule exception. Rule burden of proof that the rule does not apply. The exception contemplates that the company has got to come forth and show that this is impossible or impractical. That's not the case that we have here. Through discovery in this case, what we hear from the witnesses is, oh, it's impossible. That's not a self-proving statement. Oh, it's absurd. That's not a self-proving statement. No evidence has been brought forth. Now, it might be said, well, we didn't ask for it. Well, the burden, because of this rule, is on the company to come forth and justify its violation of the rule, and there is no doubt anywhere that the rule is being violated. Well, putting it differently, that's unfair of me. It's not that the rule is being violated, it's that they're not recording the data in the manner required by the rule. This is not in dispute. Well, if it's not in dispute, then the second part of 10D here,
Mr. Graham, can you stand a little closer to the microphone?
then the second part of the rule is triggered. And that rule requires them to show that it's impossible and impractical. They haven't done that. In fact, continuing here, it appears from discovery in this case that it is possible and practical. The company has the data. The company has the data necessary to comply with the rule and put down the actual data that the rule requires. Now, let me make this clear. Staff is not saying, I of course picked a rather explosive example just for illustrative purposes and perhaps to get folks' attention on an otherwise dry issue, perhaps. Let me make this clear. Staff is not saying the error always favors the company. Staff is saying there's no way to tell which way it goes. Staff is saying accordingly that where millions of dollars in mass assets are being recorded this way, there is no way of saying that a resulting rate is just and reasonable. By replacing an actual vintage year as recorded and an actual average asset cost with fabrications, we end up with a fabricated continuing plant inventory record. How do we know this? Well, here's the epiphanic moment. The record I've just shown you is not accurate. It never was accurate. This record is a record of what happened after the last retirement occurred using the company's system. We don't know as we look at this record whether on the date that this record was made, whether these numbers, this data, reflected actual plant in service. And that's where we stand today. The chart shows inventory after the company has made retirements per its system. When made, were there actually 5 poles each with a vintage year of 2020 with an average cost of $58,216? Or had one been retired but recorded as a reduction of 81 to 80? We don't know. The company states as much in the supplemental response to staff data 209.1S1 when Laura Moore states, that vintage year will not, except by pure coincidence, match the vintage year of the actual asset retired in the field. Well, that's a statement that could be made about the entire record. Whether the record reflects actual plant in service for rate-making purposes is a matter of pure coincidence. That's what the Ameren's own witness said. Now, moreover, it gets worse. The error is self-sustaining and quite literally feeds on itself. I hesitate to pun this way, but away we go. Feed on itself. That is, there is a feedback, I apologize, loop error involved here. In baby steps, the survivor curve projects a service life of an asset account. That projected service life, in turn, is used to retire assets on the accounting books and to add newly fabricated data to the depreciation database. Then, that fabricated data is used in the next depreciation study to determine the survivor curve in the next case, in the next retirement. Putting this differently, over time, the continuing property record is no longer an accurate record of plant assets. Ameren, Missouri is not disagreeing with this statement. It simply contends that the rules allow for an estimate without addressing whether or how the estimate involved is a reasonably accurate estimate. Now, to reiterate, look at the chart from Cedric Cunningham rebuttal testimony. Vintage year, just so I get this across, because there's been a lot of conversation, at least coming into this courtroom, about vintage year. Vintage year is directly tied to the average cost. Why do I bring that up at this point? A key word that you heard in Ameren's opening statement was the word location. Staff is not insisting here that the correct location, the rule requires it, but that's not the heartburn that is being caused for staff here. The heartburn is over the vintage year. Vintage year is directly tied to the average cost. Location is not. Vintage year, the age of the asset, is what's critical when you're trying to determine average cost of a depreciated asset. By not tracking the appropriate vintage year of retirements, Ameren is also not tracking dollars appropriately for those retirements. Two of the pieces of information that Ameren is required to track as a part of the CPR are not being recorded correctly. I reiterate that the Commission's Rule 20 CSR 4240-20020318 requires that Ameren, Missouri maintain plant records of the year of each unit's retirement as part of the continuing plant inventory records, as the term is otherwise defined in the rules that I've already cited and read to you. Now, here's staff's recommendation. Going forward, the company should record plant records of the year of each unit's retirements as a part of its CPR in compliance with the regulations. Specifically, when retiring mass assets, the CPR recording process should be based upon the actual recorded vintage years, and the associated average cost of that vintage year. Line up the records with the records. At this time, Staff is not recommending that the commission order a retrospective full inventory or adjustment of the books. Nevertheless, for rate making, the rate base should reflect an accord between book values on the one hand and plant actually in service. So staff will continue conversations with the company to determine whether a full inventory and book adjustment is necessary. On wrapping this up, let me go back to that rule that council cited us to and look at the second wing of it. Company says staff is being absurd. But Ameren's witness, Spanos, states in his rebuttal at page 18, it is always best to be able to specifically identify the actual vintage of an asset. Point not in dispute. Mitch Lansford, in response to staff's DR-439, which I'll put into evidence when Mr. Cunningham takes the stand, stated that the, quote, company maintains accounting records of all of its investments, and those accounting records contain life characteristics as required under the FERC US O of A. Ameren's response to 439 is filed in EFIS with an Excel spreadsheet, which I, of course, am not going to introduce here because it's perhaps hundreds of pages long, I don't know, that contains the accurate data. The company has it. So think about that rule that Ameren invoked. Staff contends that in this case it is just as easy to do it right as it was to do it wrong. If data is available, then doing things right is no harder than doing it wrong. Furthermore, and in any event, because the rule and because we have a duty to ensure that rates are just and reasonable, if it can be done, then it must be done. That concludes my opening.
Thank you, Mr. Graham. Any questions from the commission? I have no questions. Thank you.
Thank you, Your Honor.
On behalf of the Office of the Public Counsel,
Public counsel waives opening.
on behalf of MIEC, on behalf of Sierra Club, NAACP, and CMU.
No opening, Your Honor.
Consumer Counsel is not here. On behalf of Midwest Energy Consumers Group,
No opening, Your Honor.
CG. On behalf of Renew Missouri,
None, Your Honor. Thank you.
thank you. Well, those are all our openings. Ameren, you may call your first witness.
Thank you. The company calls Mr. John Spanos to the stand.
Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated and say and spell your name for the hearing record.
My name is John J. Spanos, S, P as in Paul, A-N-O-S.
Go ahead, staff.
Staff or the company?
I'm sorry, I meant company.
Okay, sorry, just wanted to make sure.
Go ahead, Ameren.
Okay. Mr. Spanos, by whom are you employed? What is your title? On whose behalf are you testifying?
I am employed by Gannett Fleming Evaluation and Rate Consultants, LLC. I am the president, and I'm testifying on behalf of Ameren.
You are the same John Spanos who filed direct rebuttal and surrebuttal testimony in this case, which has been marked as Exhibits 42, 43, and 44. Is that correct?
That is correct.
Do you have any corrections or revisions to make to your testimonies?
I do not.
If I asked you the questions contained in your testimonies today, would your answers be the same?
Yes, they would.
I would move for Exhibits 42, 43, and 44 into the record.
Any objections to Exhibits 42, 43, and 44, the direct rebuttal and surrebuttal testimony of John Spanos? I see and hear none. Exhibits 42, 43, and 44 will be admitted onto the hearing record.
With that, Mr. Spanos is tendered for examination.
Any questions from, any cross-examinations from MIEC? No questions, thank you, Your Honor. Any cross-examination from MECG? Any cross-examination from the Sierra Club, the NAACP, or MCU?
No questions, Your Honor.
Any cross-examination from Renew Missouri?
No questions, Your Honor.
Any cross-examinations, well, CCMO isn't here. Any cross-examinations from Public Counsel?
No, thank you.
Any cross-examination from staff?
No, thank you.
Mr. Spanos, you were here for Mr. Graham's opening, correct?
Yes, I was.
Is there anything in Mr. Graham's opening that you take issue with?
Yeah, I think he has portrayed the quality of the data that is available for Ameren and the consistency of that data as to how it's handled within the industry inaccurately. I believe that under the guidance, the manner at which Ameren follows their accounting records and records that accounting records are consistent in the industry. It is the ability to follow all of the steps that Mr. Graham laid out there is not done in an industry, particularly in the size of Ameren, because of the fact that
I'm going to
you don't
make an
find-
What's your objection, Mr.
The
Graham?
objection is no foundation for this testimony and this reference to the industry and the industry standards. There's not been any foundation laid by this witness or any other Ameren witness that justifies this commission's receipt of that opinion.
Well, I've got some questions about that anyway, but I'm going to overrule your objection.
I'll continue with the fact that the manner at which you need to record information and why these fixed asset systems have been created in the first place is because utilities weren't able to keep track of that data at the pace that they were replacing it and the detail that was required, particularly because you need field personnel to record all of these entries. And field personnel's main objective is to keep reliable quality service in play. So if you have a storm, for example, and you now have emergency situations where hundreds of assets are being changed quickly and not only being done by Ameren personnel, but by other utilities that come to assist. This happens quite a bit. So for all of that to have to get done, then get recorded in a position that it gets sent to property accounting, who then needs to input all of that information, and that the level that that requirement is that was being asked of is no different than utilizing, as done in a depreciation study, when you go through and do field inspections and review of assets, discuss property records and develop estimates based on that curve. The quality of the data is, you're getting the benefit of the survivor curve and the analysis done in a depreciation study as to why the detail of those property records to identifying every single asset doesn't make sense. You're going to cost tremendous amount more money for the utility and ratepayers to maintain the degree of detail without any benefit. And you won't see that benefit for 50 years because these assets all have average lives of 40, 50, 60, 70 years. So that whole process doesn't make sense, which is why there was these fixed asset systems developed 20 years ago, and utilities are utilizing those to better provide better service in the long run.
Thank you. I jumped ahead without asking if there were any commission questions. Are there any commission questions at this point? I hear none, so I will move on. You would agree, you had mentioned that Ameren is keeping it in accord with industry standards, but would you agree that industry standard that does not necessarily equate to a commission rule?
I wouldn't necessarily say it doesn't equate to a commission rule, and that there are vintages that are applied to every asset that's retired. And so in that guidance, I feel that it's being followed, which is why all other utility, or not all, excuse me, almost all other utilities are doing a similar fashion to recording of their assets in order to most appropriately address what rate base is. And that's why it's, this process is being done. It's something that's been going on for 20 years. It's not something that's new. It's done and was created because of the fact that you couldn't keep track of the data and still supply quality service.
And is it industry standard to use software to record this, to, I guess, estimate this?
The process of, and maybe to help clear up an understanding of what is being estimated is, I'll take the polls account, for example. Not every poll has a stamp on it, okay? So it's not identified with a specific vintage. So again, if you have a storm that occurs and you have 50 poles that got replaced all at once, you can identify how many poles were replaced, but you won't know the stamp because, one, it doesn't exist. I mean, if it was a storm, it could have blown away, or it's been sitting there for 70 years and you don't have it able to identify it. So the survivor curve and what you do, you're not doing a statistical analysis only when developing this survivor curve. You are using judgment that understands the ratio and mortality of poles. So it is able to establish, okay, 40-foot poles were built in the 60s and used in the 60s. So now we're going to apply the 60s vintage to the poles that got retired. That's a reasonable expectation. So the dollar value that is being assigned is much more in line with how the example that Mr. Graham put out in his opening remarks. You have a much narrower view of what the actual average cost is of those dollars. And that's why there's the ability to get that recorded more timely than waiting to go send the field personnel to go out and try to figure out what that vintage was is, an impossible task, and it's going to keep them from keeping the power on for somebody else.
Mr. Graham had indicated in his opening that you already have, or that Ameren already retains this information. Is that correct?
There is vintage data that has been incorporated when it was first put into play, or into service, excuse me. However, to be able to identify that exists every single asset is the challenge. So, there's 900,000 poles. So when the field personnel go out and have a project that they need to replace, it will take them time to record what they actually retired. Instead of saying 2 poles on 5th Street, they need to go out and find what the vintage of those 2 poles was. Instead of saying it's a 40-foot pole on Main Street, they have to say 40-foot pole, oh, we don't have the vintage. Well, if they have to go track down that vintage somehow, which who knows how they're going to figure that out other than some guidance as to when that street had electricity put in, they won't be able to actually get the pole up and service back to the customer. They're going to have to take hours to figure that out. And that's kind of, if you magnify that for every single project all the time, you're asking the field personnel to do work that's not under their criteria. But once they do get that information, they now need to send it to property accounting. And property accounting then needs to record every single entry that goes on. And the automation is much more reasonable to do, through an estimation using a survivor curve.
Okay, thank you. I have no further questions. Any questions based on bench questions?
Yes, from staff. Do I understand you, sir, to say that the lineman or whoever it is that is out there replacing a pole is going to be stopped and will not be able to serve the customer and replace the pole until he has gathered the data which will be sent in? He's got to stop and do all this research before he can actually replace the pole? Was that your testimony?
Testimony is that's part of what his assignment is under the criteria that you're asking is he has to, I'm not saying whether it's before or not, but it's
Well, that's
during
what
the
you
course
s-
of the day, while you're doing that project, you need to be able to record that information so that it gets sent to property accounting. Otherwise, you will have a lag and not get any recording at all of the retirement.
You mean it'll take him time to figure out what to record? And that's inconvenient to the company because it would like to automatically apply its survivor curve and just get along with it.
You're
Objection,
portraying
was
it.
there an actual question in there or just a statement?
It was a statement that I'm asking the witness as to whether he agrees with. And he understood that because he was starting to answer me.
I disagree with your
Okay.
statement and characterization of what has to happen.
Well-
If a lineman has to take time to record detail of those assets, he can't go to the next project where there's another pole that needs to be replaced. So for that particular asset, you may not do it in advance, but it keeps him from getting to the next one and the next one and the next one if they are having to do this as part of their daily routine in getting not only the pole up so that you can provide service, but also get the proper accounting that you're requesting to be done. And that's why the fixed asset system process was established 20 years ago, is because they were realizing this was delaying accurate reporting.
So in the last 20 years, the company has not, for example, imagined the use of cell phone photographs or anything like that the lineman could take right on the spot of the pole or whatever it is, file it away, do his work, get to the next job, pass that in. Let's put it this way. I don't mean to come up with the procedures. My question is, the company tried to address this problem in any way other than just relying upon survivor curves? Has it?
I think the reason why these fixed asset systems were developed 20 years ago was because there wasn't a solution that you're viewing to be so simplified. It's not that simple, and why it's not being done in that fashion across the country, because the quality and requirements that need to be done take the amount of time to keep people from doing the work. And you're saying take a picture. What are you going to take a picture of? If there's no stamp on it, a conductor, major asset, where is there going to be any type of date on the conductor that you can get that off of that without you have to go to some original construction project that is, who knows where it is now? I mean, these are assets that have been in service for 60, 70 years.
In the last 10 years, has Ameren replaced more poles as a result of storm or as a part of the strategic energy plan? Do you know?
I don't know the percentages between those two items.
Are you aware that Ameren regularly inspects its poles per commission rules?
They do inspect their poles, yes.
Okay, so they're out there looking at their poles.
They're not going out and identify whether they have a vintage on it.
They're out there regularly inspecting the poles for something.
As to whether they're able to meet the requirements of holding the conductor on, whether they're safe and properly situated, whether there's any rot to the poles. Those are the things that are part of the inspection.
And they record all that data as to whether there's any rot in the poles or anything like that.
Obviously, if they have a problem that doesn't meet the requirements, they have to replace the pole.
And that information that they see is recorded by asset ID, isn't it?
I don't know whether they have to record every asset that they look at in the inspection. I don't have the detail on that.
Well, this may be my last question, but if they're doing all this inspecting and so forth, and they conclude the pole is not defective in any way, shape, or form, and it can remain in service, does the company have any record of that? That happened with respect to that pole with its ID number?
They will look to see whether that particular, I mean, the sampling that they do records what they've gone and looked at. That doesn't necessarily say that there's a vintage on that pole or the conductor, which is tied to that pole.
I'm taking your answer as a no. That after they've inspected it for safety and so forth, there is no subsequent record showing that they inspected it for safety.
Again, objection, I don't know if there was an actual question posed.
Do you agree with what I just said? They are not.
Mr. Graham, I know it'd be convenient to just continue to go along as though I'm not here, but when somebody's made an objection, would you please pause long enough for me at least to hear the
Yes, sir.
objection and rule on it?
Thank you.
Thank you. Okay, would you restate your objection, please? I believe you said it wasn't a question, and I'll agree with that. It wasn't phrased as a question.
So I should have been more clear, I apologize. I would actually move to strike, and there's no pending question. But it seems as though he's trying to testify or make comments, and opening statements have already concluded.
What I'm going to do is, Mr. Graham, I'm going to ask you to phrase your questions in the form of a question.
Yes, Your Honor.
Thank you.
Isn't it true, sir, yes or no, that under the procedure that you have described, after a lineman or whoever has gone out and done an inspection, if he doesn't identify anything about the pole that's wrong, there's not going to be a record?
I don't know the procedure that he has to record what he's done. There is guidance for inspections that have to happen, and they do their recording based on their inspection, but I don't know the degree that you're asking.
Yes or no? Yes or no? Do you know what the procedure is that the company follows, if any, for recording data when it goes out and inspects poles? Do you know that procedure?
Can you identify what data means?
Whatever it might mean. You do not know what the procedure is.
Under the pole inspection process, I do not know what their specific procedure is for identifying that they've completed their work.
Do you know whether they have a procedure for recording data, information observed during these inspections when nothing is done to the pole after the inspection? Is there any procedure at all for that?
I don't know, but I'm not sure how this relates to the property records, so that's, I
Well,
thought
we're
that was our
talking about-
topic.
Okay, I've been cautioned about.
Well, as to relevance, that's my determination to make, not yours. Just
Well,
answer
that's
the
why
question,
I'm trying to
please.
answer the yes or no, because I don't understand how I can answer that question, why I need to know what data is.
Just have him read the whole thing into the record.
From here?
Yeah, read the question, read the answer.
Was this a response? Okay, thank you. May I approach the witness?
Yes.
And this is going, I guess we're going to need to mark this as 183.
Does council have,
Is it 184?
184.
does council have another copy?
No. Oh, yes, I do.
Thank you.
Thank you.
Mr. Spanos, I've handed you what's been now marked as 184. Would you agree that somewhat down the page there it says number MPSC 0209.1?
Yes.
Okay. And the title of this document is, tell me if I read this wrong, I'm just doing this for the record and identification purposes. Ameren, Missouri's response to MPSC data request. MPSC gives the case number and the name of the case, correct?
Yes.
Would you read into the record here the question and the answer in this DR, beginning with the words, please identify?
Objection. Mr. Spanos is not listed as the respondent, so no foundation's been laid that he is aware of this. But also, this seems very far afield or beyond the scope of the commission, or I'm sorry, the judge's questions.
This is redirect, I believe, Your Honor.
No, it is not redirect.
It can't be redirected
sorry,
if it's
no,
not your
this is-
witness.
Correct, that is correct. I'm sorry, I lost my place in the day. Yeah. This is offered to impeach him, and this is the company's response to the data request.
I'll agree that they haven't moved to enter it. I don't have a problem with having him read it for impeachment purposes. That will be overruled.
Would you read the question and the response, sir?
You want me to
Loud.
read the whole
Yes,
question?
I do.
Okay. Please identify the individual or individuals responsible for determining which existing unit of property is retired from the continuing property record when a given item is removed from service. In light of the response provided to staff's DR-209, stating in pertinent part, no location information exists in the company's property accounting records for mass property investments. For example, in DR-209, staff inquired regarding the location of an asset described as engineering in service year 12/1/2021, in service year 1/1/2021, vintage 2021, asset ID 415-78918, retirement unit recloser 14.4 kV, one phase, activity quantity 1, and activity cost $914.16, or excuse me, $914,216. The continuing property record included in the work papers of Mr. Hickman in this case indicates that there are items in account 365 overhead conductors and devices that are identified as recloser 14.4 kV, one phase. By asset number, these items range in average value from negative $515,247 to positive $914,216, and from vintage 1988 to vintage 2022. Please describe the process and safeguards in place for the responsible individual to determine which vintage, engineering in service year, and asset ID is selected to correspond to a given item that is physically removed from service. Data requested by Sarah Lange, and then her email address.
Now, if you'd read the response, please. That was the question, correct?
That was, yes.
Go ahead and read the response then.
Response prepared by Paul Mertens, Manager Plan Accounting, date November 2nd, 2022. Mass property items that are to be retired are provided to Plan Accounting through a work management system. Because a specific asset being retired cannot be identified within our mass property accounting records, retirements are selected based on retirement curves and statistical analysis provided by the company that performs Ameren's depreciation studies, Gannett Fleming. For location property, the actual asset to be retired can be determined within the company's accounting records. The Plan Accounting Group works with the business line to identify the continuing property record to be retired when the asset is taken out of service.
Thank you. Okay.
Hold on just a second, please. Mr. Spanos, what do you do?
I'm a depreciation consultant. I do work for utility companies across the country and Canada.
Mr. Graham, I see the point you're trying to make. I do, but I'm getting the feeling that we're getting a little off track in that it seems like you're asking a person wearing shoes how the shoes were made.
If I may ask my next question, I think that'll clarify that.
Go ahead.
Okay. You remember my last series of questions to you about the data that's being recorded by the people that, as the judges correctly characterize, the people with the shoes that are out there on the job. But doesn't this document that you've just read from case ER-2022-0337 indicate that you've got people out there recording data who are looking at assets and are communicating information back?
Objection, in that it misrepresents what the document says. It says for location property. The issue in this case is mass property, and I believe the witness has been testifying from the mass property perspective, not location property, which is a completely different type of property.
May I respond?
You may. I'm going to inform you at this time that I've got an email that your conversations with Ms. Lange are being picked up by the microphone, so you might want to turn off the microphone when you talk to each other. But go ahead and respond to the objection.
Right. Yes. I see that there are two wings to this. I saw that when I asked the question. One's for mass property, one is for location property, but doesn't the response indicate in either event there are servicemen out there that are in communication with the company's accounting departments and personnel?
Where within the document are you referring? Objection vague.
I don't know. I don't know that it's vague. I think you're asking
Matt,
you're making an assumption. You're making an assumption from the reading of that, and you're asking. It appears that you're asking the witness to make that same assumption. So it seems like you're asking for them to speculate as to the meaning.
I won't. I promise. I'll ask him if he knows or doesn't know. I'll read this statement.
All right, I will overrule the objection for now, and you may go ahead.
This statement says, if you look at it, mass property items that are to be retired are provided to plant accounting through a work management system. First of all, did I read that correctly?
You did read that sentence correctly.
Now, here comes the do you understand or do you know question. Do you know what that process is?
I know that the field personnel incorporate information into the into their system, which goes into the work management system, which eventually gets to plant accounting. That's the degree of my knowledge.
I believe that's all the questions I have.
Is there any further cross? Any redirect?
No, I did want to clarify though, was 184 marked, but is there,
Nobody's moved to admit this yet.
okay.
Mr. Graham, were you moving to admit this?
Yes, I'll go ahead and see what the court rules.
Any objections to admitting 184 onto the hearing record? I hear and see no objections. Exhibit 184, the Ameren, Missouri's response to data request MPSC is admitted onto the hearing record as Exhibit 184. And you indicated no redirect?
Yes, Your Honor.
Mr. Spanos, thank you. You may step down.
Thank you.
Ameren, call your next witness.
Thank you. The company calls its second witness for issue 2, Mitchell Lansford, to the stand.
And Mr. Lansford, will you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? Yes. Please be seated and say and spell your name for the record.
It is Mitchell Lansford, Mitchell, Lansford, Lansford.
Go ahead, Ameren.
Thank you. Mr. Lansford, by whom are you employed and what is your title?
Ameren, Missouri, and I'm the Director of Regulatory Accounting.
You are the same Mitchell Lansford who filed direct testimony, supplemental direct testimony, rebuttal, surrebuttal/true-up direct, and true-up rebuttal testimonies in this case, which have been marked as Exhibits 45, 46, 47, 48, and 49.
Yes,
Do you have any corrections or revisions to make to your testimonies?
I do not.
So if I asked you the questions within your testimonies today, your answers would be the same?
Yes,
I move for Exhibits 45 through 49 to be moved into the record.
Any objection to admitting Exhibits 45, 46, 47, 48, and 49, which are the direct, supplemental direct, rebuttal testimony, surrebuttal and true-up direct testimony, and true-up rebuttal testimony of Mitchell Lansford onto the hearing record? I see and hear no objections. Exhibits 45, 46, 47, 48, and 49 are admitted onto the hearing record.
Thank you, Your Honor. Mr. Lansford is tendered for cross-examination.
Any cross-examination from MIEC? MECG? Sierra Club, NAACP, MCU?
No questions, Your Honor.
Renew Missouri?
No questions, thank you.
Public Counsel?
No, thank you.
Staff, any cross-examination for this witness? Take your time.
No questions from staff.
Are there any commission questions for this witness? Hearing none, I have a few questions for you, Mr. Lansford.
yes, sir.
Do you have your testimony on you, perchance?
I do.
Would you open your rebuttal testimony to page 8?
Yes, sir.
Lines 8 and 9 lists USOA requirements for each category of mass property that CPRs including the quantity placed in service by vintage year and an average cost. How is Ameren meeting those requirements?
Yeah, definitively, and I have some surrebuttal testimony. When you look at our CPR, we include, and when we capitalize an asset, a mass property asset in this case, pole, wire, conduit, whatever it may be, we are recording these exact categories: a description, the quantity by vintage year as we're installing it, the average cost, and then the plant control account. If I direct you to my surrebuttal testimony, page 10, I have an excerpt of our continuing property records there.
Give me just a second to get there.
You see the chart in the middle of page
Hold
10?
on just a second.
Oh, sorry.
You said is it surrebuttal?
Yes, surrebuttal true up direct. It's the surrebuttal portion.
And you said page 10, is that correct?
Correct.
Okay, I'm there. Go ahead.
I have this excerpt in line 12 here. That's from our continuing property records, our CPR. And it shows each of these categories. You can see the plant control account, which is 1364. This is for poles, so a category of mass property for the company. That's been recorded. In the second column, you see the vintage year that's associated with this particular asset. that's been recorded as required. The quantity that's associated with that vintage year is also recorded in the activity quantity column, the fourth from the left. We have a general description under the retirement unit heading. And then finally, we have the average cost. Each of the elements as required by the guidance that you cited have been recorded into our uniform system of accounts.
Are
Into our
any of,
CPR. Sorry.
are those actuals, are those estimated, or are those computer generated in some way? What are these?
Every single one of those are actuals that we input an amount into our continuing property record as we capitalize an asset. Every single amount that you see there is an actual amount. As we retire amounts, as we retire and remove records from the CPR, that's where we estimate the retirements of our categories of mass property.
What do you mean by that?
What do I mean by estimating the retirements?
Yes, I mean, let's assume the actual, which is I know nothing. So let's just assume that I don't know what the purpose of this is. Let's say I look at this and it says this pole is due for retirement. I go out there and I go, well, this pole looks great, but they say I have to chop it down. So
so the CPR is a database of our plant records, right? And as we are constructing new assets, installing new poles, hanging new wire or whatnot, we are going to add records to that database to show that we've installed those assets, right? You're following me on that? And then the question here is, what do you do when you need to retire something from the system? You've taken a pole, off the system, some probably associated conductor as well. And so from there, we have to remove a record from our database. And that's where we're estimating that record. We know we removed a pole, but the exact and specific characteristics of that pole that was just removed from our system, or that wire, that's where we're estimating it as we've sort of laid out using our depreciation study.
and why are you having to estimate it as opposed to identifying the actual pole that was removed?
Where we have to, there's no bridge, there's no way to know that you took a pole off of our system and then be able to find that into this database. This database has no characteristics to identify or specifically show what pole or what section of conduit was removed from the system. There's just no way to translate it to this data, to our accounting records. And that's not required, in fact, based on the accounting guidance that we just looked at and have referred to a couple times.
Well, when you say it can't be done, are you saying that when you're saying it can't be done, and you're saying that the database doesn't have the capability to enter that information, is it just that you're missing a row and that it's the software, or?
No, I wouldn't characterize it that way, Judge. By electing to account for these investments as categories of mass property, by utilizing that section of the guidance, we do not have the necessary data to translate it to the location or to a specific pole on our system that may be retired in the future. We would have to change our accounting convention to abandon the category of mass property guidance that we're applying here and perform the same accounting methods that we perform for location property, which is where you know exactly what's being retired from the system. You know exactly, if it's an entire power plant, you're going to specifically remove that power plant from the system, or even if it's just several components of a power plant.
And correct me if I'm wrong, but it sounds like the way you're saying it, it's that your accounting system doesn't comply with the commission's rule.
No, I would not agree with that, Judge. There are just two sections of accounting rules here. One of which is for location property, and one of which is for mass property. And we're using the conventions relating to mass property for these high volume, relatively low dollar amount assets like poles and wire and such.
Okay, now in Ameren, in Spanos's rebuttal, do you have that available to you?
I do not actually have that in front of me.
Well, I'll just tell you what it states, and if we need to pull it up, we can. In his rebuttal testimony, it states, "It is always best to be able to specifically identify the actual vintage of an asset. However, for mass property assets, achieving this goal is not realistic." Doesn't the statement imply that the year an asset is placed in service isn't recorded as required by the USOA?
It is recorded, Judge. But it is estimated, and I guess the question is, it's recorded, and the data exists. We do record the retirement.
Well, how's it recorded when it's placed into service?
Oh, when it's placed into service, there's no estimation. It's the actual amount. It's the actual vintage. It's the actual average cost associated with that project. There's no estimation upon initial recording.
Are you familiar with 18 CFR Part 125.3, the Federal Energy Regulatory Commission Schedule of Records and Periods of Retention?
I don't have that in front of me.
Under plant and depreciation, 16B, it states, continuing plant inventory ledger, book or card records showing description, location, quantities, cost, etc. of physical units or items of utility plant owned have retention period of 25 years. Are you aware of any separate description for mass property asset retentions in Part 125.3?
I'm not.
Does Ameren retain separate plant records for depreciation and income tax purposes?
I don't know if I would call them separate plant records for depreciation or income tax records. We have subledgers. We have a subledger for a fixed asset system. We have a subledger for our income tax transactions, and those rely on the same data.
But those aren't separate and apart from this record?
They're all are reliant on the same data, including this data.
Now, you state on page 10 of your rebuttal that Ameren has approximately 900,000 poles, and the difficulty is in tracking the location and vintage of each pole. Is that correct?
That's right. In no way does our accounting system for these categories of mass property, like poles in the example that you bring up here, have location information where you can go find the pole on our system along with vintage, quantity, cost, etc.
Now, according to its 2021 annual report, Ameren, Missouri has over 1 million residential customers and approximately 1.2 million customers in total. Is that correct?
I believe it's correct based on my knowledge of those approximate amounts.
How does Ameren manage to identify each customer by location and bill them each month?
We do keep those records. That's a record that we do keep.
Now, when you say you do keep these records, so you do keep them for customers but not for mass property in the same manner?
Right. Yeah. The records that you need to be able to bill your customers accurately and collect from your customers or have different characteristics than what's necessary to account for categories of mass property. So yes, the data that we collect, retain, and otherwise keep is different for those two data elements.
Now, you heard Mr. Graham's opening, correct?
I did.
And I got two things from it, and that is that you shall do this unless, and then there was the words impossible or impractical. Which one of those is Ameren claiming?
Impractical. Yeah, without a doubt. I mean, we have 110, over 100 million feet of overhead conductor. We account for each foot of that overhead conductor separately. 900,000 poles, cross arms of maybe an equal amount. You see the volume of relatively, the high volume of relatively low dollar amounts begin to build and build and build when you talk about specifically tracking, each foot of conductor overhead, I guess underground as well.
Okay, those are all the questions I have. Any recross based upon bench questions?
Yes, please.
Go ahead, Mr. Williams.
I think I understand that there's an historical problem in that you haven't tracked, in mass asset property, you haven't tracked retirements by item because you don't know particular items, so you've been doing it by a dollar amount. Is there some reason you can't track things like polls going forward?
Objection, that's beyond the scope of your questions.
I don't think it is. I'm going to overrule it.
Can you repeat your question?
Is there some reason you can't track specific items? Well, let's pick polls in particular. Is there some reason you can't have a database where you know what dollars associated with a particular poll so that you have that information in the future, so when that poll's retired, you know the dollars associated with it for what you're tracking currently as mass property?
Just as it's impractical to do that for our historical records, it's impractical for us to do that going forward.
Well, I understand the
So-
impracticability about history, but with the databases and computerization we have currently, and places like Walmart do that all the time, is it really impractical to do it, and if so, why?
Yeah, sure. I'll just try to describe that. It's that same it's that same process that Mr. Spanos was describing a bit. What would it take, I guess, to track this stuff going forward? The first thing, it's a multi-step process. What would you have to do? The first thing you'd have to do is go out and assign some sort of asset ID to every, to every new asset on the system, right? You would have to assign that, right? And then you would have to then, train your employees to understand and identify and how to use that new asset ID that's been determined. They'd have to take time, as Mr. Spanos mentioned, to then when that asset is then being retired, they'd have to take time to determine that asset ID, to determine the accounting characteristics, to call up a database, whatever it might be, and then and then process that transaction. That entire database, that entire process would have to be designed. There would be a digital or software element of doing that. It'd have to be implemented. It'd have to be paid for, and we'd have to be pretty clear that there would be direct, benefits that came out of that process as well in order to do all of that.
Well, I've heard of this thing called Google Maps or MapQuest, where you actually can see some polls from a satellite image, and all you would need to do is tag it and have the original information, and that was being the poll removed, would you not?
Objection assumes facts not in evidence. Calls for speculation as well.
Give me a moment. Let me think about this. I see the point you're trying to get to. Can you ask a different question and get there?
Aren't there different ways than what you've described in order to track the dollars associated with a particular asset that's being installed or replaced or removed?
Aren't there different ways than what I described?
Yes, then somebody in the field actually having to collect a bunch of information and relay it. Couldn't you design a system where they would only, where you would only need to know that the pole is either being installed or replaced or removed?
Would somebody in the field then be, still, somebody in the field would still be needed to identify that the pole was being installed or replaced, correct?
But that would be the only information somebody in the field would need to provide to the accounting department, correct? Could you develop a system where that was all that was needed? Let me put it that way.
I think maybe theoretically it is possible. At what cost, I'm not sure.
And during normal maintenance, aren't there decisions made before you're out in the field as to actually replacing or removing something like a pole?
Objection, this is beyond the scope of the judge's questions.
What's the question again?
Exactly how, if the court reporter would read it back.
I'm going to sustain the objection.
No further questions.
Any other recross based upon bench questions? Mr. Graham, did you have any recross for this witness?
Yes, Your Honor. Mr. Lansford, just as sort of a introduction here, when assets are placed out there, poles, so forth, and you've heard us talking about those today, is it not the case that an ID number is assigned to each one of those?
Objection beyond the scope of the judge's questions.
Mr. Graham, I'm going to cut you off for just a second. I'm going to go back. I'm going to disagree. I think the identity of the mass assets is what this is all about, and I'm going to let Mr. Williams ask the question that I did not let him answer before. So, Mr. Williams, go ahead.
Well, that question, if I recall it correctly, was about identifying the property that was going to be installed or replaced or removed before you actually go out in the field.
And I would just say I'm not involved in planning, that maintenance. I wouldn't know exactly how that process works. I'd have to speculate. And
So your answer is you don't know?
I don't know.
That's a good answer. Thank you.
And now, Mr. Graham, you may ask your question.
My question is that when an asset is placed out there, or at some point after it's out there, isn't it assigned by the company, a lineman, or someone assigns it an ID number that's specific to that asset?
And I will renew my objection.
And I will overrule that objection.
I know for certain that there is no assignment of an asset ID to those poles or any section of our conduit or overhead conductor that can correspond with our plant accounting records. I'm aware generally that we do put a pole tag on some of these poles so that we can do our pole inspection program. But my knowledge of that pole inspection program is limited to that.
So there is a pole tag.
At least for some of our poles, I don't know what our pole inspection program entails, but I'm aware that we have some pole tags on some of our poles. Similarly, or in contrast to that, I'm definitely aware that we have no asset IDs on any of our overhead conductor.
May I approach, Your Honor?
Yes.
I'm not looking for copies for other people. I'll give this one to the judge. All right, I'm going to show everybody this. That was a response to ER-0439. If the judge will indulge me, I have only one copy of this, so I'm going to take it from counsel to counsel.
That's fine, go ahead.
And what is our next?
I believe that'd be 185, is that correct? Yes, that's 185. Mr. Graham, what do you want to call that?
I'm going to call that response and exhibit 2, is it 439? Turn my speaker on. That's going to be Ameren, Missouri's response to MPSC data request number 439 with attachment.
Could you speak a little clearer into the microphone? I'm sorry.
Yeah, that's Ameren, Missouri's response to MPSC data request 439 with attachment.
May I clarify, there are multiple attachments to DR 439 is what was submitted, it looks like, through EFIS. So is this, I see one that says poll data? Okay.
Poll data is the specific subject of the attachment. And I'm letting Mr. Lansford take a look at that. Have you had an opportunity, sir, to see that?
I have, yep. I would like to,
Well,
once you.
There's not a question on the table yet,
Yes, sir.
but I take it you want to correct an answer that you gave earlier?
I do not.
Okay. Now, isn't it the case that a question or a DR was propounded to the company? And if you want to, let's just jump straight down to the answer. I'm going to read this and ask you if I've read it correctly. Where is the second page to this? I think this is it. All right, I'm going to read this and you tell me if I get it wrong. To clarify, now I'm going to start at the top so the record's perfectly clear when the judge reads it later. You tell me if I read this correctly or if I make a mistake. DR 201.1 states in part, vintage, location, voltage, etc. are not a part of the asset information collected, which is by design because not collecting such information is the essence of and a key benefit of using mass property accounting. At the end of the month, the work management system sends that information to the power plan system. The information sent to power plan includes the retirement unit, 40-foot pole, for example, in parentheses, and the quantities retired. 2. Power plan then automatically uses the Iowa survivor curve for the account where the cost of 40-foot poles are recorded to determine what quantities within any given vintage year it will select for retirement. That vintage year will not, except by pure coincidence, match the vintage of the actual asset retired in the field. The draft evaluation methodology contained in Ryan Arnold's direct testimony in part relies on the age/asset vintage as a criterion to support justification for distribution system investments. 1, and here comes our question. Explain in detail the age/asset vintage data Ameren, Missouri has available to quantify and document the age/asset vintage for distribution system assets for each category separately. System hardening, substations, underground cable upgrades, revitalization of the downtown St. Louis underground network, grid resiliency, and smart grid technology. 2, please reconcile the response to DR 209.1 S and the draft evaluation methodology presented in Ryan Arnold's direct testimony, specifically DR requested by Claire Eubanks, and there is her email address. Did I read the DR correctly?
Yes.
Okay. Now let's look at the response. Tell me if I've read this correctly. To clarify, the quote from DR 209.1S1 referred to in this data request relates to the type of information that is determined to process a retirement of categories of mass property as it relates to the company's property accounting records. Other categories of information or data points are determined for other purposes, as I will describe below. The company maintains accounting records for all of its investments, and those accounting records contain life characteristics as required under FERC USOA, Uniform System of Accounts. A copy of these accounting records are provided in response to data request MPSC 01.25.1. Separately, the company maintains operational records for its energy delivery assets, which were provided in response to data request MPSC 0440 and which document the vintage of those assets. I read that correctly.
Yes.
Then it goes on to say no other age/asset vintage data exists for these assets. Did I read that correctly?
Yes.
Now, to this document and provided with this document is the schedule there concerning polls. Do you have it in front of you?
I do.
Does it not identify for each one of those polls a tag number?
For this page, this section of polls that we have, there is a poll tag number.
And an age.
And an age.
Okay. And that information is not produced by an Iowa curve or your software. That was actual information for the assets that are recorded there, correctly?
It was produced by the inspections.
Yes. So, to go back directly to a question that the judge asked you, it's your software and your accounting system based on that software that is not in compliance with the rule. Isn't that true?
No, absolutely not.
No further questions. I would, what number did I write on that, Mr. Lansford?
185.
I would offer into evidence exhibit number 185.
Any objection to admitting Exhibit 185, response to MPSC DR 49 and poll attachment? Hearing and seeing none, Exhibit 185 will be admitted onto the hearing record. And Mr. Graham, you said you have no more questions?
That is correct, Your Honor.
Any, and at some point I will need to get that exhibit, but is there any redirect?
Just briefly, Your Honor.
Go right ahead.
Thank you. During the recross questioning from Office of Public Counsel, Mr. Williams, he was asking you, I believe, about the development of a brand-new system that would allow this tracking as requested by staff to occur. Do you recall that discussion?
Yes.
And I believe you said that there would be some cost associated with that. Is that correct?
Yeah, that hypothetical, that Mr. Williams was posing to me, of course there'd be a cost, many millions of dollars to develop a system like that.
Thank you very much for your time.
Mr. Lansford, you may step down. Would you bring me that exhibit, please?
Sure thing.
Amber, do you have any further witnesses for this issue?
No, Your Honor.
I have staff listed next. Would staff like to call their witness?
Cedric Cunningham.
Mr. Cunningham, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated and state and spell your name for the record.
Cedric E. Cunningham. Cunningham is Cunnigan.
Go ahead, staff.
And again, if you would state your name for the record.
Cedric E. Cunningham.
All right. Are you employed by the staff of the commission?
Yes.
And in what capacity?
Senior professional engineer.
And have you filed in this proceeding direct testimony with the exhibit number of 117, rebuttal testimony with an exhibit number of 118, and surrebuttal / true-up direct testimony with an exhibit number of 119?
Yes.
Do you have any corrections to make to any of these documents?
Yes, my direct testimony.
And that's exhibit 117.
Yes.
And would you describe your corrections, please?
So on page 6, line 16, it reads, "and the whole life technique." That should be remaining life technique.
What
And
page is that again?
Page 6, line 16. And then I would also strike page 6, lines 18 through page 7, lines 12. That was a holdover from a previous case.
Are those your corrections to exhibit number 117?
Yes.
Do you have any corrections to either 118 or 119, your other testimonies?
No.
Okay. If I were to ask you the questions that are set out in those documents, would your answers be the same ones as you have now corrected them?
Yes.
And with those corrections, are those same answers true and now correct to the best of your knowledge and belief?
Yes.
Your Honor, at this time, I would offer or tender into evidence Exhibits 117, 118, and 119, and tender the witness for cross-examination.
Any objection to admitting Exhibits 117, 118, and 119, the direct, rebuttal, and surrebuttal testimony of Cedric Cunningham? Onto the hearing record. I hear and see no objections. Exhibit 117, 118, and 119 are admitted onto the hearing record. Is there any cross-examination from public counsel? Any cross-examination from MIEC? MECG? Sierra Club, NAACP, MCU?
No questions, Your Honor.
Any questions from Renew Missouri?
No questions, Your Honor. Thank you.
Any questions from Ameren, Missouri?
Yes, Your Honor.
Go ahead.
Mr. Cunningham, you agree that the uniform system of accounts requires less detailed information for mass property assets. Specifically, location is not required for mass property assets in the continuing property record.
I agree that location is not required for mass property assets.
Do you believe that that then is less detail than is required for location property?
For that category, yes.
You agree that depreciation in the regulated utility context estimates the reduction in value of an asset over time, or in other words, how assets depreciate over time.
Yes.
And survivor curves are estimates based on statistical analysis and judgment about the service life of assets, right?
Can you restate the question?
Sure. Survivor curves are estimates based on statistical analysis and judgments about the service life of assets, right?
Yes, I would agree with that.
Focusing on your proposal to modify the retirement of mass property within the company's continuing property records would require the work order system to tie to the asset IDs within the continuing property record, correct?
There would have to be some kind of tie between the physical assets in the field and that asset ID that you have in the continuing property record. It may not necessarily require additional tagging. It could be a simple change in your spreadsheets or databases where you link it, but it would require some kind of tie.
And you've been present for the presentation of the company's witnesses, Mr. Spanos and Mr. Lansford, today?
Yes.
So, under your proposal to modify the retirement of mass property within the company's continuing property record, wouldn't that practically mean that Ameren, Missouri field personnel would have to find and note the asset ID tag for every asset being retired on a work order?
To tie it to the continuing property record, there would need to be some kind of tie between the asset ID and the continuing property record, and some kind of identification on the asset in the field. I believe, I don't have it in front of me now because the judge has my copy, but on that spreadsheet from attached to DR-439, there is an asset ID tag, or trying to remember it. There is a tag number associated with those poles.
So my question was, wouldn't that practically mean then, though, that Ameren, Missouri field personnel would have to try to find and note any tag, asset ID tag, for every asset being retired on a work order?
Yes, they would have to identify the asset somehow.
And to your knowledge, are asset IDs for mass property currently maintained in the company's work order system today?
Asset IDs for certain equipment, like I said, such as the poles, they do have asset tags for those. I can't say it for every account that the company has mass property on.
So, for example, the wires or conductor, are you aware of any tags with the asset ID on it for that type of asset?
For wires, I am not aware of that. I think also, well, I'll let you ask your next question.
Is your recommendation then that the company begin labeling every mass property asset like a foot of conduit, or I'm sorry, a foot of conductor with an asset ID so that it can be recorded in the work order system?
I think we would have to look at each individual asset group or account, because when you look at mass property, I don't know if someone said it earlier or not, but it's for homogeneous, high count assets, but also low value. And we have some assets in this in these accounts that are approaching $1 million, and I wouldn't consider that low value. And so there may be some wiggle room in there where we can say, you know, you may not have to do this tagging for, you know, wires, but if you can do it and it's more feasible, we might need to narrow that down.
So may I clarify then, is this a potential revision of your proposal that you would not suggest that this would be required for every type of asset group within mass property assets?
My testimony did not outline specific accounts, but I would be open to discussions of the accounts and assets that this new process could be used on.
Are you aware of tags on poles, for example, ever falling off or being damaged over the life of the asset?
From personal experience, no, but it is feasible given storms, tornadoes, or car strikes that they could be damaged. It's feasible.
And are you aware of asset ID tags for the company's location property, so non-mass property? Sometimes even falling off or being damaged over the life of assets that they're in service.
From personal experience, no.
So if an asset sticker or ID did exist on every pole, for example, or every cross arm, the field personnel would have to send the asset IDs with quantity information somehow to be provided to the plant accounting group. Is that accurate?
There would have to be the asset ID and the quantity associated with that same asset ID, or some other way to identify the vintage year.
So this is the step where you were talking about the tie or coordination required between systems like the work order system and the continuing property record would have to
Yes.
occur. Okay. So then, receiving that, the plant accounting group would have to select then the quantity with the ID retired within the company's continuing property record.
Yes, but it appears that they're already simulating that same data through PowerPlan. You have to retire from a vintage group anytime you retire, and it's just recording it versus simulating it.
May I clarify, when you use the term simulate, is that the same thing as using the statistical analysis that PowerPlan uses? Or is there some other simulation occurring?
That's the same thing I'm referring to.
Do you agree that additional numerous staff, field personnel, property accountants, would have to be hired by the company in order to effectuate your proposal for mass property asset retirements?
I'm not aware of how many staff would need to be hired to facilitate something like this. As far as assets are already identified in your system somewhere, it could be a simple switch in your database and no new tagging would be necessary.
A switch in which database?
So for polls example, polls already have an asset tag on them from that DR-439 response. There's already an asset tag on certain polls. There is already an asset ID in the CPR for polls as well. It would simply be linking those in the database to the appropriate vintage year. Then when an asset tag is retired, you could track it that way. It would require linking those two IDs between your systems.
But it would also require that the field personnel note the asset tag or that ID to then transmit it to the mass property accounting group, pardon me.
That's one option, yes.
Well, have you ever been a field personnel who would be responsible for noting assets to be retired and assets to be installed?
No.
Have you ever booked an asset retirement with any community property record, not just Ameren's?
No.
Okay. And the goal of your proposal to modify the retirement of mass property within the company's continuing property record is more precision in the retirement process?
It's more precision in the data that we use. The data that we use in the depreciation studies to determine the depreciation curves is being simulated for these accounts. And so over time, you get that feedback loop of the data appearing more and more like you expect it to. And when we have random retirements due to, if a brand new pole is struck down, that data is no longer getting reflected. It's just going to repeat. It's just going to mimic the curve shape. And so actually tracking the data helps us track and determine if that curve shape is changing, but we don't get that without actually tracking the data.
In your rebuttal testimony, if you could shift to your rebuttal, please.
What page?
Page 5, please.
Okay.
So, looking at page 5, lines 7 and 8, specifically, you describe that the magnitude of difference between book values and plant and service could be relatively small on a percentage-wise basis, right?
That's what it states, yes.
Did you perform any analysis to confirm whether it was a small impact percentage-wise?
I did not perform any analysis because you would actually have to know what the actual plant and service was, which we don't have that information to know how far off the current books are.
Your proposal to modify the retirement of mass property, as I understood it, is only going forward, is that correct? So future work orders and not try to go back to the inventory of existing mass property assets, is that correct?
Yes.
Okay. So since your proposal is going forward, when would the additional precision you're proposing become statistically relevant?
It's hard to say. It would be different for each account based on the life of those assets.
Well, since many of the mass property distribution assets are 40, 50-year lived assets, wouldn't it be decades before there was statistically relevant additional precision?
It really depends on how far off the survivor curves are from actual data, and I don't know that.
Those are my questions. Thank you.
Any questions from the commission?
No, thank you, Judge.
Thank you. I just have a very few questions for you. Do you examine the mass property records of other regulated utilities in Missouri?
Yes.
Do other regulated utilities have the same issue with retirements being generated by software rather than recording actual plant retired?
I am unsure at this time. We were not made aware of this instance until we got a data request response that let us know that they were simulating the data. We received the data in the manner that we ask it, and we didn't know it was simulated up until this point.
So at this point, you don't know if other regulated utilities are also handling mass property this way?
Correct. And I think it was data request response 209.1, I think, where we first became aware of it.
And that's already been entered into the record?
I'm not sure.
No, it has been.
Oh, okay.
That was a statement, not a question. I think I'm looking at that. MPSC 0209.1?
Yes.
Thank you.
And there's also a supplemental response to that, too, that outlines it a little bit further, 209.1S1.
Okay, that was not placed into the record. What is data request 565?
565. I do not have a copy of that in front of me, actually. Can someone?
It appears Mr. Williams with Public Counsel has a copy. I'd like somebody to verify that it is what it is before they hand it to a witness to read from. Thank you. Please.
I'm handing you what's been marked as response to NPSC 0565. Well, it hasn't been marked. That's what it is, a data request response.
Thank you.
Are you familiar with that data request?
If you give me just a minute to read it, I believe someone else from staff asked it. Give me
Okay,
just a
please
minute.
take your time. And I believe it's referenced in your SIR rebuttal on page 5.
Oh, yes, there we go.
What can you tell me about that particular data response?
So it's referring to polls, and it's specifically asking about their accounting records. So question 2, please describe the extent to which these records were relied upon by Mr. Hickman in his classification of polls, including identification of the years of inspection reports utilized. I think the part that I was more interested in was that they, number 4, please confirm whether Ameren, Missouri possesses records of the vintage year and location of each of the company's approximately 900,000 polls. And so one of the things that we've specifically not asked for, or at least my recommendation, was not that the location of the polls are tracked, but that the vintage year is. And that is, one of the specific things that is called out in the CFR and the CSR on multiple occasions. For mass property, it's vintage year, quantity placed in service by that vintage year, and the associated cost or average cost by that vintage year. And vintage year is the key to determining those other pieces. So like the location wouldn't matter as much for my purposes and my recommendation, though the company does already track it, but tracking that vintage year would. And I think I provide on page 4 of my SIR rebuttal testimony, there's another version of the CPR or continuing property record where they have an asset ID for, this is looking at cross arms 30 foot and over, but they have an asset ID tied to a vintage year and tied to the activity quantity and the average cost for that year. The thing is, we don't know how accurate that is anymore because they aren't recording it, but they're simulating the retirements for that. And so when it comes to doing those depreciation studies, I don't know how far the data is off from the actual data in the field. And, you know, we argue back and forth over curve choices sometimes, but our data is faulty, potentially. Or, you know, as one of the other Ameren witnesses says, it only matches by coincidence.
I know this hasn't been offered by any party. Are there any objections to making the response to data request 565 a commission exhibit?
No objection.
Any objection from the company?
No, thank you.
Any other objections? I haven't actually assigned the commission any numbers, so I will call this Commission Exhibit 01. And I will call it response, Ameren response to data request 565. And that will be admitted onto the hearing record. And if somebody can get me a copy of that, that would be helpful. Doesn't have to be today. Now, Ameren treats transformers as mass asset property, is that correct?
I believe one of the accounts has them, yes.
So that is in fact mass property?
They're treating accounts 364 through 373 as mass property, yes.
And that's one of those accounts?
Yes.
Do you know if transformers have serial numbers?
I would assume so. I can't say that I've actually seen one in person.
I guess, how big of an issue is this? Why, in kind of a nutshell, why is this an issue?
So if you go to my rebuttal testimony, on that chart on page 4, this is, was it? The 30-foot cross arms and over, and this is one account. If they retire the wrong vintage year, say the third line, the 2019 vintage year has 27 poles in it. If that pole is taken out, there's about $9,000 associated with that pole on their books. So if it's physically taken out, but they choose a different vintage year, say they choose 1971 because it's the older, that value associated with that pole is only $170. And so the difference between those amounts would remain in rate base, and they'd recover their return on that even though that asset is gone. And while most of the time the curve might pick the right year or it may not, I just don't know. But the rate of rate base is different from what's in the field if it's not actually recorded. And, you know, I picked that number, but, you know, if it was a 2020 poll, the average cost with that is $58,000. And so every time you're off on the vintage year that you pick, you're off on the cost that's still in rate base. And like I said, this is one example. All the accounts may not have as drastic of a swing in prices, but we'd have to go through each account and really look to figure that out. And we didn't have time to do it for every account for this in every retirement unit during this case.
Okay, thank you for explaining that to me. Setting the commission rule aside for a second, whether or not they've complied with the commission rule, for your purposes, would it be sufficient to do some sort of random sampling of a set number and see how far these curves are off, as you say, or is that not something that makes any sense?
I don't think you could do a random sampling on the inventory.
Because it would have to be known inventory?
Yeah.
And there's your problem?
And that's why I suggested, because I don't know how far off we are. And so that's why I said if we just change it going forward, eventually it would fix itself. But I just don't know how far off it is. It could be in customers' favor. It could be in Ameren's favor. I don't know.
Okay, thank you. I have no further questions. Any recross based upon commission questions? Ameren?
Yes. Mr. Cunningham, do you know the accounting entries for retirement of mass property and how those accounting entries affect rate base?
Can you say that again?
Yes, sir. Do you know the accounting entries for a retirement of mass property and how those accounting entries affect rate base?
So I can't say that the accounting, let me say this again. The depreciation rates is what goes in and then determines depreciation expense and how much plant and service is removed when you balance it with the reserve balance. And so that's where that accounting data comes in on the depreciation database.
So do you know what the debits and credits are for the accounting entries for a retirement of mass property and how those entries affect rate base?
So when plant is retired, it should be retired from the plant and service account and the reserve balance account.
Thank you. Those are all my questions.
Any redirect from staff?
Yes, Your Honor. Again, I need to approach,
Go right ahead.
and I believe this one is going to be Exhibit 186. Before I go any further, I'd like,
And how are you identifying that?
okay, this is going to be Ameren's response to data request 440.
Thank you, sir.
Okay, Mr. Cunningham, you were asked a number of questions about Ameren's tags on cables or on poles, is that right?
Yes.
I'm going to direct your attention to a document which I've handed you and which has been marked or will be referred to in the record as Exhibit number 186. And we are going to call it Ameren's response to data request 440. Okay?
Okay.
Would you read, first of all, clearly identifying as such, the question that was directed to Ameren? Read off of 186, the question that was directed or the data request that was made to Ameren in this data request. Just read it off, please.
1. Provide any and all data supporting the slide decks attached to Ryan Arnold's direct testimony. 2. Please explain the source of asset, age/vintage data included on the slide decks for each category separately. System hardening, substations, underground cable upgrades, revitalization of the downtown St. Louis underground network, grid resiliency, and smart grid technology. DR requested by Clara Eubanks and her email.
Okay, now that was the data request, is that correct?
Yes.
Would you now please read to us Ameren's reply?
Your Honor, perhaps this can just be reflected that the document speaks for itself and it's been marked. If he moves it into the record, there's no need to waste court reporter and everyone's time reading in the response. It speaks for itself.
Mr. Graham, do you just want to move to admit this and then ask further questions about it?
Yes, that'll be fine.
Any objection to admitting Exhibit 186, Ameren's response to DR 440, onto the hearing record? No objections. Ameren's, Exhibit 186, Ameren's response to DR 440 is admitted onto the hearing record.
Mr. Cunningham, among the items that are described in this data request and in the response to the data request, are there mass assets?
Yes.
And doesn't this response indicate that the company has and uses asset age and vintage information in order to record and otherwise do work with respect to record keeping and with respect to the maintenance and replacement and retirement of these assets? And you correct my question to the extent that it's necessary. Take a look at the exhibit.
They list different systems, but yes, each category, they state how asset age and vintage data is extracted.
With respect to each one of these categories.
Yes.
And from this exhibit, can you identify for the commission which of the assets or the categories of assets that are identified here as being related to asset age and vintage data would you characterize as mass assets?
Well, under system hardening, they specifically have poles in there, pole age. Underground cable. I'm not sure just from the title what all is in grid resiliency or UG revitalization, but it would appear that at least some of these accounts are in the mass property accounts.
So again, what is the effect of using by Ameren, Missouri, of course, you were asked about survivor curves. What is the effect of using retirement data simulated from a chosen survivor curve rather than from the records themselves?
So I kind of answered that with the commissioner's question, but the data that you receive is part of what you use to determine the survivor curve. And then the survivor curve is used to determine the depreciation rate that then in turn affects depreciation expense and how quickly plant is retired off of the books. And that affects how much rate of return the company receives on the surviving plant. And so by using simulated data, all those pieces along that chain would then be inaccurate.
You've examined all the pre-filed testimony in this case and been in the hearing today on this issue, is that correct?
Yes.
To your knowledge, has Ameren put on any evidence of the cost of compliance with this rule?
Objection, this is beyond the scope of any cross or the
What's your
judge's-
question again?
Has Ameren put on any evidence of the cost of compliance?
This is redirect.
Yes.
No, I was saying that to Ameren. So the
I
objection's
did get
overruled.
that one right this time.
The objection's overruled. Go ahead, Mr.
Have you heard any evidence from Ameren concerning the cost of compliance?
I believe Mitch Lansford answered a question on it, but I haven't seen any evidence provided to actually list out what the cost would be.
Well, let me ask this. Have you ever done investigation in the field for us here at the PSC? Or
I've,
your previous work?
I've done site visits for the PSC. I don't know if I would call it investigation.
Well, put on your common sense cap. Would you say it would be easier for a field worker to report retirement of pole? We'll just take that 900,000 number. You've heard that bandied around for poles, right?
Yes.
Would it be easier for a field worker to record the retirement of pole 900,001 or to report retirement of a 43-foot Class 4 pole?
I mean, if it's both one data point, it just depends on what you're
Let's explore
recording.
that. Let's explore that. If there is a tag on there that says pole 900,001, would it be difficult to associate that tag number with all of the data reports, or all of the data points that are required by the rule, and reference them all back to a tag number? Vintage number, the whole thing, or vintage year, the whole thing.
If the database already had that tag number in it and the required information, it would be simple to do that.
Yeah, it'd be simple for the lineman to do that.
Yes.
Okay. Is it your understanding that some asset groups are recorded to multiple accounts? For example, are transformers, switches, poles, assets types found in multiple accounts?
Yes.
Would it be easier or harder to communicate the retirement of one of those asset types with or without an identifying asset number? I'll
You
repeat.
asked a couple different
Well, I'll
ifs.
try that again. Would it be easier or would it be harder? Which would it be to communicate the retirement of one of the asset types with or without an identifying asset number?
It would be easier to retire one of the different asset types with an asset number.
The last few questions that I've asked you, would these be the kinds of questions one would expect reasonably to be asked and answered in determining what it would cost to bring this system into compliance?
Yes, that would be reasonable.
That's all I have.
Mr. Cunningham, you can step down. Thank you. Mr. Williams, you had a request as to Mr. Robinette?
We're offering Mr. Robinette as a witness on this topic, should anyone have any desire to inquire of him.
Do any parties, or are any parties going to have any questions for Mr. Robinette?
I would renew my objection from yesterday regarding his presentation as a witness. We took it up in preliminary matters. in that OPC witness Robinette did not provide any testimony on this issue. Under the procedural order, they had plenty of opportunity, all parties had opportunity to file rebuttal and surrebuttal, and no OPC witness provided rebuttal or surrebuttal on the CPR issue. It would defy commission procedural rules and is inconsistent with due process, just as a summary of my renewed objection.
And I take it what you're wanting to do is offer his testimony into the record?
No.
Just have him present to testify live?
We're just offering him, should the commission or anyone else have questions of him. My anticipation that is if the commission has an interest in utilizing his expertise towards any resolution of this issue, it might ask questions. And in that event, I would expect the other parties to do cross, but if the commission doesn't want to question him, then I anticipate he won't appear and testify.
Well, I hate to make him dress up and sit through me, but I have no questions for him, and I don't believe the commission does either that I've received. Do any other parties have any questions for Mr. Robinette? I see none, so I think the question, I think the objection's kind of moot at this point, unless you want me to rule on it.
No, that's fine, thank you.
All right. Then, Mr. Robinette, there's no need for you to appear on this subject. All right, it's been another long day, but we have one issue with no actual testimony tomorrow, where I believe we're just doing openings on that, and then we have an on-the-record presentation. Given that, I don't think we need to start at 8:30 tomorrow. Is there any objections to starting at 9?
No objection here. I do want to note that MECG's witness on issue 1 will be available via WebEx tomorrow. I assume after the remaining issue opening statement.
I'm sorry, thank you for reminding me of that. So we do have one witness tomorrow. I'd like to take him actually first before we move on to the next issue, just because I don't want to pick him up after the issue. So why don't we return to him? Why don't we return to witness Chris for issue 1 first thing in the morning, and then we'll move on to the last issue. I still don't see any reason that we would need to start before 9 a.m. So if there's no objections to starting at 9 a.m., we'll do that. Okay. I will see everyone tomorrow at 9 a.m., and we are off the record for the day.
Thank you, Judge.